Jai Hind, esteemed guests, respected deans, faculty members, respected dignitaries, and all participants. I, Ankita Singh,
Myself, Gracie.
from PLLB 5th year, we extend our warm welcome as we are gathered here today for National Seminar on Issues and Challenges in Implementation of New Criminal Laws, organized by Sardar Patel Subharti Institute of Law in association with Dr. B.R. Ambedkar Chair, Swami Vivekanand, Subharti University, Meerut.
It is with profound privilege to share that Dr. B.R. Ambedkar Chair has been established with the objective of encouraging research and teaching on and about the life, ideals of Dr. B.R. Ambedkar and other social issues. Therefore, in conformity with the said objective and with the combined efforts of all faculties and authorities, we have come up with the most awaited and debated topic, that is issues and challenges in implementation of new criminal laws.
As we all know that law is a social phenomenon. It is a social expression of human beings in the society. Law has to change according to the needs of the society. When law becomes outdated, obsolete, it becomes necessary to evolve it. Consequently, on 1st July 2024, 3 new criminal laws, that is Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshi Adhiniyam has replaced the old criminal laws, that is Indian Penal Code, Code of Criminal Procedure and the Indian Evidence Act. These laws aims to update provisions to meet contemporary needs of the society, create a more efficient and equitable legal system. This seminar seeks to explore challenges, gather insights from experts and encourage meaningful discussions on the way forward.
It is with great privilege to share with the august gathering that we have received participation from over 10 states including Uttar Pradesh, Delhi, Haryana, Tamil Nadu, Karnataka, West Bengal, Jammu Kashmir, Rajasthan, Odisha, Madhya Pradesh and other states, making the objective of the seminar a grand success. Moving forward, we again wholeheartedly welcome our esteemed guests and request them to kindly come on the stage to form the dais.
We request Dr. Professor Vaibhav Goyal Bhartiya, Dean Faculty of Law and Mr. Harshit Sir to honor Advocate Saju Jacob Sir by offering the token of love and respect. Moving forwards, we request co-convener of the event, Professor Dr. Reena Vishnoi Ma'am, to kindly come on the stage for officially welcoming the dignitaries of the day and enlightening audience with the theme of the seminar.
So, Jai Hind to one and all present here in the Sardar Patel Auditorium. I, Dr. Reena Vishnoi, feel privileged to have been given opportunity to welcome address to everyone on the occasion of this one-day national seminar on the topic Issues and Challenges in Implementation of New Criminal Laws, organized by Sardar Patel Subharti Institute of Law, Swami Vivekanand Subharti University in association with Dr. B.R. Ambedkar Chair. As we all know, the Indian Parliament has initiated a transformative step in the criminal justice system by replacing 3 historical laws: the Indian Penal Code 1860, the Code of Criminal Procedure 1973 and the Indian Evidence Act 1872 with the Bharatiya Nyaya Sanhita 2023, the Bharatiya Nagrik Suraksha Sanhita 2023 and the Bharatiya Sakshi Adhiniyam 2023 respectively. These new laws, grounded in Indian values of justice, that is Nyaya, signify a shift from a punitive to a justice-oriented approach reflecting Bharatiya Nyaya Paddhati. The overarching goal is to create a criminal justice system that not only protects citizens' rights but also uphold the rule of law, ensuring accessible and speedy justice for all. This reform represents a significant stride towards an equitable, modern, and a just legal framework in India. So all we have to know about these new laws. On the occasion of this national seminar, on behalf of Subharti Law College, I warmly welcome our Honorable Vice Chancellor Sir, Major General Dr. G.K. Thaplyar Sir, Swami Vivekanand Subharti University, Meerut. I also welcome respected Dr. A.P. Garg Sir, Research Director, Swami Vivekanand Subharti University. In continuation, I also welcome respected Shri Saju Jacob Sir, Advocate Supreme Court of India, is a resource person in the seminar. I also welcome respected Professor Dr. Bageshwar Ma'am, Professor, Faculty of Law, Delhi University, as a resource person. I also welcome respected Professor Dr. Assad Malik Sir, Faculty of Law, Jamia Millia Islamia, Central University, New Delhi, as a resource person. I also welcome our Dean Faculty of Law, Dr. Vaibhav Bhatia Sir. In continuation, I also welcome all the HOIs and the faculty members present in this hall. I also welcome all the participants, and I wish to inform again to the House that from 10 states and the 1 union territory, the participants get registered, and I hope all the participants definitely will get benefited with this one-day national seminar. So once again, welcome you all with these words, Jai Hind, Jai Bharat.
Now I request Prakriti from BALLB 4th year to kindly come on the stage and introduce the dignitaries of the event.
Thank you so much for giving me this ideal opportunity to introduce our esteemed guest speakers for the day. We are now honored to invite an esteemed personality, Advocate Saju Jacob Sir from the renowned Lily Thomas Chamber, a distinguished advocate of the Supreme Court of India and a solicitor in United Kingdom and Germany. Sir is a lawyer based in Delhi with core legal practice before the Supreme Court, High Court of Delhi, National Consumer Dispute Redressal Commission, National Company Law Tribunal, Central Information Commissioner, and Central Appellate Tribunal. Sir is Professor of Practice at Swami Vivekanand Subharti University. Sir brings with him an exceptional depth of legal expertise and a truly global perspective on the evolving landscape of law. Please join me in welcoming Advocate Saju Jacob Sir to the podium with a warm round of applause.
Jai Hind, Suprabhat. Good morning to all of you, sir. Respected Founder Chairman Sri Dr. Adul Krishnaji, Honorable CEO Srimati Dr. Shalya Raj, Honorable Vice Chancellor Major General Sri Thaplyarji, Honorable Pro Vice Chancellor, and the distinguished academician and professors from Jamia University, Professor Assad Malik, distinguished academician as well as Professor Dr. Bageshwar, Professor, Faculty of Law, University of Delhi, and also the academician and Professor Dr. Amar Prakash Garg, Director, Research Applied Sciences and former Vice Chancellor, Shobit Institute of Engineering, Professor Dr. Vaibhav, our Dean, and also the distinguished academicians, learned colleagues, learned friends, learned and illustrious students. Thank you very much. I express my gratitude for the invitation that you have extended to me, and I bow down before the lotus of Saraswati as well as our Jai Mata, Jai Hind. Today, we gather with a shared purpose to explore and discuss the issues and challenges surrounding the implementation of India's new criminal laws. As we know, the recently proposed Bharatiya Nyaya Samhit, the Bharatiya Nagarik Suraksha Sanhit and Bharatiya Sakshya Bill aim to transform our criminal justice framework. These bills replaced the century-old IPC, CRPC and Evidence Act, which was initially formed by our colonial past and especially by Dr. Lord Macaulay in England. And now we focus on expediting justice, addressing procedural delays that has been plaguing Indian judiciary for quite long, and strengthening the protection of citizens' rights and victim rights. The newly enacted criminal laws have transitioned India's legal framework on criminal justice into the new age. every change will bring forth myriads of advantages. That is the purpose of any and every change, as usual with all the changes in the past history. However, the biggest challenge that I foresee and I also feel that is the fear of change that we currently undergo. Change is a must and liberation from the past. With the change of new laws, we say goodbye to the laws made by our past history. We are changing our legal spectrum into a digital world. Let us embrace the change, understanding it. Change is the only constant and the law of the nature. Our Lord Buddha, who is a great philosopher and also a spiritual leader, stated categorically that change is not painful, but resistance to change is painful. That is what I have pointed out, that the biggest challenge is the fear of change. Bhagavad Gita also teaches us that change is the law of the universe and that life is unpredictable and we should adapt to the changes that the unpredictability offers. American President Roosevelt has once said, "No man is above law and no man is below law. Nor do we ask any man's permission when we require him to obey it. Law must be built and law must be amended and we must build the law." That is what we did now. The important highlights of new criminal laws are summoned through electronic modes. As I have already indicated that we are transforming our world into a digital world. Videography of crime scenes, registration of police complaints online, and a zero FIR. What is zero FIR? A zero FIR is a procedural tool that empowers citizens to report crime regardless of where the person is situated and where the crime has occurred. Under the new legislation, victims will receive a complimentary copy of the FIR guaranteeing their involvement in the legal proceedings. It allows police wide range of powers and sometimes too much. That is also another challenges that we face. It allows also the protection to the citizens. If the laws are implemented judiciously correct, it would help the citizens to live peacefully. Similarly, the presence of a forensic expert will enhance the efficiency of the investigating team and allow for crimes to be decoded with the aid of latest achievements in forensic technology. Yet, as with any ambitious reform, several challenges stand in the way. Let me outline a few key areas that require our attention and thoughtful discourse and discussion. It was therefore very heartening to notice that Section 532 of the BNSS allows us for all trials, inquiries, proceedings under the code to be conducted electronically. I am one of the beneficiaries for the digital transformation, out of the digital transformation. I travel very often to foreign countries. My clients also come from foreign countries. They do their electronic evidences through video and through emails. As laudable as this addition is, we must continuously introspect and protect the privacy of the accused as well as victim when dealing with the digitization of proceedings and creating digital evidence. These laws allows for digital courts. That is the biggest advantage that we now face, and the future offers us and especially the law students like you. In the digital age, the data and sensitive information of persons has gained paramount importance. In police stations, courts, we confront the challenges of data leak, every day. The safety of person, the stigma attached to the accused, the threat perception of a witness will be compromised if the privacy of the stakeholders is not protected. Bearing in mind the evolving nature of crime that we have in the modern world and the emergence of new digital crimes like phishing, it is imperative to boost the infrastructure and capacity of our police forces and also court infrastructure. Court crime in contemporary times reflects the technological advancement of our age. It is mandatory that we need to update and upgrade the technological advancement in order to protect the citizens' privacy. The digitization of files and infrastructure for conducting witness examination online must be harnessed to record and peruse voluminous materials with the swiftness of a tap on the screen. I hope that various discussion in this conference spark a positive conversation on various aspects of the new criminal laws. To conclude with a quote by Justice Oliver Wendell Holmes, the law is the witness and the external deposit of our moral life. Its history is the history of moral development of the race. Let us embrace the new change and upgradation of amendments. Thank you very much. Have a nice day.
We now have the honor of inviting Professor Dr. Bageshwari Deswal Ma'am, an esteemed professor from the Faculty of Law at the University of Delhi. Ma'am had been a university topper and gold medalist in both BA Law and LLB in Maharishi Dayanand University, Rohtak. Ma'am has been winner of debates at national and international levels. Ma'am has published book titled Criminal Liability and Other Concept of Substantive Criminal Law in 2013 and Decoding the Indian Anti-Rape Law in 2015. Ma'am is known for her impactful research and dedication to legal scholarship. Ma'am brings wealth of knowledge and a fresh perspective to today's discussion. Let's welcome Ma'am to the mic with a huge round of applause.
Good morning, everyone. Honorable Vice Chancellor, sir, Honorable Director Research, Applied Sciences, respected Professor Vaibhav Goyal ji, Advocate Saju Jacob, Professor Assad Malik, all the dignitaries of the dais, and my dear students. Today we've gathered here to talk about a topic which is extremely pertinent in contemporary times, and that is issues and challenges in implementation of new criminal laws. The new criminal laws that we got this year, which have been implemented from 1st of July 2024. Now, what are these three new criminal laws and why did we need them in the first place? When was the IPC enacted? Anyone? 1860. And what is the year now? 164 years old. Do you use anything that is so old? See, to quote the great Greek philosopher Heraclitus, the only constant in life is change. And laws, they exist to serve the needs of the society. So laws, they need to be dynamic and they need to keep evolving to suit the changing needs of the society. And that is why after such a long time, we needed laws that were modern, contemporary, which could cater to present day problems and which could also be futuristic at the same time. So there is a PPT that I have prepared so that I just don't digress. I've been given a very limited time in which I'm expected to discuss an overview of these laws with you. So we'll start the presentation. First slide, please. When we talk about criminal law, the entire bulk of law is divided in three substantive enactments. The main three enactments, substantive law and the procedural law. The substantive law is that which lays down the substance of the crime. That is, what are the essential ingredients of the crime? At the same time, what are the exemptions, what are the conditions which make a person eligible for exemption from criminal liability. So all that has been laid down in the substantive law. See, till the time we do not have a proper procedural law in place, a substantive law would be of no use. No doubt, substantive law is the most important in criminal law because it tells us what we can do and what we have been forbidden from doing. So that is what the IPC did. Indian Penal Code, it told us exactly what is acceptable conduct and what is forbidden conduct and what is the punishment that is prescribed in case you do not adhere to the prescribed code of conduct in the law. Okay. Now after that we need a procedural law, because what if we don't follow the established law? Then how is an FIR to be registered? What is a complaint? How it is different from an FIR? How does the police arrest or apprehend a person? Does an accused person have a right to bail? Then how is the accused to be tried for a crime? How he is to be punished? All that is laid down in the procedural law. For that we had the CRPC. Now in addition to these two laws, there is one more law, which is the evidence law. So while the substantive law tells us what is to be proved, the evidence law tells us how that is to be proved. So these three laws, they are to be studied together. So that is why now when we undertook an exercise of overhauling our criminal justice system, any one of these laws, they could not be changed in isolation. It had to be a comprehensive exercise because none of these laws, they can exist in isolation from the other two. So that is how we have these new laws now. So first of all, let us decode the titles. IPC has been replaced with Bharatiya Nyaya Sanhita. Criminal Procedure Code has been replaced with Bharatiya Nagarik Suraksha Sanhita, and Indian Evidence Act has been replaced with Bharatiya Sakshya Adhiniyam. So Bharatiya Nyaya Sanhita, one thing that is common in all the three laws is we have replaced the term India with the term Bharat. Now many people say that this might be a political move, but let me be very clear about this thing. What does our constitution say? It says India, that is Bharat. So these are terms which can be used interchangeably. Then, now why did we have to replace this term India with Bharat? Because both connote the same thing. The reason being that we have so many languages that are spoken across the length and breadth of our country. In how many languages would you find the term India? None. And in how many languages would you find the term Bharat? In almost all of them. So at a time when we were enacting laws for our own people. Now see, these are laws which have replaced the old and archaic laws which were enacted by our colonial rulers. They enacted these laws for their subjects. But we were enacting laws for our own people. So the need was to make these laws more indigenous, something that we could all relate to. So that is why the term India, it has been replaced with the term Bharat. Then coming to replacing the term penal code with Nyaya Sanhita. Sanhita is a literal translation for the term code. But change from penal to Nyaya. Penal means punishment. Dand dena, because that was the objective of the Britishers. Anyone who doesn't fall in line, that person has to be penalized. Now our focus is on towards justice, because we are talking about our own people. So we have to ensure that no innocent is punished and no guilty is spared. So justice, it is something in which we have to be very, very mindful of how we have to apprehend a person, try a person, how a person is to be punished. There has to be a holistic understanding of the term justice, because all the stakeholders, their interests have to be taken care of. In criminal justice system, punishment to the accused does not translate necessarily into justice for the victim. हमने accused को पकड़ा, उसको try किया, उसको punishment दे दिया. Victim को क्या मिला? कुछ भी नहीं. If required, sometimes we call the victim to testify against the accused. So at times he can be called as a witness, but that's it. How do you compensate the victim for something that has been done against that person? Victim compensation we introduced as late as in the 21st century in our procedural law. Before that, we had no such thing. We seldom take the interests of the victim while we decide bail petitions also. So in all these things, where does justice appear? And what about a person who is wrongfully accused? And then what about the society at large? When we talk about the theory of social contract, the society at large also has its interests at stake. So that is why we have to be mindful that justice is to be delivered to all the stakeholders of the criminal justice system. That is why there has been a shift now from penalty towards justice. Similarly, when we talk about the Criminal Procedure Code, see, that was a law which merely objectively laid down that if a crime has been committed, this is how a person is to be arrested, tried and punished. Now we are talking about protection to our own people. Because who are the people that we are dealing with? Our own people. Hamare apne nagarik. So we are committed towards a sense of security that has to be there amongst our people. They all should know that the innocent need not fear and the guilty will not be spared. So that is why we have now this. Instead of just a plain procedural law, now we have a law which echoes our sentiments. Bharatiya Nagarik Suraksha Sanhita. And then instead of the Evidence Act, we have the Sakshi Adhiniyam. So what are the changes? At a glance, if we talk about, in Bharatiya Nyaya Sanhita, the new offences that have been added are 20 in number. Jail term and fine has been increased in 116 cases. Mandatory minimum punishment has been prescribed in 23 crimes. And community service has been prescribed in 6 crimes. See, community service is a new kind of punishment that has been prescribed now in our laws. Earlier, we did not have the concept of community service. So now in community service, although BNS doesn't define community service, its definition is found in Bharatiya Nagarik Suraksha Sanhita, because as I told you earlier, all the 3 laws, they are to be read and understood together. So what is community service? It's a kind of a non-custodial punishment. We do not necessarily have to put every person behind the bars. अंग्रेजों की तरह हमें कोई जेल भरो आंदोलन नहीं चलाना है ना. हमें जहां पर लगता है that the crime that has been committed by an individual is petty in nature, there is a scope for reformation. Then in such cases, this is an attempt at restorative justice. We are trying to re-socialize the offender. We are trying to reintegrate the offender within the system. Here I am reminded of an incident. There is a lady judge of Delhi High Court. Once she had gone to Gurudwara Bangla Sahib. For those of you who have been to Delhi, Connaught Place में एक गुरुद्वारा है और वहाँ बहुत लोग जाते हैं. She said once she had gone there, and then there was a group of some 8-9 boys who were just on their bikes, and they were creating a lot of ruckus outside the Gurudwara. Silencer निकाल रखा था, खूब रेस दे करके और वहाँ शोर करते हल्ला करते वो घूम रहे थे गुरुद्वारा के बाद. She said मुझे बहुत गुस्सा आया, मुझे लगा इतना न्यूसेंस ये क्रिएट कर रहे हैं. She asked the police officers to get them in front of her. When those boys, they were brought before me, I realized that they are not criminals. They are just misguided youth. They are just like our children. I mean, see, criminals, they are not born as it is. She said, I felt that these are misguided youth. They are not here to commit a crime. They are doing this because they don't know any better. They are here just for the thrill of it. And that is why they are engaging in these activities. Sending those boys behind the bars would have a negative impact on them. The company of hardened criminals would actually transform them into criminals. So what she said, I put all those 9 boys on a duty. They were asked to do pocha in the Gurudwara, that you will mop the floors, ek jute polish karega, koi langar mein kaam karega. And she said at the end of 1 month, she said I put a police officer also on duty to ensure that these boys, they are doing these duties. And at the end of the month, the boys, they came to me and they said that thank you ma'am for making us realize that what we did was wrong and now we are not going to repeat this in future. So that is what is the objective of community service, because as I said, we are dealing with our own people. So when there is a chance for reformation, every person has not to be necessarily sent behind the bars. Then if we talk about Bharatiya Nagarik Suraksha Sanhita, the new sections, subsections or clauses that have been introduced are 92 in number. 117 sections have been modified, 14 sections have been deleted. In 35 provisions, audio, video, electronic means are required and timelines have been specified at 35 places. Tell me, how many of you have seen the famous movie of Sunny Deol, Damini? नहीं भी देखी, अच्छा बहुत कम ने देखी, नहीं भी देखी हो तो उसका डायलॉग तो याद होगा, तारीख पे तारीख. So That is something, that is an evil which was plaguing our criminal justice system. So what we need is to specify timelines. आज FIR रजिस्टर करी, इन्वेस्टिगेशन आप टाइम बाउंड प्रोसीजर है उसमें टाइम बाउंड तरीके से खत्म कीजिए. कोर्ट्स में once the trial is there, the courts, they cannot just sit upon the files. They have to complete the trials within a time bound manner. Once they have arrived at a conclusion, they are not supposed to sit on those decisions. They are supposed to announce it in open court. All this to be done within a time bound manner so that there is a confidence that is inspired in our people. Then coming to Bharatiya Sakshi Adhiniyam, the new sections, subsections and explanations that have been added are 15 in number, 24 provisions have been modified and 10 sections or explanations they have been deleted. Now if we talk about the historical background, the new laws, how they have come into existence, the first Indian Law Commission was established in 1834, then they gave us the Lex Loci report. Because the Law Commission was asked to do a research and tell us whether we required to codify the laws for Indians, because that was a commission set up by the Britishers. So that commission, it suggested that yes, we need to codify laws for Indians, but see, their suggestions were perfectly in alignment with the Britishers' policy of divide and rule. So what they said, that in personal matters let Indians be divided on religious lines. हिंदू मुसलमानों को आपस में लड़ने दो, तो पर्सनल लॉज को कोडिफाई मत करो. जो उनके क्रिमिनल लॉज हैं, लॉ ऑफ कॉन्ट्रैक्ट है, सिविल प्रोसीजर है, इन सबको आप कोडिफाई कर दीजिए. सो दैट वाज द लेक्स लोसाई रिपोर्ट, जिसके इल इफेक्ट से हम आज तक बैटल कर रहे हैं. उसके बाद in 1845 the second law commission was established, and after we had the Sepoy mutiny in 1857, जिसे वो गदर कहते हैं, तो वो 1857 में उसके बाद अंग्रेज़ों को लगा कि अब तो बहुत ज़्यादा ये लोग हमारे खिलाफ आवाज़ें उठाने लगे हैं. So they have to be crushed, so they brought in this Indian Penal Code, which was already drafted, and they finally implemented it in. Now when we talk about IPC, we got that in 1860, and CRPC we have of 1973. But what purpose would a substantive law serve without the procedural law? So IPC we got in 1860, and immediately the very next year Britishers had drafted a CRPC 1861. In 1862 another CRPC. Why these two CRPCs? Because one was for presidencies, one was for provinces. Then they integrated these two in 1898, and finally in 1973, after we got our independence, we felt the need to constitutionalize. Constitution में मिल गया आज़ादी के बाद. फिर हमें लगा कि ये जो प्रोसीजरल लॉ है अंग्रेज़ों का, उसमें वी आर नॉट टॉकिंग अबाउट द राइट्स ऑफ आवर पीपल. So we needed to constitutionalize our criminal law procedures, because in criminal procedure, what is at stake? Article 21 पढ़ा है आपने? क्या कहते हैं? No one to be deprived of right to life and personal liberty except in accordance with procedure established by. Where is this procedure established by law to be found? In CRPC, in the procedural law. So any procedural law that does not align with our constitution, how would that procedure be of any relevance? So that is why in 1973 we attempted to constitutionalize our CRPC, but then 1973 में तो ये कानून मिला, और कुछ साल के बाद 1979, 1980 में we were faced with one of the darkest chapter of Indian criminal justice system, and that was the Bhagalpur blinding case. I don't know how many of you have heard about it, but you must have seen the movie गंगा जल. उस केस के ऊपर बनी थी, जिसमें कि कुछ एक क्रिमिनल्स जो कि जेल में लॉज थे, पुलिस वालों ने क्या किया, लोहे के सरिये लिए, आयरन रॉड्स, उनको हीट किया, एंड दोज प्रिजनर्स विच वर अराउंड 31 इन नंबर, उनकी आंखें फोड़ी पहले उन सरियों से, और फिर उसके अंदर H2SO4 वॉज पोर्ड. कोई किसी ने कोई शिकायत नहीं करी, मैजिस्ट्रेट ने भी कोई उस चीज़ का कॉग्निजेंस नहीं लिया. There was a habeas corpus writ petition which was filed by a public spirited individual, after which this incident came to light. Okay? And public was also in favor of the police officers, because they felt that the persons जिनके against ये सब हुआ था, they were hardened criminals. But then one thing that was highlighted in this case was that such kind of means, they can never be used to justify the ends, no matter what the ends were. हो सकता है कोर्ट भी अल्टीमेटली इनको फांसी की सजा देती, बट कैन यू जस्टिफाई एम्प्लॉइंग दीज काइंड ऑफ मीन्स? इवन इफ somebody is to be hanged, now we have a procedure for that. Okay, you cannot just employ any kind of procedure as per your own whims and fancies. So this self-styled vigilantism, self-styled justice, this is something that was to be curbed. Police excesses were to be curbed, and this was a case which highlighted that although we were talking about constitutionalizing our procedural system, but what about the rights of the accused persons? We did not have any provisions regarding that. Then what about rights of victims? No provisions at all. What about plea bargaining? No. We say that witnesses are the eyes and ears of criminal justice system. But what about witness protection? We had no provision whatsoever for witness protection in our old laws. So that is why, despite having our own criminal law, many people they say that when you say that you have made these laws contemporary, or these are our laws which have been enacted by our own people, so CRPC was enacted in 1973, what was the need to overhaul it? So this was the need to overhaul it, because it was lacking in so many aspects that we had to update it. Then, so that is how we got these new laws. Evidence Act we had got in 1872. Again, it was a very old law. Now, today, in today's times, today's day, can you insist on paper documents as a means of evidence in every case? In every case, there is minimum one kind of a digital or electronic evidence. कोई भी crime होता है, WhatsApp पे, video recording पे, कोई messaging app पे, कोई ना कोई evidence वैसा होता है. So how can you insist on those paper records? But our Evidence Act was sorely lacking in all these respects, because we got that way back in 1872. So obviously now was the time ripe to change our laws, to make them contemporary, to suit the changing needs of our society. So what was the objective of new laws? To safeguard constitutional rights and deliver justice within Indian soul. We had to get rid of our colonial context, and that is why terms such as British calendar, British queen, juryman, all these, they have been effaced from the statute. The objective was to decolonize our laws and Indianize them. So there is now a paradigm shift. Now we have adopted a progressive approach. Instead of focusing only on punishment, focus is also on providing justice to all the stakeholders. There is a thirst on restorative justice while retaining the deterrence element. There is a better structuring now which makes it easier for people to understand. Law is meant for people, and it should be in an easy language and in a structure which everybody can comprehend. All definitions now. See, tell me, आप किसी भी स्टैट्यूट को उठाते हैं, आप डेफिनेशन ढूंढते हैं तो कौन से सेक्शन में जाते हैं? आईपीसी में डेफिनेशंस कहाँ पे थी? आईपीसी में डेफिनेशंस थी सेक्शन 6 से सेक्शन 52A तक. ढूंढते रहो, पन्ने पलटते रहो, आपके काम की डेफिनेशन कहाँ है. ऊपर से जैसे आप डिक्शनरी में देखते हैं अल्फाबेटिकली होती है, आईपीसी में ऐसा कुछ भी नहीं था. बहुत ही हैपहैज़र्ड तरीके से उसमें सारी की सारी डेफिनेशंस और एक्सप्लेनेशन सेक्शन 6 से सेक्शन 52A तक बिखेर रखी थी. So now what we've done, all the definitions, they have been clubbed, put together in a very systematic manner in section 2. All the explanations, they have been clubbed and put together in section 3. So what we've done, now we have a very systematic law. Then some acts have been decriminalized. That is to align with judicial decisions. Adultery, homosexuality, जो कि हमारे judicial decisions ने उनको strike down कर दिया था. Marital rape की age वो 16 से बढ़ा करके 18 कर दी थी Independent Thought versus Union of India में. तो वो सारी की सारी चीज़ें अब इसमें कर दी गई हैं. So some acts have been decriminalized while enhanced punishments have been provided for others. Redundant provisions have been deleted. ठग की डेफिनेशन आईपीसी में तब ज़रूरत होती थी. आज के दिन तो ठगी करने के और बहुत सारे तरीके हैं. So that definition, it has been rendered redundant. How can you carry on with these kind of definitions in modern times? So it had to be effaced from our statute. So now in Bharatiya Nyaya Sanhita, IPC had a total of 511 sections. BNS has reduced the number to 358. It doesn't mean that the number of crimes has been reduced in any way. या हमने इसको कोई weak law कर दिया. No, it's just that now it's more systematic and it's more crisp. So in total chapters in IPC we had 23, while in Bharatiya Nyaya Sanhita they are 20. So it's systematic, it is more simple. British calendar, Queen, British India, Justice of Peace, Crown, delete kar diya. Court of Justice has been replaced with court in 44 places. Now talking about British calendar. Now that we have replaced with Gregorian calendar. So the objective of laws is to decolonize. The objective of new laws is to decolonize, make the laws contemporary, use progressive language, aligned with new legislative enactments. New legislative enactments, we got the Information Technology Act in 2000. But IPC was not aligned with that. So we needed a proper substantive law which was aligned with that law. Similarly, if we talk about Immoral Traffic Prevention Act, ITPA, you talk about POCSO. Now what about all these laws? Juvenile Justice Act. सब में अलग अलग माइनॉरिटी की एज कहीं पर अलग अलग है, चाइल्ड मैरिज प्रोहिबिशन एक्ट में अलग है, चाइल्ड की डेफिनेशन अलग अलग है. सो वी नीडेड लॉज दैट वर अलाइंड विद मोर कंटेम्पररी लेजिस्लेटिव एनैक्टमेंट्स and which were incorporating latest judicial decisions. So what are the main points when we talk about the substantive law from IPC to Bharatiya Nyaya Sanhita? Certain crimes have been made gender neutral. Now, what are those crimes? See, you must have heard last year there was a case of a private university in Chandigarh wherein a girl, she was recording her own roommate, another girl who was in the process of changing her clothes. Now, till the time we'd had that, at that time, the provision related to voyeurism which we had in IPC, that was totally gender specific. That is, who could be accused of voyeurism? Only a boy. And the victim could only be a girl. And in that case, what had happened? The accused was also a girl and the victim was also a girl. But the law refused to acknowledge that even girls could be guilty of voyeurism. So now what we've done, we've replaced the term man in the perpetrator for the term, by the term whoever. So now voyeurism, it has been made gender neutral. Similarly, if we talk about the crime of disrobing. Now disrobing is something which is usually committed by groups of people. You must all be remembering the Manipuri violence. There were hordes and groups of people. In those groups, there could be men and there could be women also involved. People usually draw strength from numbers. अकेले करने की हिम्मत नहीं होती, ग्रुप में वो ऐसी हरकतें कर जाते हैं. So earlier, the law relating to disrobing was also gender specific. In the sense, perpetrator could only be a man, victim could only be a woman. तो ऐसे भीड़ में से क्या हम चुन चुन के केवल पुरुषों को सजा देंगे और उनके साथ जो महिलाएं शामिल हैं क्या उनको छोड़ देंगे? Now what the law says, instead of using the term man for perpetrator, now we have replaced it with the term whoever. So it is again a partially gender neutral crime in the sense that victim, it continues to be only a woman. But the perpetrator, it could be either a man or a woman. Then when we talk about harboring of offenders is a crime. Okay. But earlier, there was an exception wherein if the harbor is given by the wife of the accused, she would not be held guilty of harboring. Now, does that mean that only men commit crimes? कि औरतें crimes नहीं करती हैं? अगर औरत crime करके जाए और अगर उसका पति उसको हार्बर दे तो क्या उसको exemption नहीं होना चाहिए criminal liability से? हम wives को तो exemption दे रहे हैं. So now we've replaced the term wife with the term spouse. Similarly, we use the term deserter. फौज से जिसे हम बोलते हैं भगोड़ा, deserter. Earlier, again the exception was only available to wives. Why? Because it was only men who served in the defense forces. Now we have women also in the armed forces. So what if a woman is a deserter and her husband gives her a harbor? He is also entitled to this kind of an exemption from the law. Similarly, if we talk about serving of summons, earlier, in the absence of the person upon whom the summons was to be served, it could be served upon only any adult male member of the family. As if women don't have an existence or an entity. Now what the law says, it can be served upon any adult member of the family. It doesn't necessarily have to be a male member. It could be any person. So that is how now the law is more progressive. It is more gender neutral. Then we have introduced new crimes to deal with changing needs of society. Snatching. Earlier we did not have snatching. Then if we talk about crimes that take place like wherein women, they are lured with the false promise of marriage or promotion into having physical intimacy with a man. In such cases, if the man goes back on his promise, so is the man to be criminally prosecuted or not? We had certain guidelines on that. Now, in accordance with those guidelines, a provision has also been introduced. Then we got the Juvenile Justice Act. We amended it in 2015. After the Nirbhaya incident, you must be remembering that it is only in heinous crimes when a juvenile can be tried as an adult. Otherwise, what is the punishment prescribed for juvenile maximum? 3 years. After 3 years, a juvenile is set free. What happened after that? Lots of criminal gangs and all, they started roping in juveniles to commit crimes. They used to engage juveniles to commit crimes for them because कई बार पैसा देके, कई बार ड्रग्स का लालच देके, कई बार नौकरी का या किसी भी चीज़ का लालच देके, family members would also turn a blind eye when their juvenile was engaged in a crime because they had certain rewards for that, and the family members also knew that maximum punishment that can be given to a juvenile is 3 years. So now what have we done? We've introduced a provision wherein if you engage or employ a juvenile for committing a crime, you would be entitled to the punishment for that crime. One, merely engaging the juvenile is a crime in itself for which there could be punishment up to 3 years, and if the juvenile commits a crime for which the juvenile was engaged, तो जुवेनाइल तो 3 साल में छूट जाएगा, लेकिन आपको वो पूरी सजा काटनी पड़ेगी जो उस क्राइम के लिए बड़े को दी जा सकती है. So that is how these new provisions they have been introduced. Then we have crimes such as now organized crime, petty organized crime, terrorist act. So many new provisions they have been introduced. Then if we talk about the crime of theft, earlier theft could take place only in respect of tangible movable property. So much so कि इलेक्ट्रिसिटी के थेफ्ट के लिए भी हमें एक स्पेशल लॉ बनाना पड़ा. आज के दिन we have so many instances of identity theft, data theft. We did not have any provision in the IPC for that. Now what we've done, we've made a simple change in the definition of the term movable property. It includes now property of every description. So now what happens? When there is theft of tangible, intangible, corporeal, incorporeal property, all that would be covered within the definition of the term theft, and all that can be prosecuted under the Bharatiya Nyaya Sanhita. So were all these changes not required? Was it not the need of the hour? Then if we talk about transgenders, are they not equal humans too? Are they some despicable specimen of humanity? Don't they deserve an equal place at the table? We already have the Transgender Persons Right to Identity Act. लेकिन हमारे IPC में तो जेंडर सिर्फ ही और शी था, उसके बियॉन्ड था ही नहीं. Now what it says? The term gender would include all persons. Minor की definition, child, minor को हमने child से replace कर दिया. Child is any person below the age of 18 years. पहले kidnapping में हम पढ़ते थे लड़की अगर 18 से कम हो, लड़का 16 से कम हो तो kidnap हो सकता है. अब हमने क्या कहा? All children. See, even trans children. Moreover, trans children, they are at a higher risk of getting kidnapped and trafficked. Why? Because घर वाले भी शन करते हैं, पीयर ग्रुप उनको मजाक करता है, कई बार टीचर्स भी अगर सेंसिटिव नहीं हो वो भी उनको मजाक उड़ाते हैं, जिसकी वजह से many times these children they run away from their families. Sometimes they are subjected to beating, so they go into their own shell, they go into depression. So these children they are easy victims of trafficking and prostitution. So they also need to be protected. वो अगर हम मेल फीमेल बाइनरी की बात करेंगे तो उन बच्चों को कैसे बचाएंगे? So now we've replaced this term child, minor with child. Any person below the age of 18 years. Gender, all genders, all persons. So these are the changes. I think my time is up now. So I would just like to conclude by saying that yes, these changes were the need of the hour. So to say that old Hindi song, छोड़ो कल की बातें, कल की बात पुरानी. Let us embrace these changes wholeheartedly. Thank you. Jai Hind, Jai Bharat.
Thank you, ma'am, for sharing your invaluable insights. We are now privileged to invite our honorable guest speaker, Dr. Mohammad Assad Malik, sir, who is currently teaching in Faculty of Law, Jamia Millia University, New Delhi. He has studied law in MJP, Rohilkhand University, Bareilly, UP, and PhD on States Liability in Tort, a case study of India from Jamia Millia University, New Delhi. Sir has more than 18 years of experience of teaching and research. Sir has published 25 and counting papers in international and national journals and presented more than 40 papers at international and national conferences. Sir has also delivered more than 200 invited lectures in various programs which include IAS, IPS, IRS, judicial officers, ITS, PCS, HCS, labor commissioners, forest officers, doctors, engineers, teachers, teaching program, and to students of various universities and colleges. He also presided over as judge for more than 80 international moot court competitions, seminar and conferences. With a huge round of applause, let's welcome Assad Malik sir to the podium.
Thank you very much. First of all, I would like to thank Subharti University for inviting me, and congratulations for organizing this national seminar on issues and challenges in implementation of new criminal laws. And as you know, today this is 9th November, Legal Service Authorities Day, and Madam has discussed about the access to justice. All of you might be aware when the Legal Service Authorities Act was passed, and then this Legal Service Authorities Day is celebrated, basically to provide the justice to each and every individual. Respected Honorable Vice Chancellor, Major General Dr. G.K. Thapyal sir, respected Professor A.P. Garg, Director Research Applied Science, respected Saju Jacob, Advocate, Supreme Court of India and Solicitor UK, respected Dean Professor Vaibhav Goyal Bhartiya, Dr. Reena, Dr. Sarika, Premchandra, all the teachers and all their students. As this topic introduced by the respected members and Bageshwar ma'am in discuss detail about all these things. First of all, I would like to think one thing that आपका जो मोबाइल है वो ऐसा लग रहा है जैसे किराए पे लेकर आए हों. जब हम बचपन में साइकिल लेते थे 50 पैसे के घंटे में, तो कितना भी चलना होता, वही कुछ बच्चे मोबाइल में ऐसे लगे जैसे किराए का है, अभी वापस करना है घर जाके. तो इसलिए पहले उससे अपने मोबाइल को थोड़ा सा बंद कर दीजिए. और दूसरा जो 3 कानून के बारे में बात हुई थी अभी, जस्ट मैडम डिस्कस अबाउट दिस एंड शी स्टार्टेड फ्रॉम द कॉलोनियल माइंडसेट, बिकॉज ऑल वी नो दैट व्हेन द कोडिफिकेशन वाज स्टार्टेड इन 1833, when Lord Macaulay came and these 3 courts were made by the Britishers, and the reason that was replaced by, because as the law is a tool of the social change. और फिर एक और भी बात थी कि वो जो एक शेर था वसीम बरेलवी का, पतंगों की तरह उड़ना भी कोई उड़ना है, पतंगों की तरह उड़ना भी कोई उड़ना है, उड़ रहे हैं मगर दूसरों के हाथों में. So actually you are supposed to be yourself, you too. So that is the attempt has been made to make this law. On the other side, many people, yesterday I received a call by one of my student. वो कहता है सर ये बताइए इसमें जो चेंजेस हैं क्या, अब हमें बहुत परेशानी हो रही है, हर दिन ब्रीफ करना, पुलिस वालों को समझाना. तो फिर वहाँ पर अब सवाल ये था, एक वसीम बरेलवी का शेर था कि ज़लज़लों के खौफ से घर बनाना छोड़ दें, हादसों की ज़द पे हैं तो क्या मुस्कुराना छोड़ दें. So it means you will not make a law. Actually this is the need of the time, and accordingly you are supposed to make yourself ready, because as the madam also highlighted the use of the technology and the timeline which was the need of the time, because as madam started the milti hai to sirf tarikh from 1979 when the Husainara Khatun judgment was delivered until 2024, still when you will see National Judicial Data Grid, when you will open the website, you will see how many cases are pending in the different courts in India. It is reflecting the position of the Indian criminal justice system. So that's why there was the need of this law. And the other side, if you will see the criminal justice system which we are having in our country, that is known as the adversarial system of law. I think all of you are aware about the adversarial system of law. There are 2 adversaries. Number 1, prosecutor. Number 2, defense counsel. And judge as a neutral party is sitting there, who is supposed to deliver the judgment on the basis of the evidences. And it is necessary that justice to be provided. Justice to whom? Because offense considered against the society. And victim compensation was not there. As Bageshwar ma'am said, now there is a provision. Because what if the fine imposed, death penalty awarded, what is the benefit to the family of the victim? उथा ना खुदा ही मिला, ना बिसाले सनम, ना इधर के रहे ना उधर के हम. So you have to provide something to the person who is there. So actually this is the reason that keeping in all the aspects. And one of the advocate Murphy in London, उन्होंने पूछा adversarial system में वकील साहब ने जज साहब से, may I know the truth? Lawyer said, no my lord, only evidence. So actually in criminal justice system based on the adversarial system of law, basically as Bentham said, witnesses are the eyes or ears of the court of law. Now we are coming to this topic, as already madam introduced about this Bharatiya Nagrik Suraksha Sanhita or CRPC. From 1861 till 1973, many times the CRPC was changed. And after 1898, when the Constitution of India came into force, then also from 32nd, 33rd, 35th, 36th, 37th or 41st, these 6 law commissions submitted the report for changing this CRPC, and many times the CRPC was amended. 1978, 1991, and particularly after Nirbhaya gang rape 2013, and then Kathua gang rape 2018, and today now it has been replaced. But as the term used that Bharatiya Nagrik Suraksha Sahinta, here I think that will be better. We have to remove the code, because the codification purpose was different when it was codified. So today we could use the term act as we use in the Adhiniyam, because still we are giving the Hindi meaning of the code. So that is not appropriate, I think. And when you will see the preamble, that is also not the same thing. Now we are coming to the question that as today we are having this BNSS 531 section, 39 chapters, 2 schedules. In number 2 schedule there are 2 more forms added. Today we are having 56 forms. And we know that offense against the society. All of you I think are aware about the offense. What is offense? Being a law student, the meaning will be different. Being a layman, the meaning will be different. What is offense? Offense क्या होता है? Any act or omission punishable by law. That is offense, which is defined under section 2Q of the Bharatiya Nagrik Suraksha Sahinta. Earlier it was defined under section 2N. And offense when committed, then who is the first person to whom you are contacting? सबसे पहले किसे फोन करते हो? डॉक्टर को, वकील को, इंजीनियर को, मैकेनिक को, पुलिस को, to whom you are calling? Police officer. It means the 5 functionaries, those are involved in the criminal justice system. Number 1, police. Number 2, prosecutor. Number 3, magistrate. Number 4, defense counsel. Or number 5, prison authorities. So these are the 5 functionaries playing the important role from the time when the offense is committed and this execution of the sentence. Now the question arises, offense if committed, how the police officer will decide what should do? How can he know? He is not a law graduate. Mistake of law is no excuse. And he is supposed to follow the law without knowing the law, without reading the law. तो कोई ख्वाब में तो आएगा नहीं उसे लॉ पढ़ाने कोई, तो फिर वो कैसे कानून जानेगा? उसके लिए मदद कहाँ से मिलेगी? Even number of the training programs organized by the government for the police officers as well. Actually, for that purpose, to set the criminal law into the motion, we are having 2 agencies in our country. Number 1, police, और number 2, अगर पुलिस ने आपकी नहीं सुनी तो आप कहाँ जाएंगे? Magistrate. तो 2 parallel agencies, number 1 police और number 2 magistrate. So these agencies, how can you set them into motion? For that purpose, you need the classification of law. As all we know, cognizable offense, police, non-cognizable offense, magistrate. Number 1 FIR or number 2 NCR. What is the difference between NCR and FIR? Full form मालूम है ना? What is the full form of the FIR? और NCR? नहीं, मैंने पूछा इसलिए क्योंकि मैंने एक बार क्वेश्चन पूछा था एग्जाम में, व्हाट इज द डिफरेंस? तो बच्चों ने जो क्लास में आए थे उन्होंने तो वही लिखा जो है, जो नहीं आए थे उन्होंने लिखा FIR तो बता दिया. NCR, नेशनल कैपिटल रीजन, गुड़गांव, फरीदाबाद, गाजियाबाद, एंड सम सेड इवन मेरठ नाउ इज कमिंग विद इन द NCR. तो इसलिए मैं पूछ रहा हूँ, दिस इज नोन एज ए नॉन कॉग्निजेबल रिपोर्ट. एंड हियर in case of the cognizable, police has more power. In case of the non-cognizable, magistrate has more power. So actually this classification, cognizable, non-cognizable, bailable, non-bailable, compoundable, non-compoundable, summon case or warrant case. There is no change in the definition of any of this classification. Now you know that this hierarchy of the court or hierarchy of the public prosecutor in our country. That is one of the most important thing. In the hierarchy, if I ask from top to bottom, highest court is Supreme Court, then High Court, then Session Judge, then no. The two magistrate, now two things have been removed. Number one, from the hierarchy, Assistant Session Judge has been removed. Metropolitan Magistrate has been removed. Today when you will see Supreme Court, High Court, Session Judge, Additional Session Judge, Chief Judicial Magistrate of the first class or second class. How much punishment can be given by the Supreme Court? Any High Court? Any punishment? CJM? Sorry, Session Judge? Death penalty subject to the High Court. CJM? 7 years, any fine. Judicial Magistrate of the first class? 3 years and plus 50,000 rupees fine and community service. Second class magistrate? 1 year, 10,000 community service. As madam also said, the community service first time introduced in our criminal jurisprudence. and which is not defined section 4F of the BNS and section 23 of the Bharatiya Nagrik Suraksha Sanhita. Community service explanation in this 23 is saying community service means for which the person will not get any kind of the remuneration. That is the community service. Even it was there in the Juvenile Justice Act 2015. That was as a form of the punishment under section 18 and juvenile justice rules. This was categorically mentioned. On the other side, we are coming to the hierarchy of the public prosecutor. What is the hierarchy of the public prosecutor? Directorate of the prosecution, then deputy directorate. One addition is here under Bharatiya Nagrik Suraksha Sanhita, that is the assistant director of the prosecution. Section 18. पहले 24-25 से था, now 18, 19 and 20. And then public prosecutor, special public prosecutor, additional public prosecutor or assistant public prosecutor. There are two changes made here. Number one, the director of the public prosecutor qualification has been now changed. 15 years as an advocate or has been a session judge, which was not there. Concurrence of the High Court was necessary earlier, now it has been removed. Power and responsibilities which was not defined earlier, described earlier, now it is given under section 20, class 7, class 8, class 9. Now we are coming to this three stages after the commission of the crime. Number 1, investigation. Number 2, inquiry. Or number 3, trial. So first is investigation. Investigation defined under section 2, class L of the Bharatiya Nagrik Suraksha Sanhita, which was earlier section 2H. There is no change, only one explanation is added, which is saying if there is a special law and BNSS there is a conflict, then the special law to prevail over the BNSS. What is the purpose of the investigation? What do you mean by investigation? Investigation means that is the collection of the evidence and recording the statement. And who will conduct the investigation? Police officer or any person. So this is the investigation start. And first step, as I discussed, FIR. And sir already said that zero FIR. Earlier section 154, now section 173. The term zero FIR now not used even in BNSS. But as the madam cited, the number of the judgment has been incorporated. In the BNSS also, either the judgment has been diluted or the judgment has been incorporated. Under the this 173, three changes have been made. Number 1, zero FIR. Number 2, EFIR. Number 3, preliminary inquiry. Zero FIR, irrespective of the area the term is used. Punati Ramulu versus State of Andhra Pradesh, 1973. In this case, the Supreme Court said the police officer cannot refuse to register the FIR on the ground that it is not within the jurisdiction. It means it was permitted earlier as well. Satvinder Kaur versus NCT Delhi, 1999. Again, the Supreme Court said if the information given to other police station, which is not jurisdictional police station, then they have to forward the information to the concerned police station. It means it was there. EFIR. EFIR means the information even earlier can be given through the telephone. It is not new, but the terminology now use that electronic communication. If information given through the electronic communication, that should be signed by the informer within the period of 3 days, that is 72 hours. Number 3, that is known as preliminary inquiry. However, the inquiry term which you use in the criminal jurisprudence is totally different. But you know that in the case of the Lalita Kumari, the Supreme Court of India allowed the preliminary inquiry in 4 or 5 types of the offences: matrimonial dispute, corruption cases, commercial dispute, medical negligence. So these cases the preliminary inquiry was allowed. But now this preliminary inquiry that has been incorporated as under section 173 class 3 in the offences punishable more than 7 years with the prior permission of the Deputy Superintendent of the Police, this inquiry to be conducted and the report to be submitted within the period of 14 days to find out whether there is a prima facie case or not. It is a good, because earlier only in corruption cases or commercial. What do you mean by corruption? Corruption may be of 100 rupees or a corruption may be 1000 crore rupees. It means there was no equality. If a person who is committing the theft, अगर उसने एक ब्रेक चुराई है तो उसके लिए रूल दूसरा था, और अगर कोई 1000 करोड़ लेके निकल गया तो उसके लिए दूसरा था. वो एक शेर था ना कि वो मिसाइल बनाकर भी पा गए ऊंचा मकाम, वो मिसाइल बनाकर भी पा गए ऊंचा मकाम, हम एक कट्टा बनाए जेल में डाले गए. when the offence is committed, that is this information, so that now parity is maintained. 7 years for all. So this preliminary inquiry now has been introduced under the भारतीय नागरिक सुरक्षा संहिता. Even अब सवाल उठा क्यों 7 साल? इसके पीछे भी कुछ वजह है. वो कहते नहीं बेखुदी बेसबब तो नहीं, बेखुदी बेसबब तो नहीं, कुछ तो है जिसकी पर्दादारी है. तो what is this? If you will go back 2009, all of you have 49A was added. Notice to be issued if the offence punishable for 7 years. Arnesh Kumar versus State of Bihar, 2014, I think all of you are aware. Siddharth versus State of Uttar Pradesh, 2021, arrest is not necessary. Satyan Kumar Antil versus CBI, 2021. It means these all cases saying, in the case punishable up to 7 years, the arrest is not necessary. That's why the preliminary inquiry in those offences punishable up to 7 years to be conducted, and then FIR if required will be registered, otherwise not. Reason is that कि अगर उसने कुछ भी नहीं करा है तब भी आपने उसके खिलाफ लिख लिया. तो अब यहां पर ये प्रोविजन बेहतर इसलिए है कि इससे कम से कम पुलिस को एक 14 दिन का वक्त है. अब सवाल यहां पर खास तौर से 2 जो किताब में नहीं लिखे हैं, आपके ना भी एक्ट में लिखे हैं. सवाल यह है कि इन ईच एंड एवरी ऑफेंस विच इज पनिशेबल अप टू 7 years द प्रिलिमिनरी इंक्वायरी इज मैंडेटरी और एनी एक्सेप्शन. नंबर 1. Number 2, if the police failed to complete the inquiry within the 14 days, then what will be the consequences? So actually, SOPs has been issued by the central government, Ministry of Home Affairs. It is clarified in those SOPs, number 1, there are 2 exceptions are there. Number 1, if the offence punishable under section 199 class C of the भारतीय न्याय संहिता. 199C का मतलब जो उस वक्त 166A का क्लास C था. अगर कोई लेडी किसी अफेंस के बारे में उसके खिलाफ जो हुआ है पुलिस को इन्फॉर्मेशन देती है और पुलिस इन्फॉर्मेशन अगर नहीं लिखती है तो पुलिस वाला भी उसके लिए लायबल होगा. तो दिस इज द अफेंस इवन पनिशेबल अप टू 6 months. बट preliminary inquiry will not be mandatory. Without conducting the preliminary inquiry, FIR will be registered. Number 2, if the offence committed under the SC/ST Act, then preliminary inquiry will not be necessary. Directly the FIR will be registered. Number 3, that if the police fail to conduct the preliminary inquiry within the 14 days, then the police has to register the FIR. And the responsibilities also on the SHO and the deputy superintendent of the police. That has been now mentioned. If FIR is not registered, all of you know, you are supposed to go to the superintendent of the police, then you have to go to the magistrate. तो 175(4) जोड़ दिया गया है, और सॉरी 173(4) एंड 175 खास तौर से जो क्लास 3 जो 156(3) हुआ करता था, which is now section 175 class 3. One thing is added now, if a person who is filing the application under section 175 class 3, that should be supported by the affidavit. It is not new. In the case of the Priyanka Shrivastava versus State of Uttar Pradesh, 2015, the Supreme Court first time made it mandatory the requirement of the affidavit, but now statutory recognition is given. 175 class 4 is newly added section, which is the protection available to the public servant. If any of the complaint is filed, then the assertion of the public servant will be necessary, and also the report of the senior official will be asked. Forensic investigation is now mandatory. Even it will be implemented after 5 years. According to section 176 class 3, offence punishable more than 7 years, then forensic team will visit the place, that will be audio videograph, and that will be implemented after the 5 years. So actually these are the certain changes have been made in the case of the investigation. Now, so far as the arrest is concerned, there is no change. पहले 41 था, अब 35 है. Only one section is added, 35 class 7. If any offence committed, punishable up to 3 years, and the person accused, either the child, age more than 60 years, or a female, then arrest can only be made with the prior permission of the deputy superintendent of the police. If the private person is arresting, जो पहले 43 था, अब जो 40 हो गया, 6 hour time has been fixed. The person should be handed over by the persons, जो प्राइवेट पर्सन ने गिरफ्तार करा, 6 घंटे के अंदर आप उन्हें. एक चीज और चेंज हुई है, जो पहले 37 जो पहले 43C था, उसमें एक चीज उन्होंने ऐड कर दिया कि दैट वन ऑफ द पुलिस ऑफिसर नॉट बिलो द रैंक ऑफ द सब इंस्पेक्टर शैल बी डेजिग्नेटेड एट ईच एंड एवरी डिस्ट्रिक्ट फॉर मेंटेनिंग द रिकॉर्ड ऑफ द पर्संस हैज बीन अरेस्टेड एंड इट इज आल्सो बी डिस्प्लेड, एंड सम ऑफ द स्टेट इंक्लूडिंग द महाराष्ट्र दे सेड दैट डिजिटल डिस्प्ले दैट विल बी डन. एक और चीज जो सबसे कंट्रोवर्शियल है, जो चैलेंज भी हुई है कोर्ट में, 43 क्लास 3, पहले हैंडकफिंग हमारे यहाँ नहीं था. इन द केस ऑफ द प्रेम शंकर शुक्ला, डेली एडमिनिस्ट्रेशन 1980 कोर्ट ने कहा था हैंड कफिंग इज इनह्यूमन, वायलेशन ऑफ द आर्टिकल 21 एंड इफ रिक्वायर्ड विद द प्रायर परमिशन दैट कैन बी डन. बट नाउ अकॉर्डिंग टू सेक्शन 43 क्लास 3 दैट दिस हैंड कफिंग इज अलाउड, मे बी हैंडकफ्ड इन द ऑफेंसेस जो लिस्ट वहां पर दी है. तो एक तो यहां पर ये बदलाव आया. इसके अलावा अब आता है जो सबसे इंपॉर्टेंट चीज है, रिमांड. रिमांड मेरे ख्याल से सभी जानते होंगे. अर्लियर इट वाज सेक्शन 167 एंड नाउ इट इज सेक्शन 187. इसमें 3 चेंजेस हुए हैं. रिमांड तो जान ही रहे हैं कितने दिन की होती है. नंबर 1, इफ द पर्सन अरेस्टेड कितने देर में जाना चाहिए मजिस्ट्रेट को, 24 आवर. पुलिस रिमांड कुड बी फॉर मैक्सिमम 15 days. And then the remand in the judicial custody is 60 days or 90 days. It was the law. What changes has been made in the Bharatiya Nagrik Suraksha Sanhita? Number 1, now this 15 days can be stretched up to the 40 days. If the offence punishable up to 10 years, it is more than 10 years, it may go to the 60 days. मतलब पहले जो 15 दिन के अंदर ही लेना था according to अनुपमा कुलकर्णी versus CBI 1992, now it can be. आज अगर 5 दिन के लिए 20 दिन के बाद फिर 5 दिन की लेंगे, 25 दिन के बाद मतलब 40 दिन तक ले सकते हैं और उधर 60 दिन. क्यों ये हुआ? CBI वर्सेस विकास मिश्रा 2022 where the Supreme Court said there is a need to reconsider the decision of the Anupama Kulkarni and these people means the accused are misusing this provision. उसमें गिरफ्तार करके लाती है पुलिस, जैसी अरेस्ट होती है उसके बाद वो पुलिस रिमांड मिल जाती है, वो बीमार पड़ जाता है, हॉस्पिटल में भर्ती हो जाता है, रिमांड 15 दिन खत्म हो जाते हैं, हॉस्पिटल से बाहर आ जाता है, फिर सीबीआई कहती है इसकी पुलिस कस्टडी, कोर्ट कहता नहीं दे सकते बिकॉज देयर इज ए लिमिट. देन इट वाज सैड कि दैट इज वन ऑफ द रिक्वायरमेंट, दिस देयर इज ए नीड टू चेंज. सेंथिल बालाजी सुप्रीम कोर्ट रेटेटेड द सेम थिंग, क्योंकि जो हाई प्रोफाइल पीपल होते हैं वो कहते नहीं हमने किया गुनाह जो दोजख हमें मिली. दोजख का क्या गुनाह था जो दोजख को हम मिले? अब उन्होंने गुनाह करके पूरे मिसयूज करके लॉ को और दूसरे भी उसके समझ में आया. तो कुल मिला के पर्पज ये था. अब यहाँ पर जो कंट्रोवर्सी है वो ये है, वो खास बात है, ध्यान से सुनना. नाउ द क्वेश्चन इज टुडे इफ यू आर ए मजिस्ट्रेट, एनी पर्सन हु अपीयर बिफोर यू, 15 days आर ओवर, पुलिस कस्टडी इज टाइम. नाउ दिस पुलिस और प्रोसिक्यूशन इज डिमांडिंग द कस्टडी इन द पुलिस मोर देन 15 days, whether it is allowed according to BNSS or not, or it will be only for 15 days, matlab only 15 days. Actually in the CRPC it was written otherwise than the custody of the police. It was mentioned. It means otherwise than the custody of the police का मतलब पहले 15 दिन पुलिस कस्टडी होगी, उसके बाद जुडिशियल ही होगी. But now this term has been deleted. Even the government of India, Honorable Home Minister on 2nd July clarified that this police custody will remain only for 15 days. It may be for 60 or 40 days, but the police custody cannot go beyond the 15 days. BPRD also uploaded in the website, but the law is not saying this. According to law, the police custody can be up to 90 days or up to 60 days. Why? If you will read section 480 proviso number 3, it is clearly written that provided that merely the bail cannot be denied to a person that he is required for the identification or police custody beyond the 15 days. It means if you will read at 187 with 480 proviso, it is clearly indicating now the remand in the police custody may be beyond the 15 days. Now it will depend what kind of the interpretation will be done by the judiciary. One more change. One of the judgment was delivered in 2007, Rakesh Kumar Paul versus State of Assam, जिसमें कोर्ट ने ये कहा था अगर 10 साल तक पनिशेबल है तो उसमें 60. अब उन्होंने क्या करा, ये टर्म ही हटा दिया. Now it is saying offense punishable more than 10 years or more, 90 days police custody, 90 days custody or up to 10 less than 10 years. So term less than they use under section 187. So far as the bail is concerned, as such there is no change has been made, only little bit changes have been made. Now we are coming to the timeline which has been, क्योंकि सबसे ज्यादा 2 चीजों पर फोकस था. नंबर 1 टाइमलाइन, नंबर 2 यूज ऑफ टेक्नोलॉजी. तो टाइमलाइन इफ यू विल सी एज वी डिस्कस, FIR 72 days आवर्स के अंदर साइन करने होंगे. इन केस ऑफ द नॉन कॉग्निजेबल ऑफेंस द रिपोर्ट विल बी सबमिटेड फोर्टनाइटली, मतलब 15 दिन की होगी. व्हेन द चार्जशीट इज सबमिटेड अंडर सेक्शन 193, देन इट शुड बी अकॉर्डिंग टू द प्रोविजन ऑफ द BNSS 60 दिन और 90 दिन का टाइम है. लेकिन चार्जशीट सबमिट होने के बाद जब मजिस्ट्रेट कॉग्निजेंस लेता है एंड द कॉपी इज टू बी सप्लाइड, सेक्शन 230 विद इन 40 days कॉपी टू बी सप्लाइड, committal should be done, 90 days from the time of taking the cognizance, which can be extended to 180 days under section 232. Discharge application can be filed within the period of 60 days from the appearance of the person under section 250. Charges to be framed within the 60 days according to section 251 of the Bharatiya Nagrik Suraksha Sanhita. Judgment to be delivered within 30 days, which may be extended up to 45 days. पहले कोई time नहीं था, but now they have fixed the time 30 days, which can be extended to maximum 45 days. Copy of the judgment to be uploaded within 7 days on the portal according to section 392 class 4 of the Bharatiya Nagrik Suraksha Sanhita. Or many places also the timeline has been fixed for the purpose of speedy justice. And on the other side, so far as the use of the technology is concerned, 4 sections are most important. मैडम ने बताया 35 सेक्शन ऐसे हैं जहां ऑडियो वीडियो और ये इलेक्ट्रॉन, लेकिन 4 सेक्शन के बेस पे आप समझ लीजिए इसका यूज क्या है. नंबर 1 सेक्शन 2A विच डिफाइन दी ऑडियो वीडियो इलेक्ट्रॉनिक मीन्स. हाँ, एक खास बात, इसमें बिल को डिफाइन कर दिया गया है, बिल बॉन्ड को डिफाइन कर दिया गया है और बॉन्ड को भी डिफाइन कर दिया गया है जो पहले नहीं था. ऑडियो वीडियो की डेफिनेशन दी है. सेक्शन 2I इलेक्ट्रॉनिक कम्युनिकेशन इज डिफाइंड. एंड 105 every search and seizure shall be videographed by the constable from the cell phone and it should be forwarded to the district magistrate, sub-divisional magistrate or judicial magistrate of first class. And then 530 that is known as a e-court. All the proceedings including the summon, warrant, execution, conducting of the trial may be conducted in the through audio video electronic means. Summon can be issued through electronic means. So actually all these changes have been made. Now I am coming 4 sections जो ऐसे हैं जिन पे थोड़ा नए हैं. नंबर 1 86 सेक्शन जोड़ा गया. पहले हाँ 84 की बात कर लेते हैं. आपने सुना होगा सम्मन होता है, वारंट होता है, अटैचमेंट होता है. मतलब एक वो शेर था जमुना प्रसाद उपाध्याय का कि यहाँ कुर्की है ना, यहाँ वारंट है, कुर्की है, कारागार का डर है. यहाँ वारंट है, कुर्की है, कारागार का डर है, गुंडे सियासत में न जाएं तो कहाँ जाएं. तो एक्चुअली जो कुर्की, कारागार और अटैचमेंट, तो पहले होता है सम्मन, फिर बेलेबल वारंट, देन नॉन बेलेबल वारंट, देन प्रोक्लेमेशन, देन प्रोक्लेमेशन अफेंडर, देन अटैचमेंट. प्रोक्लेम्ड अफेंडर पहले 82 क्लास 4 में 19 सेक्शन में हुआ करता था. दैट हैज बीन रिमूव्ड. नाउ दे अंडर सेक्शन 84 दे सेड कि that is if offence punishable more than 10 years the person can be declared as a proclaimed offender. Section 85 attachment, there is no change, but they added one more provision which is the new provision section 86. अगर कोई प्रॉपर्टी हिंदुस्तान के बाहर है या दूसरे देशों में है तो उसके अटैचमेंट का भी प्रोविजन कर दिया गया है. एक और खास बात है 107 नया प्रोविजन जोड़ा गया है जो पहले नहीं था. अंडर वन इट इज फ्रॉम द PMLA, forfeiture of the property and should be distributed to the victim of the crime, or if no victim is found out it stand to be forfeited to the government. तो ये PMLA से आया है. हालांकि इसके बारे में कहा जा रहा है there is no safeguard is available which is available in the PMLA. तीसरी चीज in absentia trial, if the person declared proclaimed offender there was no trial, now it is allowed under section 356. In absentia trial, keeping in view the certain safeguard which has been provided to the person accused. उसका ट्रायल कंप्लीट होगा लेकिन सजा जब ही होगी जब वो मिल जाएगा, दूसरे के में घर को किसी को नहीं निभाएंगे. चौथा बहुत अच्छा चेंज है कि एक्चुअली दोज पब्लिक सर्वेंट और द विटनेसेस which were supposed to appear physically before the court of law, now they may appear through the audio video electronic means. Section 336 is a new provision which is added now, 336, जिसमें ये बताया गया है कोई भी सक्सेसर और एनी अदर पर्सन ऑन बिहाफ, अगर उसकी डेथ हो जाती है, ट्रांसफर हो जाता है, इफ द पर्सन वांट कैन आल्सो अपीयर थ्रू द ऑडियो वीडियो इलेक्ट्रॉनिक मीन्स. तो दिस इज फॉर द पर्पज ऑफ अवॉइड द हार्डशिप इट टू बी फेस्ड बाय द पर्सन, क्योंकि कई बार उन्हें या तो छुट्टी नहीं मिल रही होती थी, बहुत जगह दूर थी. अभी उत्तर प्रदेश में आपने देखा होगा कोर्ट उन्होंने वारंट इशू कर दिया. तो बिकॉज ऑफ दैट रीजन दिस 336 इज वेरी ब्यूटीफुल प्रोविजन दैट विल बी वेरी हेल्पफुल. एंड वन मोर इंपॉर्टेंट थिंग, दिस electronic communication or use of the technology certainly will be helpful for making the justice easy, because here it is to be said access to justice, ease of justice and transparency. These three things should be kept in mind. But at the same time when we see these changes, अब सवाल है challenges क्या है. अगर ये कानून बना तो दिए गए, लेकिन अब आगे क्या परेशानी है? तो what kind of the problem we may face in future? Actually, Government of India conducted so many workshops, training program for all the stakeholders or functionaries. But as the forensic investigation will be implemented after 5 years, it means we are supposed to develop the infrastructure. Another problem we will face with respect to this right to privacy, which is one of the fundamental right. And also, in our country, less trusted department is the police. मतलब सबसे ज़्यादा पहले कॉल तो हम पुलिस को करते हैं, लेकिन सबसे ज़्यादा कम भरोसा भी करते हैं पुलिस पे. Any statement recorded by the police, not admissible. Any confession before the police, not admissible. But अब जो उसने मोबाइल से रिकॉर्ड करा है, अब सवाल उठेगा कि फॉर एग्जाम्पल that will be forwarded. For that purpose, even e-Saksh, e-Praman, number of the apps has been. But still they are facing the problem because of the network. कितने पुलिस वालों का कहना है साहब नेट नहीं आ रहा होता, हमें सर अपलोड करना है, नहीं होता है. और दूसरी बात, टेक्नोलॉजी में अगर धोखे से वो डिलीट हो जाए जो वीडियो बनाई है, तो लोग समझेंगे पैसा लेके और सेटिंग कर ली, क्योंकि भरोसा तो हम कर नहीं रहे पहले से ही. तो एक्चुअली दिस काइंड ऑफ दी टेक्नोलॉजिकल एडवांसमेंट सर्टेनली हेल्पफुल, बट एट द सेम टाइम वी हैव टू एश्योर दैट राइट टू प्राइवेसी and this hash value जो उसकी है and this chain of custody, everything that should be assured. So this problem will come. So for as one more thing, as you know, the judicial impact assessment or legislative impact assessment, so when the law is made, at the same time we need more courts, more public prosecutor and more judges. Lawyers की कमी नहीं है, because number of the law colleges are there and number of the students are coming and getting enrolled. So basically in future these kind of the challenges may come and we hope जब कोई परेशानी होती है तभी उसका सॉल्यूशन भी ढूंढा जाता है. तो अल्टीमेटली वट एवर द चेंजेस हैव बीन मेड एंड यू नीड टू स्टडी all these 3 laws, because if you want to appear in any of the examination or as a lawyer, so it will be very helpful to you. Thank you very much to all of you and Vice Chancellor sir or Vaibhav Goel sir. Thank you very much.
We welcome Professor Dr. Amar Prakash Garg sir. Sir is Director of Research Applied Sciences at Swami Vivekanand Subharti University. Sir is former Vice Chancellor of Soviet Institute of Engineering and Technology. We welcome you, sir.
So, thank you very much. Very good afternoon to all. Honorable the Vice Chancellor, learned advocate Saju Jacob, Professor Assad Malik, Professor Bageshwari, Professor Vaibhav Goel, Professor Rina Bishnoi, my colleagues, and the young budding advocates. You have all heard about that what changes have been brought in these 3 laws. Why these changes have been brought? What is their importance? But the most important point to my mind, that is, what is the challenge in its implementation, has not been touched. To my mind, the biggest challenge, or in nutshell, if I say, then the rules which were based during British period, these rules were basically to rule us, not for the rule of law. So that was the basic fundamental thing. That's why the rules were changed. The second thing which comes to my mind is that for delivery of the speedy justice, these 3 laws have been formulated and enacted. 51 million cases are pending before the courts as on October 31st, 2024, out of which 3.1 million alone they are pending in the high courts and supreme courts. Do you think that these 3 new laws will reduce these number of the courses? I have big doubt. If these number of the cases are to be reduced, then we have to increase the number of the courts. We have to make such type of the system, for example, लोक अदालत. एक मैं आपको दृष्टांत सुनाता हूँ. जब मैं 1982 में ब्रिटेन में था, 42 years ago, कॉमनवेल्थ एकेडमी स्टाफ फेलो था. मैंने अपना टिकट, मेरी फैमिली का टिकट तो ब्रिटिश काउंसिल ने दिया था, मेरा टिकट ब्रिटिश काउंसिल ने दिया था, मुझे अपनी फैमिली का टिकट खुद खरीदना था. मैंने टिकट के लिए एजेंट से बात की, फाइनल हुआ. 400 पाउंड में मेरे को टिकट जो था मेरी वाइफ का, मेरे बच्चे का तय हो गया, और उसने एक स्लिप पे लिख करके दिया. जब मैं उससे टिकट लेने गया तो उसने कहा नहीं साहब 430 पाउंड होंगे. हमने कहा साहब भाई ये तो गलत बात है, आपके हमारे 400 पाउंड तय हुए थे. हमने ये बात अपनी कॉफ़ी टेबल पे शेयर की, और जब कॉफ़ी टेबल पे शेयर की तो हमारे प्रोफेसर ने कहा कि यहाँ एक सिस्टम है कि आप, वहीं बर्मिंघम में था मैं, तो वो सिटी में ही, क्योंकि यूनिवर्सिटी थी तो हार्डली वॉकिंग डिस्टेंस था, वहाँ ऑफिस में जाकर के आप एक कंप्लेंट दायर कर दीजिए, 10 पाउंड आपको देने होंगे, और खाली सिंपल आप कंप्लेंट फाइल कीजिए एंड यू विल, द कंप्लेंट विल बी रिड्रेस्ड. आई नीड नॉट टू गो टू द कोर्ट. मैंने जाके कंप्लेंट फाइल की, 10 पाउंड जमा किए. नेक्स्ट डे एजेंट ने आकर के मुझे 400 पाउंड में टिकट दिया, और 10 पाउंड मुझे वापस उस एजेंट ने किए नेक्स्ट डे विदिन 24 hours. That type of the system for the petty cases we need. अगर हमें वो सिस्टम इवॉल्व हम करें, वो सिस्टम मैं नहीं समझ पा रहा हूँ कि अभी इन 3 लॉज से जनता को मिलने वाला है.
समरी ट्रायल में 20,000 तक के जो है वो मैंडेटरी कर दिया. पहले मजिस्ट्रेट की पावर थी मर्जी, अब इट इज मैंडेटरी, वो समरी ट्रायल होगा अगर 20,000 तक का उसमें आए.
अगेन आदमी को तो कोर्ट भी जाना पड़ेगा ना.
हाँ, जाना तो कोर्ट में पड़ेगा.
हाँ, कोर्ट भी जाना पड़ेगा ना. तो कोर्ट में जाने के लिए आप समझते हैं हाउ मेनी ऑफ यू आर रेडी टू गो टू द कोर्ट?
सभी रेडी हैं सर.
नहीं, ये तो जाने के लिए तैयार है, लेकिन आप पब्लिक से अगर आप पूछें, आप अगर मेरे आदमी से पूछे, किसी और से पूछे, मुझे मान लीजिए कोर्ट में जाना पड़ा, 3 डेट्स पे जाना पड़ गया, 3 मुझे लीव विदाउट पे लेनी पड़ गई, तो मेरा कितना मनी हो गया? तो these things are still lacking in the system. एक दूसरी चीज मैं कहना चाहता हूं कि जो आपका एविडेंस लॉ है, अभी भी एविडेंस लॉ के अंदर साइंटिफिक इन्वेस्टिगेशन, डिजिटल लॉ तो हम ले आए हैं, लेकिन डिजिटल लॉ के साथ साथ साइंटिफिक इन्वेस्टिगेशन बहुत सारी चीजें छूटी हुई हैं जो इसके अंदर होनी चाहिए थी. डीएनए फिंगरप्रिंटिंग है, माइक्रोबायोम नहीं है, बहुत सारी चीजें हैं. ब्लड की जो आपकी फॉर्मेशन है, ब्लड के अंदर जो ब्लड की रेड सेल्स हैं, सेल्स की जो फॉर्मेशन है, उसकी जो फिजियोलॉजी नहीं, मॉर्फोलॉजिकल सेल्स है, दे आर ऑल्सो प्लेइंग ए वेरी इंपॉर्टेंट रोल इन द आइडेंटिटी ऑफ द क्रिमिनल. So the many of the scientific things still they are lacking, which need to be enacted, which need to be incorporated in this law for the fast, not only the fast, but the right justice delivery system. I have been asked to reduce some of the views and to reserve these for the valedictory session. So in the valedictory session, you all will be here. So I will address these issues, but at the same time, I would like to say that these laws are very good. For example, many of you might have read these laws, but those who are in the 4th year or 5th year, they might not have read. So for them, I would like to suggest to the law department that they should have some bridge course or some value-added course or some additional course, so that the students who are going to pass out, they can also study these 3 laws, one very thing. And those who have already passed out, for them also some value-added courses should be started, so that the pupil or the students of law can be educated about these laws. The another very challenging is That is, the students of the law of the Subharti University should take a place today that they will educate the public about these laws. Without educating the public about these laws, they cannot be implemented. So these are some of the issues, some of the challenges which the society, with the lawyers, with the professors, with the universities, institutions, they should come together and they should work together to implement these laws faithfully, sincerely and honestly for the justice delivery system, because the law is made for the good governance, and the good governance will make a civilized society. So to bring this civilized society, I wish all the success for the students of law of the Subharti University, for the faculty members and for the public to come forward. Thank you very much for giving me opportunity, and see you in the valedictory session.
Thank you so much, sir, for gracing us with your words of wisdom. Now we request Honorable Vice Chancellor, Major General Dr. G.K. Thapliyal, sir. Sir has over 40 years of experience in armed forces and higher education. We welcome you, sir.
Sorry for cutting you short for my introduction. And good afternoon, everybody. Learned minds sitting on the dais, and our honorable guest, Professor Jacob, Professor Remand, Professor Assad Malik, Madam Bageshwar, Professor Remand, and our Dean, Faculty of Law, Professor Bageshwar, our distinguished faculty member, and all the my dear students sitting here. See, we heard about the different view about these laws. I am not a person who actually knows and who will tell about these laws, what are the challenges are there, how these laws are acted, why, what was the reason. I will only take you somewhere in the history and back into the history. History means why these laws, means what is the connection between the laws and human beings. How the laws were made, what was the reason for making laws. So if you go back into the evolution of the mankind, you will find that we have gone to the different ages. Different ages means first you know the Bronze Age, then you know the Iron Age. Then after the Iron Age, we start our agricultural revolutions. Then comes the industrial revolutions. Then comes the technology or evolutions. Then came the digital evolutions. Now we are going through a new age that is called artificial intelligence and data science and quantum computing age. So it is similarly as we have evolved during these millions years. The first thing started probably when we started cultivating crops, that we started making villages, we started making societies. So there was a requirement that what is the morality and what is the ethics. So I think the morality and ethics were the first laws, which was made by then maybe the person who was the powerful in that particular locality. He made those moralities and those ethics. Then we come ahead now, the ancient Vedic period. When we look into the Vedic period, how the human lived together in that society and what kind of laws were there. So human societies in the Vedic period and post-Vedic period was governed by Dharma Shastra. Dharma Shastra means anything written there in the Dharma Shastra means what are your dharma, means what are your duties. Your duties towards your society, your duties towards your group, your duties towards your father, your duties towards your anything, that relationship, that is called Dharma Shastra. And everything was dependent, whatever written in the Dharma Shastra, that we were following that. Then we come to the age of Chanakya, that is the Chandragupta period, Maurya period. The first document we find written by Kautilya, that Arthashastra. And if you see the Arthashastra, it is not only related with economics or politics, it is related with the Danda Shastra. It's mentioned clearly in that document, and that is first revealed by Megasthenes. If you have heard the name of Megasthenes, who was the traveler, came to India during Maurya kingdom. He wrote in detail about what kind of a legal system prevailed during Maurya period. It was a very well-defined system, that if you commit this kind of a offense, there will be a death set of rules, and this kind of a punishment, the danda, will be given to you. So it was well-defined. After that, we enter to the another era, that is the Gupta period, which is the golden period of India. And Gupta period, if you see, all these rules and regulations were made based on the requirement. Why I am talking to you all about this? Because everything evolved as we evolved. Even our legal system also evolved. So means there is always a requirement of change. We cannot evolve without making changes. So that change is the must. So that's why after that, then we enter into era of Mughal. What happened during Mughal time? Mughal, because they were from outside, they brought their own legal system with them. But best thing, what did they do? They combined their own legal system with the Indian system prevailing that time and made a law according to the combined, that is Islamic, Hindu or local. Am I right, sir? So these were the system they adopted during a Mughal period. After that Mughal period, when the Mughal period or Mughal dynasty vanished, then came the period of our colonization. And this was the worst period of our history. During this period, they realized, the Britishers, our ruler, they realized if we follow their rules, what they have framed, we will not be able to govern them. We will not be able to rule them. So they made their own rules to govern us. And एक शब्द यदि आपको याद होगा उसमें है कि देश राजद्रोह, एक word है. Means anything which you are doing against the Raj kingdom or the government, it's called Rajdroha. Now that Rajdroha word has been replaced by Deshdroha. It's a good terminology. Means earlier they used the word Rajdroha, means anybody who is acting against the ruler, that he will be put under that Rajdroha. But now that word has been replaced by Deshdroha, Rashtradroha. So means anything you are doing against the present government, it will not be considered as an offense. But anything which you are doing against the country, that will be taken as an offense. So that's the change. So these are the systems. Abhi now, Madam touched upon the India and Bharat. Everything is written in the present law, संविधा, जितनी भी संहिता उसमें भारत वर्ड का इस्तेमाल हुआ है. आप सोचिए कि why there was a requirement of removing this word India and emphasizing on this word Bharat, whereas our constitution says India, that is Bharat. For constitution purpose, we are same, whether we call it India or we call it Bharat. There is no difference, but there is a tremendous difference. When we call Bharat, we connect ourselves with the oldest civilization which we had. When we say India, that colonial mindset, we get along with that India. So it's a requirement that we should follow. We should be proud of calling ourselves Bharat and we are Bharatiya. Not necessary that we use that English translation India. Similarly, one of the series of lecture, I touched upon one area that was Advocate Jacob knows that. When we translated in our while making constitution, we translated word religion as dharma. In my opinion, I don't know how many of you agree with me, it should not have been translated, religion should not have been translated as the dharma. Religion means it's a sect where you follow a particular book, or you follow a particular master, or you follow a particular what you call Pagambar. But in the dharma, there is nothing like you don't follow anything. It's your right. Your right towards your country, rights towards your people, rights towards your fellow being, and rights towards your even environment, to the planet Earth. That is also mentioned in the dharma. So dharma should not have been translated. It should have been taken as a word dharma. Am I right, sir? So that is changes, probably it may happen, not today. It may happen after some time. That religion word will be removed. It will, in place of religion, we call it dharma. And dharma will be our dharma, means manav dharma. What is our, it's nothing like any religion. Nothing based with the Hindu philosophy or any Jain or Buddhism philosophy. It's a dharma of a human being. And dharma of human being is to sustain life on this planet Earth in harmony with the planet Earth. So that is one. Also you remember that, or you know that India is the oldest civilization, and yet a very surviving civilization. But how many Western or European country say, or books say, that India is the oldest civilization? None. They say India's civilization starts only after Harappan civilization. That's a Harappan civilization. Because there are evidences about Harappan. But if you read now, there are so many things coming up. Even 13,000 years ago, our civilization was there. So there will be changes as we keep on inventing and keep on getting evidences, and especially when we use technology, which the way technology is advancing, even our that narrative that India is not the oldest civilization, Sumerian is the oldest civilization, Greek is the oldest civilization, or Chinese Shang is the oldest civilization. India is only 100,500-year-old civilization. That also will be changed in due course of time when we have evidences saying that 13,000 years ago, when we say we connect ourselves with the Ram, or we connect ourselves with the Pandavas, or we connect ourselves with the Mahabharata. So probably we will have, because they call, that Western call all of these stories as a mythology. Ramayana, Ramcharitmanas, they say it's the mythology. Ramayana is a Ram, life of Ram is a mythology. Life of Krishna is a mythology because we don't have evidences. History, whatever history is written based on evidences. And evidences are whether you have a written evidences, you have some kind of an artifact of that time, then based on that evidences you say that is my history. But in the due course of time, the technology is advanced. So as the technology is advancing, in the beginning I said we are entering into the era of artificial intelligence or quantum computing. Probably we will also need to change our legal system or our articles and other things in the constitutions. So you should be ready, and all young mind, you should be always innovative. You should always find and write and express your views, express your opinion, what should be done, what is right. And these opinions nowadays in the era of this technology is known to everyone. Anybody can catch your idea and work on that. So thank you very much for patient listening. Jai Hind.
Thank you so much, sir, for sharing your immense knowledge. Now it is the time to felicitate our esteemed speaker of the day. For this purpose, I would like to request Honorable Vice Chancellor, sir, along with all other dignitaries, to kindly come forward for the felicitation ceremony.
Jai Hind, one and all. Honorable Vice Chancellor, sir. Respected Director Research Applied Sciences, our own Saju Jacob, sir. Respected Bageshwar madam. Respected Assad Malik, sir. And my dear friends. Today we are here to talk on issues and challenges in the implementation of new criminal laws. With the help of the different speakers, we came to know that the change in new criminal laws, it was the requirement of the time because our old laws were too old because of different reasons. Since Bageshwar madam has to go, it was a time that we have promised that we will get her free by 12:30. So in my concluding remark, I would like to simply say a couple of things. I would like to share a few things with all of you. कुछ बच्चों ने नोट्स लिए, मेजॉरिटी के बच्चों ने नोट्स नहीं लिए. जब हम आपके जितने थे स्टूडेंट लाइफ में थे, हमारे पास ऐसी अपॉर्चुनिटी नहीं हुआ करती थी. सेमिनार नेशनल इंटरनेशनल वो डे ड्रीम हुआ करता था. साल 2 साल में कभी एक की इन्फॉर्मेशन आती थी, वहाँ पर भी जा पाना मुमकिन नहीं होता था. आप लोग लकी एनफ है कि यहाँ जो रिसोर्स पर्सन बैठे हैं पूरे इंडिया के अंदर इन क्रिमिनल लॉज के ऊपर अगर ये अवेयरनेस को फैलाया है, तो वहाँ पर बागेश्वरी मैडम और असद मलिक साहब ने पूरे इंडिया के डिफरेंट कॉर्नर्स के अंदर जाकर, आप बहुत लकी हैं कि वो आप उनको यहाँ सुन पाए हैं. जिन्होंने कैजुअल अप्रोच में बैठे रहे, उन्होंने बहुत कुछ मिस कर दिया. सो आई एम नॉट गिविंग कंक्लूडेड रिमार्क, बट यस, सो फॉर द वोट ऑफ थैंक्स एज यूजुअल आई एम शॉर्ट ऑफ वर्ड्स एंड मोर स्पेसिफिकली आज की बात करूं तो वागेश्वरी मैडम का गवर्नमेंट ऑफ इंडिया का कुछ ऐसा असाइनमेंट था जिसको वो छुट्टी पर रह ही नहीं सकती थी. उन्होंने किसी तरीके से मैनेज किया कि प्री लंच वो यहाँ रहेंगी और पोस्ट लंच वो वहाँ रहेंगी, और वो अपने बिजी स्केड्यूल से वो यहाँ पर आई. मैडम, आई एम थैंकफुल टू यू एंड आई विल कीप ऑन डिस्टर्बिंग यू ऑफनली फॉर द पर्पस ऑफ एकेडमिक इंटरेक्शन. एंड इवन लाइकवाइज असद मलिक जी, कुछ इन्विटेशंस थे, उन इन्विटेशन से अलग उनके खुद के कॉलेज के अंदर उनका अपना इवेंट था. उनके यहाँ मूड कोर्ट चल रहा है और उनको मूड कोर्ट के अंदर वहाँ रहना था. मैंने कहा सर आपने पहले प्रॉमिस किया है. जिस दिन मुझे प्रॉमिस किया उससे पहले उनके यहाँ वो एक्टिविटी प्लान हो चुकी थी, लेकिन मुझे प्रॉमिस करते हुए उनके माइंड में वो नहीं था. तो उन्होंने अपने वादे को निभाते हुए आप लोगों से इंटरेक्शन करने के लिए वो यहाँ पर आए. आई एम थैंकफुल टू यू सर. एडवोकेट साजू जैकब जी, he is an advocate in UK and India, Supreme Court of India, and he came back from Germany Saturday only. And वहाँ के फ्लाइट जेट को रिमूव करके आप यहाँ पर ऑन टाइम आप आए. I have no words. I am really thankful to you. हमारे डायरेक्टर रिसर्च, he is a very good orator and believe to interact on each and every topic and each and every subject. So I am thankful to you that you have accepted my invitation. हमारे वीसी सर, जब मैंने उनसे कहा कि सर मुझे एक्टिविटी करानी है और ये टॉपिक की बात हुई, तो उन्होंने जिस तरीके से हमें सपोर्ट किया. आज वीसी सर का मॉर्निंग में एक जर्मन डेलीगेट के साथ मीटिंग था. उस मीटिंग को सर ने जो 10 बजे के बाद था उसे प्रीपोन किया. हमारा टाइम जो था सर, उस टाइम पर हमारे पास रहे. एक दूसरा इवेंट दूसरे कॉलेज के अंदर था, वहाँ इनॉग्रल होना था. उस इनॉग्रल के अंदर भी वहाँ पर इनॉग्रल करके हमारे को जितना समय सर ने दिया और हमारे हर प्रोग्राम को जिस तरीके से वीसी सर आशीर्वाद देते हैं, मैं चाहूँगा जोरदार तालियां हमारे सभी अतिथियों के लिए. सेमिनार में गलतियां जरूर रहती हैं, कोई भी कार्यक्रम हो उसमें गलती ज़रूर होती है. गलतियां सारी मेरी तरफ से रही होंगी. यहाँ के जितने भी फैकल्टी मेंबर्स हैं, उनका एक यूनाइटेड एफर्ट जिसके कारण आज हम इस एक्टिविटी को करा पाए. तो तालियां हमारे फैकल्टी मेंबर्स के लिए. जिन बच्चों ने बड़े दिमाग से सुना, इंटरेक्ट किया, उनके लिए तालियां. और जिन्होंने नहीं सुना वो पढ़ेंगे, और पढ़ने के बाद में अगला सेमिनार प्रेम सर ने कहा है दोबारा कराएंगे इसी टॉपिक के ऊपर, और उसमें वो कंट्रीब्यूशन देंगे. इस चीज के लिए उन सब के लिए जोरदार तालियां. I am taking these clappings as an evidence that you will contribute in coming seminar. And last but not the least, हमारे फाउंडर्स जो हमारे साथ लगे रहते हैं, जिन्होंने अपॉर्चुनिटी दी यहाँ पर हमें सर्व करने की और आपको यहाँ पर लर्न करने की. हमारा नॉन टीचिंग स्टाफ जो पर्दे के पीछे रहकर 24/7, मुझे मालूम है कल रॉबिन छुट्टी पर थे, लेकिन उसके बावजूद भी वो यहाँ पर आए. यहाँ पर फैकल्टी मेंबर्स जिन्होंने डे एंड नाइट वर्क किया, कुछ यहाँ का नॉन टीचिंग स्टाफ जो डे एंड नाइट वर्क कर रहा है, जो कभी फ्रंट पर नहीं आ पाते. तो उन सभी के लिए और ज्ञात अज्ञात सभी शक्तियों के लिए एक बार जोरदार तालियां और सभी को नमन, सभी को धन्यवाद. जय हिंद, जय भारत, जय सुभारती. मैं कहूँगा एना मैडम से यहाँ पर आ जाएं. 5 मिनट का इंटरवल होगा, बच्चे अपनी किट्स ले लेंगे और उसके बाद फर्स्ट सेशन को आप यहाँ पर स्टार्ट कराएं. अतिथियों से निवेदन कि वो मेरे कॉलेज की तरफ, मेरे ऑफिस की तरफ चले. छात्र यहाँ पर अभी बैठे रहेंगे जब तक अतिथि अपना कक्ष छोड़ते हैं. जय हिंद, जय भारत, जय सुभारती.
Jai Hind everyone. My name is Yuvraj Singh, student of BLLB first year at Sardar Patel Subharti Institute of Law, Swami Vivekanand Subharti University, and I am the moderator of Technical Session 1. I wholeheartedly welcome our respected chair and co-chair of this session. The session is chaired by Mrs. Afrin Almas Ma'am, Assistant Professor at Faculty of Law, and co-chaired by Dr. Ajay Raj Singh Sir, Assistant Professor at Faculty of Law. The theme of the technical session 1 is Bharatiya Nyaya Sanhita, and every speaker will be given 5 minutes max to present their paper. I request all the speakers to kindly adhere to time limit. In the sequence, I would like to invite Ankita on the topic of evolution of Indian Penal Code to Bharatiya Nyaya Sanhita, progressive steps in criminal justice reform.
Jai Hind everyone. My name is Kajal Kumari, student of BLLB 5th year. It is pleasure to be here to present my paper on the topic Significant Reformative Approach in Criminal Justice, the concept of community service as a punishment under BNS 2023. The Bharatiya Nyaya Sanhita 2023, India's new criminal code, introduces a significant change in community service as a punishment in the regime of criminal punishments. Community service punishment is a legal reformative form of punishment in which convicts of certain offences are made to perform such service which is unpaid. The criminal justice administration in India is a dynamic mechanism in the society, and the interpretation of law is an essential part of it. The basis of approach behind the progressive step is the variety of crimes and offenders with their different minds. Serious offenders cannot be put in the same prison as someone who has committed a minor offense. The purpose is to prevent future harm and restore justice. Community service is a form of punishment that involves requiring an offender to perform unpaid work in the community. It is often considered as a more rehabilitative alternative to traditional imprisonment, aiming to address the underlying causes of criminal behavior and contribute to social well-being. However, community as a concept is included in the auspicious land. They represent a shift toward restorative justice, emphasizing rehabilitation and reintegration of offenders into society rather than purely punitive measures. Community service is a non-custodial restorative justice approach aiming to reintegrate offenders into society.
Now I would like to invite Ankita on the topic of evolution of Indian Penal Code to Bharatiya Nyaya Sanhita, progressive steps in criminal justice reform.
Jai Hind everyone. It is a privilege to stand before you today to speak on a topic of immense importance and relevance to our legal landscape, evolution of Indian Penal Code to Bharatiya Nyaya Sanhita, progressive step in criminal justice reform. As we gather here, let us step in criminal justice reform, reflect on how far we have come in shaping a criminal justice system that aligns with the value and need for our society. The Indian Penal Code (IPC), introduced in 1860, served as India's foundation for criminal law. Crafted during British colonial rule, it was a comprehensive attempt to define criminal offences and their punishment. While it provided a structure that kept society in check, we have to acknowledge that it was a product of a different era and cultural context. Its roots lie in colonial principles designed to serve colonial interests. Over time, as society evolved, so did the need for a more people-centric and culturally resonant legal framework. Key progressive changes. In this journey from IPC to Bharatiya Nyaya Sanhita, we observe some pivotal shifts that reflect our society progress and growing understanding justice. Victim-centric approach. In new framework, greater emphasis is placed on the right of victims. For a long time, criminal justice focused largely on punishing offender. Now it emphasizes on victim rights, compensation, and many more. Gender sensitivity. Enhanced protection for women and marginalized gender with modern safeguards against gender-biased violence. Technological adaptation. Updated provision to address cybercrime and digital offences align justice with today's tech landscape, reflecting India's value. Finally, the Bharatiya Nyaya Sanhita is not just a law, it's about grounding our criminal justice system in values that truly represent our culture. It emphasizes fairness and social harmony, moving away from the colonial mindset of control and punishment to a framework that reflects the ideals of democratic India. Why does evolution matter? This move from IPC to BNS is the testament to our country's resilience and adaptability. It's a deep step toward creating a justice system that is not just India in name but in spirit. The change acknowledges the importance of a legal system that grows with society, embraces inclusivity, and promotes fairness for all. In conclusion, this journey is not just about legal reform, but about nation building. By embracing Bharatiya Nyaya Sanhita, we embrace an era where justice is swift, fair, and resonate with the heart of India. This transformation symbolizes hope, resilience, and a contaminate to a system that serves, protect, and unite its people. Thank you for all being a part of this seminar and for your dedication towards justice. Jai Hind, Jai Bharat.
Now I would love to call Ayush Anand on the topic of evaluating the efficacy of restorative justice legislation in India in new criminal laws, a legislative innovation towards restorative justice.
Jai Hind to one and all present here. My name is Ayush Anand, student of BA LLB, 7th semester at Sardar Patel Subharti Institute of Law. Today I am going to present my research title paper, Evaluating the Efficacy of Restorative Justice Legislation in India in New Criminal Law, a legislative innovation towards restorative justice. This research paper evaluates the efficacy of restorative justice legislation within the context of India's new criminal law, highlighting it as a significant legislative innovation aimed at transforming the criminal justice landscape. Restorative justice prioritizes repairing harm and fostering dialogue between victims, offenders, and the community, contrasting sharply with traditional punitive approaches. The study examines recent legislative reforms that incorporate restorative principle, analyzing their potential to enhance victim support, reduce recidivism, and promote community engagement. By utilizing qualitative and quantitative research methods, including interviews and case analysis, this paper investigates the practical implementation of these restorative practices across various regions in India. Findings reveal both opportunities and challenges in realizing the full potential of restorative justice. While many stakeholders expressed optimism about its benefit, issues such as insufficient training for facilitator, public misconceptions, and inadequate resource allocation hinder effective application. Moving forward, Warren Burger, former Chief Justice of US Supreme Court, to put people behind walls or bars and do little or nothing to change them is to win a battle but to lose a war. It's wrong, it's stupid, it's expensive. Restorative justice is an emerging paradigm in the field of criminal law that shifts the focus from punitive measures to repairing harm, restoring relationships, and fostering accountability through dialogue between victims, offenders, and the community. In India, a country with a rich and diverse legal system, the application of restorative justice has gained significant attention in the recent years as a potential alternative to the traditional retributive justice models. The adoption of restorative practices in India's criminal justice framework is being increasingly recognized as a means to address not only the emotional and social repercussions of crime but also the underlying causes that lead to criminal behavior. Moving forward, key changes in the Bharatiya Nyaya Sanhita 2023 regarding restorative justice. Inclusion of restorative justice principle in the legal framework. Section of restorative justice, the BNS 2023 introduces provisions that formalizes the use of restorative justice within the criminal justice process. While restorative justice was previously applied on a case-by-case basis in India through various pilot programs and voluntary mechanisms, the BNS 2023 establishes a more structured framework for its use, especially in cases involving lesser offenses, juveniles, and first-time offenders. Section 5 of the BNS 2023 explicitly recognizes restorative justice as an alternative to the punitive action, allowing for measures that focus on repairing harm, engaging victims and offenders in dialogue, and facilitating reconciliation.
Jai Hind to all. I am Janayal Maur, BLLB third year. I am going to present on the topic of community service under Bharatiya Nyaya Sanhita BNS 2023. The Bharatiya Nyaya Sanhita BNS 2023 marks a significant shift in India's criminal justice system, replacing the colonial era Indian Penal Code (IPC). This new code is part of a broader effort to modernize and reform the justice system, focusing on efficiency, transparency, and rehabilitation. One of the central goals of BNS is to address the growing concern about prison overcrowding and to promote alternatives to incarceration for minor and non-violent crimes by incorporation restorative justice principle. BNS aims to focus on rehabilitation over punitive measures, thus providing a more progressive approach to dealing with offenders. A key reform introduced by BNS 2023 is community service as an alternative to imprisonment. This initiative reflects a shift towards a more rehabilitation and socially constructive justice system. Community service officers offenders the opportunity to atone for their actions through position societal contribution, while avoiding the damaging effects of incarceration, such as social isolation and stigmatization. This reform is particular first-time offenders, allowing them to reintegrate into society while reducing the strain on the prison system. Legal frameworks for community service. The BNS 2023 introduced community service under Section 4 Clause F, which mandates this form of punishment for first time non-violent offenders. This provision is designed to encourage restorative justice, allowing offenders to make meaningful contribution to society rather than serving time in jail. The community service mandate seeks to address the underlying causes of criminal behavior while promoting personal responsibility and rehabilitation. Eligible offences. Community service is applicable for a range of minor offences under BNS, including petty, theft, public misconduct, defamation, and unlawful trading by public servant. Judicial discretion. A key feature of the BNS framework is the role of judicial discretion. Magistrates are empowered to decide when community service is an appropriate alternative to imprisonment based on the nature of the offences and offenders' background. By focusing on rehabilitation through community service, Bharatiya Nyaya Sanhita 2023 respects and moves towards a more human and constructive criminal justice system, one that seeks to balance punishment with opportunities.
Please conclude. And if you have any suggestions, specifically highlight.
Community service under BNS 2023 represent a balanced approach to criminal justice by providing an alternative to imprisonment that emphasizes rehabilitation. It allows offenders to contribute to society in meaningful ways while avoiding the negative consequences of incarceration. The approach addresses both the need for punishment and the opportunity for personal growth, aligning with the broader goal of restorative justice. Future reforms. To improve the effectiveness of community service, several reforms could be implemented. These include better supervision and enforcement mechanisms such as electronic tracking system and regular monitoring by probation officers. Jai Hind.
Now I would like to invite Kausar Jahan on the topic of crime-themed content on OTT platform and its impact on society.
Jai Hind everyone. I am Kausar Jahan, research scholar. My topic is crime-themed content on OTT platform and its impact on society in India. Access to a broad variety of material such as violent films, TV series and graphic material is made possible OTT platform. This might lead to viewers being less sensitive and aggressive conduct and normalize criminal activity. Studies indicate a connection between media violence exposed and aggressive conduct, especially in susceptible group like young adults. The way that violence and criminal are portrayed in the media can show people's understanding to ethic and social norms, which can encourage conduct the sexual offense, establish boundaries for the amount of time spent on OTT platform, prevent excess screen time and promote healthy balance with other activities. It's important to be mindful of the time spent watching content and strict balance between our digital lives and our physical and psychosocial well-being. The present age is considered to be the digital age. The media covers and acceptance is one rise, especially in the last 2-3 years, which have been seen the increase in the number of viewers on OTT platform. The availability of various media device can set be important reason for the growth on OTT platform. During the lockdown, people preferred on OTT platform for liking in the maintain. People for also reported to spend time OTT platform. It is easier to adopt technology there, so young people are inclined towards OTT platform.
Sir, do you have certain suggestion on the topic? Any suggestion? Or you may conclude. Conclude कर दीजिएगा.
The important to promoting media literacy among young people, educating people about the potential impact of media, their attitudes and behaviors can help make more informed choice about the content they consume. Overall, the study call for increased awareness tendency of the potential impact in content available on OTT platform youth viral. By promoting media literacy and critical evaluation of content, we can help young people make more informed choice and mitigate any potential negative impact on their attitude and behaviors. Thank you.
Next on the list.
Now, I would like to invite Rakesh Kumar Baroi on the topic of a critical analysis of crimes targeting refugee women and children.
Good afternoon, respected guys and teachers and dear my friends. Today's my topic is critical analysis of crime targeting the refugee women and children. A plight of women and children who are forced to flee their homes and qualifies as one of the most critical and widespread human rights violation today. Such group experience a particular descriptive and interplay of risk, both refugee through their overlapping identities, which frequently highlights their exposure of violence and abuse of discrimination. This present study is examining the crime against refugee women and children from a legal standpoint, exploring the international human rights law and family legal studies and the realities of women and children refugees face. From the feminist viewpoint, the age and gender and often displacement are the factors of contribute to the additional burden to the that refugee women and children bear, the proving the situation of power and immorality that enhance their plight. The research begins with the orientation of scope of the studies and the more particularly the sociological interpretation and law, in which examine the violence and abuse based on the policies and structural levels of refugee women and children. In particular, the risk of the populations under the include the human trafficking, sexual, gender bias, and other forms of risk that thoroughly analyze. It is briefly explain the various international human rights legal instruments that exist to promote and best interests of refugees, access those the instruments and regarding their relevance refugees, women and children's protection. Thank you. Jai Hind, Jai Bharat.
Now, I would like to invite Arif Mohammed on the topic of mental health challenges in the criminal justice system, legal and human rights implications.
Respected Chair, dear faculty members, my fellow friends, myself Muhammad Arif, research scholar at Sardar Subharti Institute of Law. The title of my research paper is Mental Health Challenges in the Criminal Justice System, Legal and Human Rights Implications. So starting with the intersections of mental health and criminal justice, it comprises a significant role in the legal and human rights implications. My paper explores the margin of mental health issues as confined in the realm of in the criminal justice system, arguing the mental disorder that are untreated result in the high rates of incarceration, lengthened sentences and stigmatizations. My paper will assess the challenges, great implications to individuals and communities, especially in societies where mental health services do not exist and are so insufficient. This analysis of international human rights contract displays the legal standard and obligation that supports human approaches towards those who are with the mental illness, emphasizing compliance in the criminal justice system. So I have some suggestions and challenges which is directly related to my topic. So some challenges under the criminal justice system with respect to the mental illness and human right, that is the lack of sensitivity, lack of knowledge, lack of forensic psychotropic psychiatric services, lack of background informations and lack of clear guidelines. So these are the some challenges which are under the new criminal laws with respect to my topic, that is mental health. And the suggestion that I have to give only two is that the first suggestion, ban on the use of unmodified electroconvulsive therapy, that is ECT, and the second suggestion is that create a comprehensive data privacy and security framework for the mental health patients. Thank you so much. Jai Hind, Jai Bharat.
Now, I would like to invite George Celestian on the topic of community service under BNS on comparative study with Tanzania.
Jai Hind everyone. My name is George Celestian. I am from Tanzania. Today I am going to present this paper by the heading says Community Services under BNS of cooperative study with law in Tanzania by starting what is community development services. These are the services or activities that are done in the society without payment. And there are some examples of the community services like helping people, sick people, helping the orphans, helping the old people, doing cleanness of the cities, and planting some trees. That is community development services. And according to religions, every religion have insist their followers they should conduct their community services. For example, by starting with the Christians, by using the Bible, all Christians are instructed to conduct their community services. For example, the Christians are also supposed to help the poor people, also orphans as well. And also Muslims in the Quran says that God loves people who do good things. So when the Muslim do good things to the poor children, do anything in community services, that will make them to be loved by God. And also furthermore, I'm going to talk about the Hindus. Hindus here we're going to talk about karma. When you do good things to someone, that person will get a good thing later on. So people are supposed to do community services also. And also Buddhists, in Buddhist we are going to talk about karuna. Karuna means mercy. So when the Buddhists do good things to people or they engage in community services, they can get good things at the later on, so as they can improve our society as well. And also I'm going to talk about BNS. BNS, the long form of BNS is Bharatiya Nyaya Santiha. This involves the laws that can be found in IPC, Indian Penal Code of 1860. And in this BNS, there are some changes and there are sections that they talk about the community services. For example, in the section 202, public servant unlawful engaging in trade. The public servant are not allowed to engage in trade. Wherever they engage in trade, they can be imprisoned for 1 year and also fined, and also they are supposed to be engaging in community services. Also in section 209, non-appearance in response at a proclamation under section 84 of BNS 2023, people are supposed to be there at the right time and at the right place. Whenever he or she is right, he will get a fine of being imprisoned for 3 years and also fined, and he or she can engage in the community services. And also section 226, attempt to commit suicide to a compel or restrain exercise of lawful. People are not supposed to commit suicide. Whenever a person commits suicide, he or she can get a punishment for being imprisoned and also be imprisoned for 1 year, and also he or she will remove fine and will engage in community services. And section 303, it talks about theft. When a person steals, he or she is supposed to be imprisoned and also remove fine and also engage in community services. And also section 355, misconduct in public by drunk person. Drunk person also, they are supposed to be imprisoned and also they are supposed to remove fine and engage in community services. And lastly, section 356, the defamation. About defamation, the one who conducts defamation, he or she will be imprisoned and also remove fine and also will engage in community development. And I'm going to talk about similarities of Indian and Tanzanian law. This is because Tanzania and Indian, they are the same law. It is also because we are colonized by the British. So the laws that are found in Tanzania and the laws that are found in India are the same. So the both punishments in India and the both punishments are found in Tanzania are the same because we are both colonized by the British and we are using one law. And lastly, I'm going to talk about my suggestion. My suggestion is that the court and the government should also make changes in the law so as the laws should fit and should be relevant to the society. And those criminals and the wrongdoers, they're supposed to be engaged in community development so as community development services so as they can develop our society and have good future society. Thank you. Shukriya.
Now, I would like to invite Kasak on the topic of reforming criminalization examining new offences and chances in punishment under BNS.
Jai Hind everyone, my name is Kasak Sirori and the title of my research paper is Reforming Criminalization. The Bharatiya Nyaya Sanhita BNS 2023 represents a transformative shift in India's criminal justice framework, replacing the Indian Penal Code IPC of 1860, aiming to modernize laws, introduce new offences and update sentencing frameworks. The BNS criminalizes previously unaddressed offences such as mob lynching and various forms of cybercrime, along with enhanced provisions for gender-based violence and terrorism. It aims to protect marginalized groups and strengthen national security, recognizing the unique nature of offences like mob lynching and digital harassment. The Act takes a progressive stance on sentencing, limiting capital punishment to extreme cases and favouring life imprisonment for other serious offences. It introduces minimum sentences for severe crimes to ensure consistency and advocates for alternative sentencing, such as community service and probation for minor offences. These changes reflect a rehabilitative approach aimed at reducing recidivism. The Act is expected to streamline case processing by reducing ambiguities, enhancing deterrence, and fostering public trust in the legal system. Its rehabilitative approach to minor offenders could reduce prison overcrowding and improve social reintegration, fostering long-term reductions in repeat offences. In conclusion, the BNS marks a vital step toward a modernized and humane justice system. With its focus on new offences, updated sentencing, and rehabilitative justice, it aligns with global standards and addresses India's contemporary needs. However, its success depends on consistent application, resource allocation, and a commitment to ongoing reform. That's all. Thank you.
Now, I would like to invite Kesar Ahlawat on the topic of the evolution of Indian criminal law.
Jai Hind everyone, my name is Kesar Ahlawat. The title of my paper is The Evolution of a Criminal Law, a Comparative Study of Bharatiya Nyaya Sanhita and Indian Penal Code. The Bharatiya Nyaya Sanhita is a part of a comprehensive legal overhaul aimed at replacing India's colonial era criminal laws with a modern indigenous framework. Introduced in 2023, the BNS is supposed to replace the Indian Penal Code of 1860, which was established during British rule. This paper explores philosophical underpinnings and potential impacts of the Bharatiya Nyaya Sanhita of India on India's criminal justice system, a comparative analysis between the IPC and the BNS. The Indian Penal Code, drafted by the Lord Macaulay in 1860, has governed India's criminal law for over 160 years. While several amendments have been made, the foundational principles remain unchanged, leading to a disconnect between the law and the evolving socio-political landscape. Several issues, including delays in delivering justice, the colonial focus on punishment over rehabilitation, and a lack of sensitivity towards victims, necessitated the revision of the existing framework. The Bharatiya Nyaya Sanhita aims to address these concerns by ensuring a more transparent, efficient, and citizen-centric legal system. The bill is a part of broader legal reform package, including the Bharatiya Nagrik Suraksha Sanhita replacing CRPC and the Bharatiya Sakshya Bill replacing the Indian Evidence Act, all geared towards aligning the criminal justice system with India's contemporary needs. Main highlights of Bharatiya Nyaya Sanhita: victim-centric approach, focusing on the rights of victims, providing better avenues for their protection and compensation, speedy justice, reducing delays in criminal proceedings by incorporating timelines for various judicial processes, strengthening public safety, ensuring that the law is equipped to deal with modern-day crimes including terrorism, cybercrime, and crimes against women. The BNS makes a vital step towards a modernized and human justice system with its focus on new offences, updated sentence, and rehabilitative justice. It aligns with global standard and addresses India's contemporary needs. Thank you.
Now, I would like to invite Pavni Arora on the topic of transition from Indian Penal Code to BNS.
Jai Hind to all, respected judges on the dais, and one and all present over here. This side Pavni, a second year law student from Sardar Patel Subharti Institute of Law. The title of my paper is Transition from IPC to BNS, a Legal Societal Transformation. Basically, the IPC drafted by starting with a brief introduction, the IPC drafted by the Lord Macaulay in the 1860 has governed Indian criminal law for over 160 years. While several amendments have been made, the foundational principle remains over 160 years. Coming towards the second slide, there are the main objectives that I want to highlight, that are the modernization of the legal framework, updating the outdated IPC, which was drafted in 1860 to reflect current socio-politic realities and address modern crimes like terrorism, cybercrime, and again crime against women. Reduction of delays, introducing timelines for various judicial process to reduce delays in the criminal trials and ensure faster delivery of the justice. And the third one is the ensuring fairness and transparency, creating a legal system that is a more transparent, efficient, and aligned with the need of the citizen, with the better mechanism for the accountability and the fairness. So basically, here I have mentioned the small differentiate between the IPC and the BNS. So the punishment that were listed in the chapter 3rd of the IPC in section 53 to 75, whereas the chapter is renumbered as a chapter 2nd, section 4 to 13 with some deletion and the modification. One new punishment, community service, has been added in the list. At the same time, some irrelevant provisions have been omitted, the term community service and undefined. Basically, section 53A, 58, 59 of the IPC having reference to the offence of transportation of a life.
Boundaries still, what are your findings?
Sir, that basic suggestion for the title, it is that there are still remaining many laws which should be implemented in the BNS.
Okay. So your topic is a legal and societal transformation. What do you mean by this societal transformation?
So societal transformation includes that the marital rape scenarios, still the marital rape are not the criminalized. Even the victim is in the front of the eyes of the laws. So this will give the very negative impact of the society.
There is no transition. Your topic is transition.
Yes, ma'am, there is no transition from the IPC to BNS. Concluding it with the need for reforming IPC is not merely a question of updating a legal code that is over 160-year-old. It is about addressing the changing realities of a modern and democratic and pluralistic society. The colonial legacy of IPC is outdated and provision, its failure to address modern crimes and social justice. Thank you and have a good day.
Jai Hind to all. My name is Priyanshu Singh.
Myself, Gracie.
And our topic is analyzing the new provision in BNS 2023 with special reference to exploring community service as a progressive measure. The introduction to community service as an alternative punishment epitomizes the Bharatiya Nyaya Sanhita's progressive approach to criminal justice. The reformative measure empowers magistrates to issue non-custodial sentence for specific offences. Consequently, individuals have the opportunity to repay their debt to society without facing incarceration. This innovative reform not only alleviates the strain on the prison system, reducing overcrowding, but also prioritizes the rehabilitation and reintegration by providing individuals with opportunities to make amends while maintaining their freedom. Community service fosters a sense of personal responsibility and promotes positive social outcomes.
Community service, a way forward. First is shift from retributive to restorative justice. As introduction of community service reflects a broader trend in criminal justice system, which shifts purely from retributive principles to more rehabilitative and restorative approaches. Community service addresses prison overcrowding. Community service is seen as a viable alternative to traditional forms of punishment, helping to elevate the issue of prison overcrowding. Moreover, it also changes the societal attitudes, that is, community service would be seen as a soft approach to crime by the society, educating society about the approach for such progressive shift to encourage public acceptance and support. Criticisms of community service includes, as community service is known as the punishment for crime that has drawn criticism due to its perceived leniency and inconsistent application among different judges. The inconsistency in imposing community service sentences creates a perception of unfairness and disparity within the criminal justice system. Difficulties in ensuring completion of assigned hours and instances of poor record keeping value of community service. Research indicates that community service alone may have limited impact on recidivism, suggesting the need for additional rehabilitative measures. Moreover, lack of clear guidelines is also a drawback of community service. Despite the introduction of community service, the BNS does not provide a clear definition of what community service entails or how it would be administered. Moreover, there is also lack in monitor mechanisms. Effective implementation requires the establishment of robust monitoring mechanisms to ensure compliance and the proportionality of punishment to the crime committed. The absence of such mechanisms risk misuse and inconsistencies. Thank you so much.
Now, I would like to invite Suchita Tripathi on the topic of community service as punishment.
Jai Hind to one and all present over here. Myself Suchita Tripathi, and the title of my paper is Community Service as a Punishment, Building a Justice System that Heals. Justice that is only punitive is too often short-sighted. True justice seeks to restore, heal and transform. These are the lines by the Brand Stevenson. Today, I want to share a vision of justice that doesn't just separate offenders from the society, but that brings them back into it, where they are part of restoring what's broken. With the introduction of Bharatiya Nyaya Sanhita, India's criminal law is moving in a new direction. One of the most progressive ideas in the new laws is use of the community service as a punishment. Why is this shift so important? For years, our approach to crime has largely focused on confinement. But let's consider what happens when people are locked away. They are isolated, often without chances to reform, and they may come out disconnected, maybe even more likely to re-offend. Prison isolated them, but it often fails to prepare them to re-enter the society. With community service as a punishment, non-violent offenders can take responsibility for their actions in a constructive way. It brings them back into society instead of punishing them away. Imagine a young person caught up in minor offense. Instead of prison, they are now given the opportunity to work on local projects like cleaning parks, helping in government welfare programs, or maybe even working with environmental initiatives. These individuals don't just fulfill a sentence, they learn new skill, gain real life experience, and most importantly, they understand the value of giving back. So, I would like to conclude that as we move forward, let's embrace the shifts in our society and justice system. Let's support a model that is human, constructive, and forward-looking. By turning punishment into the pathway for growth, community service under the Bharatiya Nyaya Sanhita can help us build a safer, stronger, and more comprehensive society.
यत्र नारस्तु पूज्यन्ते रमन्ते तत्र देवता, अर्थात जहाँ स्त्रियों की पूजा होती है वहाँ देवता निवास करते हैं. Jai Hind to one and all present here. Today I Gaurav Lohan from BLLB 5th semester presenting research paper on the topic Strengthening the Laws for Protection of Women under the Criminal Law Reforms in India. The protection of women in India has been a key focus of criminal law reforms, particularly in face of evolving societal challenges and increasing awareness of gender-based violence. This paper examines the strengthening of laws for the protection of women under the new criminal law reforms in India. It explores the historical context of legal protection for women, tracing the evolution from the Indian Penal Code of 1860 to the contemporary legislative changes, including the introduction of Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, Bharatiya Sakshi Adhiniyam. The research highlights key legal provisions related to crimes against women such as rape, domestic violence, harassment, and the protection of witnesses, comparing them across different legal frameworks. Additionally, the paper delves into the incorporation of technological advancement, the establishment of fast-track courts, and the importance of supportive legal environment to address the need of survivors. The study emphasizes the significance of holistic approach which includes social and cultural reforms alongside legal changes. To foster a safer environment for women, the paper concludes by outlining the potential for India to create a more equitable and just society through comprehensive and proactive legal reforms, ensuring women's rights and dignity are upheld in both law and practice. The whole presentation breaks into 6 parts. Firstly, the introduction. Second, background and need for reform. Third, key objective of new criminal law reforms. Fourth, proposed legislative changes. Fifth, challenges and consideration. In 6 parts, I will conclude my whole research paper.
You take
First.
the last challenges point.
Challenge. Okay. Challenges and considerations. Implementation and enforcement. Strengthening laws alone is not enough. Effective implementation, robust policing and judicial accountability are crucial for real change. Balancing rights. While tougher laws are necessary, there is need to balance the rights of the accused with the protection of victims to prevent misuse of legal provisions. Public awareness. Ensuring public awareness about their new laws is essential for their success. This includes educating women about their legal rights and available protection. Now I would like to conclude my research paper. The new criminal law reforms in India signify a major step forward in protecting women from violence and ensuring their rights are safeguarded under the law. These reforms aim to create a safer, more just society where women feel secured and empowered. However, their success will depend on the efficiency of law enforcement agencies, the judiciary, and the willingness of society to embrace these changes. Thank you.
Jai Hind everyone, my name is Srishti Verma and the title of my research paper is IPC versus BNS, an analysis of changes introduced by BNS 2023. The recent shift from the Indian Penal Code to Bharatiya Nyaya Sanhita marks a transformative movement in India's legal landscape. Effective from July 1, 2024, the BNS brings a fresh approach to criminal justice by emphasizing restorative principles over punitive measures. This shift recognizes the importance of addressing socio-economic factors that often underlie criminal behavior, thereby supporting rehabilitation and reintegration rather than solely focusing on punishment. Unlike the IPC, which originated in colonial times, the BNS aligns with the contemporary Indian values and addresses challenges unique to our Indian modern society, such as cybercrime, terrorism, and gender-based violence. In conclusion, the Bharatiya Nyaya Sanhita represents a monumental shift in India's approach to criminal justice. Moving away from the punitive roots of the IPC, this reform emphasizes restorative justice, cultural relevances, and accessibility, making it more responsive to India's social and economic complexities. By introducing new offences, updating penalties, and prioritizing victims' rights, the BNS aims to create a system that reflects modern realities while preserving Indian values. This transformation encourages a more compassionate and inclusive justice system, striving to rehabilitate offenders and addresses underlying social issues. Ultimately, the BNS is not just a new legal code, but a step towards a more equitable and harmonious society, inviting collaboration across the judiciary, policymakers, and communities to ensure that justice remains fair, relevant, and accessible to all. Thank you and have a nice day.
Now, I would like to invite Subhugi and Kshitij Rana.
Jai Hind everyone, I am Kshitij Rana.
What is your topic, please tell?
And I am here to give my views on my topic, community service as a punishment under BNS. The BNS is a significant piece of legislation proposed by the Government of India, which aims to overhaul the criminal justice system of the country. This act, often referred to the Indian Criminal Code 2023, is envisioned as a replacement for the Indian Penal Code of 1860. And it seeks to modernize and streamline India's criminal law framework to
Section 355, appearing in public place, etc. in state intoxication and causing annoyance to any person. If someone appears in a public place while intoxicated or in a place where they are not allowed to be and behaves in a way and that annoys others, they can be punished. Up to 24 hours in simple imprisonment, up to 1,000 rupees in fine, both community service. Section 356. Bharatiya Nyaya Sanhita deals with the crime of defamation. Defamation is when someone intentionally or knowingly harms a person's reputation by making or publishing false or damaging statement about them. This can be done through spoken words, signs, or visible representation. The punishment of defamation can include imprisonment for up to 2 years. I would like to conclude. While BNS 23 may include provisions for community service as a form of punishment, the specific sections and details have not been publicly disclosed or finalized. The introduction of community service within the BNS aligns with global criminal justice trends emphasizing rehabilitation and restorative justice over punitive measures, like particularly for minor offences. Jai Hind.
Now, I would like to request the chair and co-chair of the session to kindly distribute the certificates to all the people present here.
I would also like to request respected Dean Sir and Brain Chandra Sir to kindly come on the stage. Apart from it, I would like to thank the chair and co-chair of the event, Mrs. Afrin Al-Mafman and Dr. Ajraj Singh Sir. Thank you so much, sir and ma'am, for sparing your precious time today and having on board with all of us. Apart from it, all the speakers and participants and attendees of the event. So with this, we have come to officially close technical session 1, and technical session 2 will begin after lunch break of 20 minutes. And the lunch is open for all of you. Thank you so much. At sharp 2:30, we'll be back right here with technical session 2. Thank you. Jai Hind, Jai Bharat.
Jai Hind everyone. My name is Preet, student of BA LLB first year at Sardar Patel Subharti Institute of Law, Swami Vivekanand, Subharti University. And I am the moderator of technical session 2. I wholeheartedly welcome our respected chair, co-chair, participants and attendees of this session. The session is chaired by Dr. Prem Chandra Sir, Associate Professor, Faculty of Law, and co-chaired by Dr. Sarika Tyagi Ma'am, Associate Professor, Faculty of Law, and Ms. Sonal Jain Ma'am, Assistant Professor, Faculty of Law. I request all the dignitaries to kindly take their seat on the dais. The theme of the technical session 2 is Bharatiya Nagrik Suraksha Sanhita 2023. The Bharatiya Nagrik Suraksha Sanhita 2023 was introduced on August 11, 2023 to replace the Code of Criminal Procedure. More will be discussed by the participants. Every speaker will be given maximum 5 minutes to present their paper. I request all the speakers to kindly adhere to the time limit. In the sequence, I would like to invite Anand Jamini on the topic of the Bharatiya Nagrik Suraksha Sanhita 2023, that is a legislation replacing CRPC 1973. Jai Hind and greetings to all, respected deans, sirs and faculties, members of law department, and my dear students. I am Anand Jamni, first year LLM law student. As it is an honor and privilege to stand before you today on the topic, I present my research on the Bharatiya Nagrik Suraksha Sanhita 2023, a legislation replacing the Code of Criminal Procedure 1973 Act. Today we are here to discuss landmark piece, start of legislation, the Bharatiya Nagrik Suraksha Sanhita 2023. This law is a significant step towards reforming Indian criminal justice system. Its aim and strength: citizen safety, improve law enforcement accountability, ensure justice is more access, timely and equitable to all citizens of the India. The Bharatiya Nagrik Suraksha Sanhita 2023 focus on several keys such as protecting the rights, reducing delay in criminal justice, proceeding and ensuring the law enforcement system in both transparent and accountability.
This law has the potential to make profound impact in how we experience justice in India. As a future legal professional, it is an essential to understand and engage with it deeply. The idea of British take control of the people and administration of the India has been legalized in the concept of rule of law. Under the rule of law, it's become an instrument power and justice. The Bharatiya Nagrik Suraksha Sanhita 2023 has its scope by introducing revised definition for key terms such as audio, video, electronic means. Section 2, Clause 1, Subclause A. Bail, Section 2, Clause 1, Subclause B. Bail bond, Section 2, Clause 1, Subclause C. Bond, Section 2, Clause 1, Subclause E, and electronic communication. Section 2, 1, Clause and Subclause I. These updates reflect the evolution technical landscape to investigate trial and court proceeding under the summons, notice, audio video conference for evidence and recording of search and seizure activities. In my opinion and my suggestion, the new criminal law was framed with the spirit of citizen first, dignity first, and justice first. Rather working police with danda, now we police need to work with data. In the last, that's all. Thank you and Jai Hind, Jai Bharat, Jai Subharti.
Now, I would like to invite Sonam Nabam on the topic of police custody and their major changes under BNSS 2023.
Okay, Jai Hind everyone. First of all, respected all the judges and their student friends and also the faculty members. And my name is Sonam Nabam. I'm LLM third semester. I belong to Arunachal Pradesh. And today's my topic is police custody and their major changes under Bharatiya Nagrik Suraksha Sanhita BNSS. I would like to begin with introduction. The Bharatiya Nagrik Suraksha Sanhita BNSS 2023 represents a sweeping reform of the India criminal justice procedure designed to replace the existing Code of Criminal Procedure CRPC 1973, which update the rule handling detention, police custody, forensic investigations, and technological interrogations in criminal cases. This actually aims to streamline and digitalize procedure while making the police investigation more transparent and accountabilities, and including the detention guideline, the handling of evidence, and the major digital record keeping, reflecting the evolving needs to the both crime prevention and individual rights protections. My objectives of this paper, this paper is to analyze the new police custody provision introduced by BNSS 2023, assess their alignment with the fundamental rights and the Indian constitutions. This paper will also examine the balance between the extended police custody duration and individual right, and also analyzing whether BNSS maintain constitutional protections while responding to modern law enforcement challenges. So I hope you all aware about the importance of police custody and what is police custody. So I would like to read only few of the line. What is the importance of police custody? The importance of police custody provisions play a critical and pivotal roles in balancing effective law enforcement with the protections of fundamental rights and safeguard of individual rights, prevent potential abuse of the powers, and prolong the unjustified detention infringe, and also liberty and compromise human rights. That is the most important, and we have to know what is police custody according to the BNSS. According to the BNSS, the Bharatiya Nagrik Suraksha Sanhita police custody is when the police have physically and custody of unaccused persons and bring them to the police station for the question or investigation, the accused is then lodged in the police station lockup. That is police custody according to the BNSS. Now come to the major changes of the police custody and issues under BNSS 2023. The Bharatiya Nagrik Suraksha Sanhita BNSS 2023 introduced several significant changes the police custody and provision in India. The aim at improving investigative capabilities while enhancing the transparency, accountability. Here are the some major changes BNSS explained in detail one by one. Number one changes, extended duration of the police custody. New limit of the police custody under BNSS, while custody can be extended up to 60 days for the serious offenses. Whereas the previously, you all know, the previous the CRPC limited police custody to an initial only 15 days period. Yes. This extension is designed to end a complex investigation and particularly for crime with serious implications like organized crime or terrorism. I would like to criticize and criticism to this particular extended duration of the police custody is it is possible delays in bail and prolonged custody may impact individual liberty if not carefully managed. That I would like to. This is my criticism. And that relevant case I have inserted, that is DK Basu versus State of West Bengal 1997. In this case, the Supreme Court emphasized protection against the arbitrary detention and custodial abuse. Now, number two changes, mandatory forensic investigations for serious offenses. The forensic evidence requirement BNSS mandate forensic investigation for the offenses punishable by the 7 or the more years imprisonment. And this new requirement aims to make investigation evidence bonus scientifically rigorous. The transparency and accountability. Number three changes are digital documentation and videography requirement. This is also told our earlier speaker, Joy Advocate Sirs, and again I want to read out it, just 3-4 lines. Digital record keeping. BNSS also mandated that the police document various stage of investigation such as crime scene processing and suspect interrogation and evidence handling, and through the digital record and videography, this intend to create a auditable trial, and that can be used in the accountability and support the judicial reviews. Okay, and the fourth changes are expanded authority for the handcuffing and restraint. Handcuffing means hurt carrying. Though this fourth number.
Conclude your topic.
And my conclusions: the Bharatiya Nagrik Suraksha Sanhita BNSS 23 bring a notable reform to police custody law in India, expanding the police powers with measures that allow for the extended custody period, enhance the use of restraint, preventive detention, and mandatory forensic investigation on serious offenses. These changes aim to address complex crime and scenarios with the more flexible custody procedure, providing law enforcement with the tools needed and conduct a comprehensive investigation. However, this is expanded power also raise concern about the potential misuse and the need for strict compliance with the individual right as granted under the Constitution, particularly Article 21 and 22, which protect the personal liberties and human treatment and safeguard against arbitrary. This is my conclusion, and I want to suggest just to throw in my suggestion is 3 points I have included. This is need for clear definitions. The BNS introduced a new technology and discretionary power, such as detention individual until the occasion of past it case preventive action, however, without precise definition.
Definition for what?
Yes.
Which definition should be introduced?
Sir, this one, sir. expanding authority for the handcuffing and the restraints. Section 43 sub clause 3 of BNSS. This is just put it generally, sir, police powers. That's sir. Okay, number two suggestion in enhance the judicial oversight. The BNSS approach to extend the police custody up to 40 or 60 days based on the crime. More flexibility investigation can delay access and effect to the accused right. And the number 3 is training in accountability mechanisms.
Within 30 seconds.
Yes, sir. Just this is the last point. The training and the accountability mechanism. That's my suggestion. Thank you.
I request every speaker to kindly maintain and respect the time limit that has been given to you. Take an estimate of about 3 minutes and you'll be sorted. Okay? Kindly read the operative part of your article. That's it. The issues and challenges along with the suggestions that you have. Right? Thank you.
Now, I would like to invite Zahira Hassan and Prithvi Chauhan on the topic of Bharatiya Nagarik Suraksha Sanhita 2023.
Jai Hind everyone. My name is Zahira Mehnaz Hassan.
And my name is Prithvi Chauhan.
And the topic for my presentation is changes introduced in the Bharatiya Nagarik Suraksha Sanhita 2023. The Bharatiya Nagarik Suraksha Sanhita 2023 is a recently introduced law in India that aims to modernize the country's criminal justice system. It replaces the older laws, updating them to better meet the need of Indian societies today. This new law is designed to improve various areas of criminal justice, including victim protection, public safety, and law enforcement transparency. In India, the need for improved victim rights have been increasingly important for a long time. Victims of crime have faced many challenges within the justice system. Victims, especially those affected by serious crimes such as assault, human trafficking, harassment, and violence, often go through emotional and physical trauma. India's justice system recognized that the rights and well-being of victims needed more focus by providing them better protection, compensation, emotional support, and role in legal process. One of the important ways the Bharatiya Nagarik Suraksha Sanhita supports victims by ensuring that they receive financial compensation for the harm and losses they have experienced. This compensation is meant to help victims recover from the physical, emotional, and financial impact of the crime. By providing this financial support, BNSS aim to relieve some of the burden of the crime victim may carry. To make the support effective, BNSS introduced a faster payment process. Under this payment process method has been streamlined to reduce delays, ensuring that victims receive financial help and promptly when they need it the most. Right to participating justice system. Under the Bharatiya Nagarik Suraksha Sanhita 2023, victims have now have the right to be involved.
Both of you have to
just
your paper within 5 minutes. Within 5 minutes.
Okay.
I would like to continue from Counseling and Mental Health Support Counseling Service. The Bharatiya Nagarik Suraksha Sanhita 2023 BNSS recognized that victims of crime often face sub-emotional trauma in addition to physical harm. As part of its commitment to victim cares, BNSS includes mental health support and counseling service for victims. BNSS ensures that mental health support continues throughout and after the trial. It's not just about helping victims cope during the legal processes. Long-term emotional and physiological care is offered to help victims heal completely. Mental health care is vital because emotional recovery is just as important as physical recovery for victims. Healing from trauma takes time and BNS knowledges that victims need more than just legal justice. The Bharatiya Nagarik Suraksha Sanhita provides special assistance for women, children, and other vulnerable groups. These groups are often at a higher risk of experiencing violence, exploitation and abuse. BNSS places a strong emphasis on the sensitive handling of cases, particularly those involving abuse or violence against women and children. For cases like domestic violence, sexual assault, or child abuse, BNSS ensure that victims are treated with care and respect. Now the question arises, why this is needed? Women, children, and other vulnerable groups face unique challenges when navigating the justice system due to fear, society, stigma, or lack of resources. These groups are often less likely to report crimes or participate in legal processes. Under the BNSS, victim. Okay, ma'am. Swift justice. Because it helps victims achieve closure sooner. Delays in the justice process can cause victims to relive of the crime and can prolong their emotional suffering by speeding up trials and investigation. BNSS.
ओवरऑल व्यू क्या है वो 2 सेकंड में आप बता दो कंक्लूड करके.
What sir?
What is your viewpoint?
Sir, conclusion is for me it is like it is much needed in Indian society for because we have faced many challenges and this is very confidential also, like it is needed. It is the conclusion is that
okay.
Now I would like to invite Sheetal Bhati and Manik Pahuja on the topic of recent reforms in Indian criminal legislation.
दोनों लोग 5 मिनट में कंक्लूड कर लेंगे, अपना नाम बताएंगे, टॉपिक बताएंगे और आपका क्या मेन रिफॉर्म जो आपका टॉपिक है रिसेंट रिफॉर्म्स इन इंडियन क्रिमिनल लेजिस्लेशन. 5 या 6 मेजर रिफॉर्म्स जो आपको लगता है कि बहुत अच्छे रिफॉर्म्स हैं वो आप बता करके और कंक्लूड कर लेंगे. ठीक है. हाँ, दोनों.
जय हिंद टू वन एंड ऑल.
एक मिनट ट्राई करिए कि आप पढ़िए मत, जो आपके दिमाग में चीज़ें आ रही हैं उनको आप बताइए, भले ही आप हिंदी में बताइए इंग्लिश में बताइए. ठीक है. हाँ.
जय हिंद टू वन एंड ऑल. टुडे आई शीतल भाटी विद माय कोऑर्डिनेटर
Manik Pahuja
here in front of you all to represent our topic recent reforms in Indian legal system 2023 amendments. Law is majorly classified as criminal law and civil law. Some of the major criminal laws include Indian Penal Code 1860, Criminal Procedural Code 1973 and Indian Evidence Act 1862. These laws have been replaced as Bharatiya Nyaya Sanhita 2023, Bharatiya Nagrik Suraksha Sanhita 2023 and Bharatiya Sakshi Adhiniyam 2023, respectively enacted on December 25, 2023 and took effect from July 1, 2024. The Indian government took this tremendous step for the purpose to rehabilitate the Indian criminal justice system by replacing the laws of the colonial era. These new laws were established as a result of socio-political factors, demand for justice, which prioritizes victims, the need for tax regulations due to the digitalizing and developing societal value, all played a key role. It had major changes in the newly framed laws include changed punishment for few crimes, which are more stricter, marking issues such as jurisdictions, insufficient human resources and infrastructure, backlog of cases, ineffective investigations and prosecutions, and outdated laws and procedures. It has also been pointed out that justice has been delivered slow in India due to a large number of pending cases in various courts. Therefore, there is need to change towards a modern legal system.
These bills represent a comprehensive and significant attempt to overtake India's colonial era in the criminal laws. While they promise modernization and efficiency, their success will largely depend on a supportive implementation and judicial oversight. The analysis of the bills largely reveals some flaws that seek attention. The exclusion of Section 377 of IPC by Bharatiya Nyaya Sanhita poses a gap, leaving no provision for addressing the rape of an adult man. The proposed laws bring its offences there as a fit in the manner particularly concerning the state's duty and the security. These could possibly result in over-criminalization and ambiguous legal provisions. Despite these concerns, the legislative initiatives in the three markable stress on
technological and forensic science positions the legal framework on the India. The Act indicates the commitment to provide enhanced safeguard and protection in accordance with the current needs and values. Thank you.
Now, I would like to invite Shivam Sharma and Aditya Pundi on the topic of alternative dispute resolution mechanism in criminal justice system of India. The best way to resolve the conflict not through litigation but through understanding and communication. Jai Hind, a very good afternoon everyone present here. I am Shivam Sharma, final year law student. My topic, the paper of the title is Alternative Dispute Resolution (ADR). The alternative dispute resolution (ADR) mechanism are increasingly being used in criminal cases to resolve dispute outside the traditional litigation. This mechanism aims to reduce the burden on courts, promoting rehabilitation and provide closure for the victim and offenders. Mediation, restorative justice, arbitration, conciliation, negotiation, victim offender reconciliation, community dispute resolution, and diversion, progressive bargaining, and sentencing circle are the some ADR mechanisms used in criminal justice cases. These mechanisms focus on the repairing harm caused by the criminal crime, promoting community involvement, and addressing the root cause of the criminal behavior. They are also providing opportunity to victim and offender to communicate and reach a mutual acceptance resolution. However, ADR mechanisms are maybe not suitable for all the criminal cases, but those particular involvement serious crime of public safety concern. Additionally, they are concerned about the potential for concern unequal power dynamics and legal representation despite these limitations. A ADR mechanism has potential to transform the criminal justice system by providing us systematic, restorative, rehabilitative, and community force approach to the justice.
I am Aditya Pundi. The Indian criminal justice system is burdened with an enormous backlog of the cases, resulting in delay, justice, and overwhelming judiciary infrastructure in response to these challenges. ADR mechanism has been increasing integrated into the criminal justice process of time and alternative to distribution of time consumer advisor 12. ADR in criminal law, including mechanisms such as mediation, plea bargaining, restorative justice, and lock adalat, which are designed to case reduce court congestion, and promote rehabilitative and restorative justice.
Now, I would like to invite Anshika Singh and Ambika Siotia on the topic of analyzing the loopholes of new criminal laws.
Good evening everyone, my name is Anshika. My name is Ambika Siotia, and we are here to present a presentation on our topic analyzing the loopholes of the new criminal law 2023. The world has changed in the recent years for the legal research under India, especially criminal laws. These changes have led to the considerable debates and a discussion among the legal scholars, policymakers, and the general public. In the research, we shall touch upon one of the most important criminal laws India has witnessed after a long time and study the pros and the cons of these legal reforms.
The three criminal laws come into force on 1st July 2024 as it was passed by both the House of the Parliament of India and assented by the President of India. Let us talk about the new criminal laws of India and why they had to be brought into force, how they will be changed from some of the major clauses of Indian criminal laws, and what those new clauses have been added or removed from our old Indian laws of crime. The name of the three bills are Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshya Bill 2023.
The Indian legal system is a legacy of the laws enacted in the colonial era and since being considerably amended. New provisions in the criminal laws are more flexible to respond to the development, such as the cybercrime, terrorism, gender-based violence. To understand these new reforms, we have to appreciate the historical content of the criminal law.
When it comes to legal system, criminal laws come into play in order to regulate peace and justice among people. Criminal laws in India have evolved over the centuries, corresponding to change in societal norms and values. To meet new challenges, below it an overview of how criminal laws has evolved over the year and most recent development in India.
What are the loopholes in new criminal laws as your topic? Analyzing the loopholes of new criminal laws.
So basically the loopholes are, as we have analyzed, that for अगर सर किसी हमें अगर लॉज को इम्प्लीमेंट करना है तो सर अगर पुराने वाले को देखें नए वाले को भी देखें ना तो उस हिसाब से जो मेन प्रॉब्लम आती है वो ये है कि लैक ऑफ द रिसोर्सेज एंड इंफ्रास्ट्रक्चर टू द इफेक्टिव इम्प्लीमेंट द न्यू लॉ
ठीक है
एंड द कैपेसिटी बिल्डिंग रिक्वायरमेंट and the balance involved in the rights and the society.
ठीक है हाँ. Any other loophole?
The suggestions are empowerment of victims and introduction of cyber laws of the year and study of anti-trafficking. Good. Thank you, sir.
Now, I would like to invite Pragati.
Jai Hind to all honorable chair and all the participants. I Prakriti standing here with the research paper titled as a comparative study of CRPC and BNSS in victim compensation schemes and role of plea bargaining. The CRPC provides the legislative foundation for the victim compensation, enabling courts to order reparations, while schemes like BNSS offer supplementary support to address immediate and regional needs. Victim compensation scheme was originally not the part of the CRPC, but through the Amendment Act of 2008, Section 57A was added after the recommendation of the Meerut Committee, which is now replaced by Section 396 of BNSS. The number of cases which are pending in courts is shocking, but at the same time, the figures are no more astonishing. People have started accepting this as their fate. And here, a key change of plea bargaining was inserted by Criminal Law Amendment Act 2005, in which contains the section 265A to 265L in CRPC, which was replaced by section 289 to 300 by BNSS. And here there has been two major changes which has been made by the plea bargaining of the BNSS. First, it has changed to the person who are eligible to plea for bargaining. That are the persons who are not allowed, that are the offences which are punishable by death penalty, life imprisonment or more than 7 years of imprisonment. Prior to that, in CRPC, it was mentioned that the persons who have committing any crime against the women or the crime against the child of 14 years of age or any socio-economic condition of the nation. It doesn't mean that the importance of these crimes or that the court or the nation or the legislature is not just making that the people who have committed that crime are now eligible to make the plea bargaining, but the punishment for them has been increased. That's why they have already fallen into the category of the imprisonment for more than 7 years. That's why this change has been made. And under section 265B of the CRPC, there was no time limit which was mentioned for the plea bargaining. That the public prosecutor complainant to work on mutual satisfactory disposition, and which makes that the main motive of the plea bargaining that so that both the parties should reach on one ground and the justice should be provided to the victim or the prosecutor as early as possible. But when there is no time limit for the public for the mutual satisfactory disposition here, it provides that the plea bargaining objective has totally failed, but it has now been amended by the BNSS, that is given by the section 290 of BNSS, that there is a time limit for 60 days. And as well as victim compensation scheme here in section 396 also does not provide a proper mechanism to restore compensate victims. My suggestions are timely disbursement of compensation. Second is enhanced funding mechanism. Third is holistic support services, and sustainability initiatives should be taken. Thank you.
Good afternoon, everyone. I am delighted and excited to be present here today. Today we all have gathered here to discuss about the new criminal laws. I have decided to speak on the topic Bharatiya Nagrik Suraksha Sanhita, enhancement in efficiency in criminal procedure, and will show my insight in this topic. Justice Krishna here said, procedure is the handmaid of justice, meaning that the procedure rules are meant to serve justice and not to hinder. First, I would like to discuss about the data, statistics about the under trial prisoners.
तो सर से मिलो एक बार, हम यहाँ पे चेयर पे बैठे हैं, फिर आपको जैसे वो बताएंगे वैसे बता दें.
About the under trial prisoners and about the backlog of cases which are pending in our courts. As of 2023 and according to the National Criminal Records Bureau report for 2021, there are approximately 70,000 to 75,000 of cases which are pending in the Supreme Court. If I talk to you about the High Court, we have 25 High Courts, and in those High Courts there are approximately 59 lakh cases which are pending. Now if I discuss about the situation of the district and subordinate court, the situation is alarming and astonishing. There are approximately 4.5 lakh 5 crore cases which are pending in the district and subordinate courts. Now I like to discuss about my topic. The Bharatiya Nagrik Suraksha Sanhita replaces the existing Criminal Procedure Code 2023. The BNSS also aims to establish a justice system that has a greater efficiency and that can tackle the ongoing challenges of case transparency, complex procedure, low conviction rate, lack of technology adoption, and delayed justice delivery. Above all, the greatest objective of the BNSS is the Suraksha, protection of citizens from the unfair exploitation of the procedure possible through the existing loopholes in the current criminal procedure regime. Let me tell you that BNSS is not an arrow which is shot in the dark, but BNSS is an empirically derived legislation with a clear goal in mind. It is to protect the Nagrik citizens in criminal proceedings and not to hinder the rights of the victim or the accused. The initiatives taken under the BNSS also ensures its effectiveness, be it the introduction of sentence guidelines to prevent discretionary sentencing or balancing the rights of all stakeholders involved in a proceeding. I discuss about section 531 of the BNSS. It provides that if there is any appeal, application, trial, inquiry or investigation which is pending before the date on which the BNSS came into force, then it will be decided, disposed of, continued, held or made according to the provisions of the CRPC. Now I will discuss about what was the need and evolution of the criminal justice system, that why we needed criminal justice system to function as a society. According to Hobbes, man is selfish by nature and can go to any extent for pleasure. As said by Bentham, a person avoids pain and demands to seek pleasure. He is usually moved by his instincts, and in earlier times there was no regulations and limit to control his conduct. With the increasing population and communities, his interests collided with others and led to a situation of conflict. Thus, in order to regulate the conduct of a man, a system was needed that could monitor his actions. The development of criminal justice system is same as the development of a man. The first stage was there was no control over his actions and he acted as per his needs and demands. If needed, he could hurt anyone and fulfill his wishes. Then came the second stage when the territory expanded and the concept of state emerged. At this stage, a ruler ruled the kingdom and other people acted on his behalf. This stage, however,
please try to conclude within 2 minutes.
First, I would like to discuss about few provisions, like section 258 of the BNSS talks about pronouncing of the judgment. Earlier there was no provision relating to pronouncing of judgment, but now we have that within 30 days the judgment has to be pronounced, which can be extended to the 45 days. Section 15 of the BNSS provides that the authorities provides this provision the authorities, the state government, to appoint any police officer who is not with the rank of superintendent of police as an executive magistrate in addition to as a special executive magistrate in addition to an executive magistrate. Section 66 provides when a summoned person cannot be found, then the summon can be served on to the some family members who is present at the place at that time. And with the summon, this provision replaces the earlier verbatim of some adult member and contained in the CRPC. Now there is provision section 179(1). It protects the infirm and the aged individuals who are above the age of 60 years, that they cannot be asked to appear in the court in which the punishment is less than 3 years before the prior permission from the magistrate needs to be taken. Now I just come to the conclusion stage. Though we have the zero FIR been included, that now we have the concept of zero FIR, now we have preliminary inquiry, now we have the provisions dating to arrest, how the framing of charges and provisions dating to charges, but we are running like with short of time, so I'll just conclude by saying that according to National Mission for Justice Delivery and Legal Reforms, adequate judicial infrastructure is the prerequisite for reducing delays in cases. Though we have the provisions, but we are lacking in the infrastructure. So the main motive should be to have the infrastructure so that the implementations of those provisions can take place. And the principle of criminal jurisprudence forming the base of criminal justice system has to be strengthened by the state and collective will of people. A dynamic society must have the spirit to obey laws and aid the state in effectuating the legal measures. Now last, an efficiently functioning criminal justice system is the need of the hour, where India is facing daunting challenges like corruption, poverty and ignorance in its march towards development. Thank you everyone, thanks for giving me this.
Now, I would like to invite Praveen Yadav.
Gentlemen everyone, my name is Zahira Mehnaz Hassan, student of BLLB first year at Sardar Patel Subharti Institute of Law. I am the moderator of Technical Session 3 and I wholeheartedly welcome the co-chair and the chair participants and the attendees of the session. The theme of the Technical Session 3 is Bharti Sakshay Adhiniyam 2023, that is replaced by the Indian Evidence Act 1872. Every speaker will be allotted 4 to 3 minutes maximum to present their paper. I request all the speakers to adhere to the time limit. Now I would like to invite Shelly, and the title of her paper is New Criminal Laws in India.
My name is Vishal Tomar. I am a student of BLLB 5th year and I am here to present a paper on changes introduced by BNS 2023. The new Bharatiya Nyaya Sanhita Law 2023 represents a significant overhaul of the Indian Penal Code to aiming and align and criminal law with the contemporary needs of the society. The comprehensive changes in the law address various aspects in criminal law like ranking and investigation and conspiracy to offences against women, children and the LGBT community. The removal of the term sedition from the new law has got attention, yet concerns have been raised about the potential expansion of the power in dealing with the activities that threaten the state's unity and diversity. The introduction of the offences such as terrorism and organized crime aim to modernize a legal framework, but criticize argue to ambiguous language may inadvertently allow authorities to suppress political dissent. While the law introduced positive changes, it is not without its criticism. The omission to specific provisions of the transgender community and concern regarding to potential misuse of certain clauses, such as false promise of marriage, highlighted areas that may need further refinement. Additionally, the absence of explicit protection of witnesses and a need for gender-neutral approach in the certain section call for a careful consideration. In crafting a more inclusive and responsive criminal code, suggestions include adopting gender-neutral language, considering religion as a ground in organized crime, enhancing witness protection, and directly incorporating provision for victim compensation. Furthermore, there is a call to reevaluate and the continued use of death penalty and explore alternative reformative modes of punishment like community services.
Justice for the women is not just about harsh penalty, it's about a avoid health. Jai Hind, all present here, myself Swami and today I am presenting a research paper on the title of Impacts of New Criminal Laws on the Women's Rights and the Protections. I am dividing my research paper in these 3 sections. Now I am starting to my first section, the Bharatiya NAAC Samhita is including specifically challenge instance women's rights and protection in India criminal justice system defined in the strict penalty and sexual offence section 101. The BNS Act bound of scope of sexual offence and express provide different types harassment, molestations and non-violence act. Protection against workplace harassment by the covering more types of harassment and the law provided against security for the women in professional seeking aim to revolt case, workplace misconduct and support safety. Strict penalty for the rape section 376 and is also mentioned to the gang rape. The protection against stalking and cybercrime section 354D. I am analyzing to impact material rape penalty is not mentioned in this provisions. Focus of the safety in public place is not mentioned. I am giving to my suggestion for the further development and improving for Bharatiya NAAC Samhita Act 2023 in the way of more effective and protection empowerment of women. Expand training and workplace, clearly defined to online harassment, victim support services and digital literacy programs. Now I am starting to my section B. The truth justice is not ending of punishment. It is the beginning of empowerment and protections women's every space of society. The Bharatiya Nagrikta Suraksha Sanhita Act 2023 including civil changes that impact women's rights, protections, aid, enhance the safety and enhance justice, cases of violence and harassment of abuse. In the special mention of section 354, increasing penalty and the section support women's right of safety, dignity, especially unified protections, women's and workplace, public place and then online places. Impacts. The directly supported women facing abuse at the home, giving the strong legal ground of skills, health and justice, concluded of the right of life free of the violence. Victim rights section under 435. This section empowers the women, giving the voice of court, procedure and the impact of compensation, supporting the right of justice to fair treatment. I am giving to in this act for my suggestion to stand implementation of the section Bharatiya Nagrikta Suraksha Sanhita. Firstly, I am telling the awareness of campaign, dignity, cyber cells for the women's safety, increasing overrides of the costume cases and coordinated with the civil society organization. Law that protections women's right of the backbone of the society, value, equality, respect and justice for all. Now I am starting to section 3. The Bharatiya Suraksha Act 2023 introduces a specific challenge.
Yes, Levi, conclude your paper please.
From this slide forward.
Okay.
Evidence of sexual offense. Special mention for the section 232. The section allowed to including statement made by the victim regarding of the circumstances of the offense. Special mention for the victim-friendly procedure, section 154, is including the guidance of police offense to enhance the investigation of the crime against women conduct respectfully. I am giving to these considerations for the my challenging and consideration points. The Bharatiya Selection Act 2023 proposing civilization positive challenge for the women rights and protection challenge remaining. Implementations, effective information of new provisions, criticization. Firstly, I am telling to public awareness, education, investigations of the empowerment victim to understand the right of resources available for them and culture varied also. Now I am giving to last and least for the suggestion Firstly, I'm telling to guidance of the information statement, and last to the special suggestion for special court to the sexual offence. In hence supporting to the service in the specific court to establish for the victim support and the special treatment for the sexual offence and victims. Thank you for the listening.
Genuine facility of the Law College. My name is Aarti. I am a fourth-year student. My topic is comparative analysis of the Indian Evidence Act and the Bharatiya Sakshi Adhiniyam 2023. The rapid advancement of the technology in the modern area, increasing in the uses of the technologies and the exact evidence in the legal process. The Indian Evidence Act and the BNS are two significant legislatures that govern the admissibility of the legislator, that govern the admissibility and the treatment of digital evidence. The history of electronic and digital evidence in India, the primarily shaped by the Information Technology Act 2000 and the subsequently it was amended to the Indian Evidence Act 1872. Comparative analysis, the Indian evidence, the definition of evidence is very narrow, is related to the electronic evidence. But now the Bharatiya Sakshi Adhiniyam 2023 is the broadly focus of the electronic and the digital evidence. Now, another changes the administrative standard, the Indian Evidence Act that established or the electronic evidence often the leading rejection of the lack clarity, but in the BNS there is a very broadly and the focus about the electronic and digital evidence. There is a specific section and but in the Indian evidence there is only two sections to talk about the digital and the electronic evidence. Now, is a new section was emerged, section 63 of the Bharatiya Sakshi Adhiniyam is talk about that the certificate of the requirement of digital evidence. Now, I was to give some relevant challenges of the Bharatiya Sakshi Adhiniyam. First is ambiguity in the term. The term like the proper custody, lack clearly defined within the BNSA leave the potential confusion regarding to the administrative standard. Next, balance the privacy. We are also not proper clearly defined that the balancing of privacy, because in modern area everyone is in a social media, and we can also say that every life is related to the internet. So we also balance to the privacy of the individuals and the citizens of every country, not only in India.
The electronic record is come in a secondary record. But in Bharatiya Saksha Bill Adhiyan, but in the Bharatiya Saksha Bill Adhiyan, the electronic records come in primary records. The definition of electronic records, the Act recognizes the concept of electronic record, including email, digital files, and document creates or stored electronic as admissible evidence in the court. What is tampering or tampering of electronic record? Tampering involves deleting or modifying the records with the intention of misleading or falsing the data to affect the legal outcomes. Section 57 of the Bharatiya Saksha Adhiyan defines primary evidence and carries four other explanations named 4, 5, 6 and 7 in the addition to the 3 explanations mentioned in the Indian Evidence Act. According to the Bharatiya Saksha Adhiyan Bill provision, electronic or digital records would be treated as a primary evidence in the following. Thank you.
participants. As we have come to the close of this one-day training session on the new criminal laws, I, Prakriti, a student of BLLB 4th year, is pleased to stand before you in this valedictory session, chaired by Dr. A.P. Garg sir, Dean Faculty of Law Professor Dr. Goyal Bhartiya sir, along with Dr. Anuradha Singh ma'am. I request you all to please form the dais. Today we have this opportunity to delve deeply into the complexities of the recent legal reforms that have the potential to reshape the landscape of our criminal justice system. I request all the three reporters for the day to present their reports briefly with the time frame of 5 minutes. I request Akansha Srivastava from LLM second year to present her report.
Good evening everyone. Good evening and Jai Hind everyone. My name is Akansha Srivastava and I want to pay my heartfelt gratitude to our Dean Sir and our esteemed Chief Guests and our teachers for giving me this opportunity. To sum up today's session, we had the pleasure of listening to Mr. Saju Jacob, an advocate of Supreme Court of India. Sir discussed about the adaptation of electronic modes under new acts and how digitalization is a step towards a progressive society. Towards the end, he mentioned the fact that change is the only constant and the law of nature. Hence, when we should with our whole heart accept the new laws. Then we had the opportunity to listen to Professor Dr. Bageshwar Deshwal ma'am. Ma'am stated that any law needs to evolve as a society evolves, and since we had the laws from colonial times, it was time for our new laws to come which not only cater the today's society but also a futuristic one. She very generously explained us the key changes made in all the new acts. Moving to our next chief guest, Dr. Professor Malik. He started with reminding us that on November 9, 1995, Legal Services Authority Act 1987 came into force, explaining us from the hierarchy of courts to the capacity of each court to give punishment and the hierarchy and qualification of Directorate of Prosecution under the new acts, BNSS. Sir very kindly explained us the key changes made under BNSS and the challenges which we may face in future. Moving on to our Vice Chancellor Major General Thapliyal sir, who talked about his belief in advancement of technology and suggested that there will come a time when the mythology, that is our mythological scriptures, will not be considered a myth but a fact one day, based upon the evidences which we will find in our future. We also had a pleasure to hear Dr. Professor Amar Prakash Garg. He pointed out that the old rules made by the Britisher made to rule us and not upon the rule of law. Hence, it was needed to the society. Hence, it was the need of the society to get new laws and which will benefit the society. His suggestion that all stakeholders should come together and make new laws a success, and we should pledge to educate the society with these new laws is something I'm taking back home with me today. Thank you, everyone.
I request Aarti Goyal from 4th year to kindly present her report.
Thank you, Pragati. I'm Aarti Goyal from 4th year student. I will present my report for whole seminar. The first, I want to describe the report related to our welcome session. There is advocate Saju Jacob sir who was give the address related to the new laws and the why new laws was introduced in our country. He said the changes is need for the recover the problems of the past. He also told about the Buddhas and said that the changes is the need for the society. He further said that the new change of the laws related to the digital evidence and the zero FIR and the many more changes are related to the new criminal laws. Further, Professor Dr. Bageshwar Devi ma'am, who tell about the very landmark cases and related to more information related to the new criminal laws. He she addressed what is the substantive law and the procedural law. She decorated the title, the BNS and the BNSS and BSA. The Constitution provides the Bharat, our the language, and the penal replaced by the NAAC. The penal means the punishment, but the NAAC this means a justice. And she also addressed the community service. The punishment of community service is very important for the petty offences related to the reduce the imprisonment of the any person and the fine and financial related to the punishment. Now, further, Professor Dr. Assad Malik also give the address our session that adversary system of the law. There is a two adversary system. First, advocate and judge. The Bantham said the begin eyes and of the law. He addressed may judgment need for the change of law for the better justice, and he also stated what is the offense. He also provided the hierarchy of the courts in our country. Next, Dr. Amar Prakash sir, he said that he is not satisfied with the three criminal laws. He said there is some lack of loophole of the new criminal laws. He also said that we need to settlement petty cases outside of the court does not meet in the new criminal laws. He further said that the Subharti law student should provide a free legal aid to all the citizens and the persons of city. Another, the Vice Chancellor of the Subharti University, he addressed that the agriculture revolution and the digital revolution, everything evolve as we evolve, so do their legal system. Also, would religious should be replaced by the dharma. After this welcome section, we going to the first technical section, which holding by the Miss Arfreen Alwaz ma'am and Mr. Ajay Raj sir. The first session, paper present by the Kajal Kumari. She is told about the community service introduced under the BNS. Said the community service is the justice for the fair justice of the Indian legal system. And another is Ankita. She is comparing the IPC and the BNS in the victim compensation scheme. She addressed that the new law are replace the colonialism mindset of the law, and she emphasized that the victim compensation scheme in new laws was focused. Another, Ayush Anand, he said the evaluation of the criminal law. He said that the British research paper aimed to the particular of the criminal laws is restorative justice is needed to the criminal justice system. Another Jane Alam, his topic is related to the community service. He said, and BNS's emphasize punitive approach of the criminal justice. BNS is the balance the crime and justice. Another, Kaushal Jahan, she stated about the OTT platform. OTT platform promote the criminalization and the digital age. The crime is highlighted of platform, OTT platform. Another, Rakesh Kumar criticized, analyzes crime against the refugee child and the women. He concerned about the crime against the refugee and the refugee women, children and the refugee women. Another is John who was concerned about that the community service related to the help to the poor people, and also said that the religious provide the community service already in his religious book. He also mentioned the Muslims religious book, Christian religious book, and Buddhist religious book. Kasak, she addressed that the new criminal law punishment is the improving the justice system and the rehabilitation and detention theory. Another Kasas is BNS is the comprehensive approach. She compared the BNS and the IPC. BNS need to be a contemporary need. Pavni Arora, the modernization of legal framework, the reduce of the primary object of the punishment related to the fine, and the new punishment was emerges community service. Suchita, community service is help for justice statement. Community service is rising the life and the benefit of the citizen. Another Gaurav Lahiya, she is the highlight the crime against women and the provide the faster court of the far judgment, and the BNS provide this section. Shrishti Verma, BNS is the focus society related to the modern system crime and the cyber crime rehabilitation. Kshitij Arora and Soumya is community service under the BNS's community service is aimed to without financial burden. They provide accurate punishment for the petty offences. In this last speech, there is a vote of thanks was given. Now our second technical session was started, which was held by the Sarika ma'am, Dr. Sarika Tyagi ma'am, and the Dr. Premchandra sir and Sonal Jain ma'am. The first research paper presented by the Anand, signification relation BNSS, and he said that the definition of BNSS suggests the criminal law should be a first for the citizen and the policy should be a data, not the data. Sorry. So BNSS 2023 represented Indian criminal justice, the new criminal law, custody and the protection of the police custody is when the physical accused and the person. He defined the new BNSS the definition of police custody, that means the which police custody in BNSS the physical accuse a person, and another Prakriti she present the CRPC section 357A replaced by the section 396 of the BNS, which does not provide a proper mechanism to related compensation to victim. Plea bargaining and replaced by the new law. Zahir Hussain and Prithvi Chauhan changes in the BNS 2003. They emphasizes victim compensation scheme. BNS is the providing victim compensation system for the financial support, mental support to the victims, and BNS ensure the provide victim mental and physical financial help. Sheetal Bharti and the Malik Mahani Puja. Criminal law is the significant role in the modern area. IPC in the rape, there is no section of the male in a previous IPC, but in now BNS is provide the gender neutral law. Shivam Sharma and Aditya, they are talk about the ADR in the criminal cases. They are concerned about the potential for the concerned unequal power dynamic and the unequal legal representation. Anshika Singh versus Anshika and Ambika, there is the they provide the provision of related criminal criminal law is in a communal area, and the new law is regulated for the emphasizing in the faster justice system. They suggest that the empowerment the victim scheme and the focus the cyber crime. Anchita Singh is according to the he is give the data related to the National Crime Recording Bureau. He said that the 4.217 lakh prison in India, which is the 76th world industrial prison. In BNS aim establish great justice system, greatest aim BNS protection of citizen. Bantham said the person avoid the pain and wanted pleasure. He said that the section 258 related to the within 30 days pronounce the judgment in BNSS, and he also emphasized many related to case and compares related to the BNSS and the CRPC. Now, going on, third technical session was started. First paper presented by the Vishal Tomar. He said that the failed marriage area should be a through the again gender neutral approach handing to the done. Community service is added as a punishment in a good stab. Lavi Malik she suggests the expand area in including the POXO victim support mechanism. Evidence for the sexual offense, special mention for the victim friendly approach. And another is Himanshu sir. His implementation of BSA 2023 training in the police state. He give some suggestion related to the implementation of the Bharatiya Sakshi Adhiniyam. The first suggestion is the training of police officer and provide the education, conduct the workshops for the related to the new criminal laws. Another presenter, Anupuram Krishnamurthy, she talked about the dying declaration in Indian evidence previous and the new. She emphasized that the administrability of the dying declaration should be more emphasizing. And another Aarti Goyal, she elaborated the history of the digitals and the electronic media. She talked about that the first electronic revolution was emerging in information technology 2002, and subsequently the Evidence Act was amended, and she also gave the suggestion related to the implement of new criminal laws and many more things. Thank you.
Join to honorable dignitaries, one and all present here. Today, 9th of November 2024, one-day seminar conducted on Sardar Patel Auditorium, Swami Vivekanand Subharti University. National seminar on issues and challenges in implementation of new criminal laws. There are participants over 10 states. Started with as a token of respect offered plant to honorable dignitaries. After that, lamp lighting ceremonies conducted. After that, Dr. Reena Bishnoi ma'am enlightening on the theme of the seminar and welcomed honorable dignitaries, resource person. After that, our first speaker, Advocate Saju Jacob sir, Lily Thomas Chamber, started with a quotation of the Franklin D. Roosevelt, US President. No man is above law, no man below law. Also about zero FIR, victim received copy of FIR. After that, to the next speaker, Professor Dr. Bageshwar Deswal ma'am, Faculty of Law, Delhi University. she published a paper on the anti-rape law in India, 2015, connecting with Heraclitus, changing need of the society, exemption from criminal law, substantial law, decoding the titles of the new criminal law, colonial law not only to penalize but in new law focus on justice for own people. Also connecting with theories of social contract, also with various changes of the BNS, deleted section, modified section, added sections, also connecting with the historical backgrounds of the new criminal law with 15th Law Commission and the first Law Commission 1834 Lex Lakai report, also connecting with the case Bhagalpur blinding case, also connecting with the Ganga jail film, and the third speaker Professor Assad Malik sir, Faculty of Law, Jamia Millia Islamia University, connecting with Adversarial System of India, Interpreted Criminal Procedure Code and BNSS, discuss about FIR and NCR, EFIR, hierarchy of court and public prosecutor, also connecting with the case Arnesh Kumar versus State of Bihar, changes of head curfing is allowed. About the police custody, 15 days, 40 days, 60 days, and also connected with the case Rakesh Kumar Paul versus State of Assam, also connected with section 187, less than 10 years. And the fourth speaker, Professor Dr. A.P. Garg, Research Director, Swami Vivekanand Subharti University, connecting with the what is the challenges in the implementation have not been touched, also connecting with the data of the pending cases till October 2024 along with High Court and Supreme Court cases, given suggestion, increase number of courts, educate the public for this new criminal laws, also touched with mandatory for summary trial. Also the fifth speaker today is Major General G.K. Thaplyal sir, Vice Chancellor, connecting with revolutionary ages period, Kautilya period, Dharm Shastra, Dand Shastra, changes is must for revolution. After that, Professor Dr. Vaibhav Goel Bhartiya sir, concluding remark and vote of thanks. There are 3 technical sessions. First session is chaired by Ms. Afreen Almas ma'am and Mr. Ajay Raj sir. There are 16 participants presented his paper. Out of 16, 2 are presented with co-author. Moving forward for this topic, community service punishment, evolution of Indian Penal Code, community services punishment, crime in OTT platform, crime targeting in women and children, mental health challenges under the new criminal law suggestions, what is community services, section 84-209 BNS, reforming criminalization new offences, the evolution of the criminal law, speedy justice, victim-centric approach, DC versus BNS, modernization of legislation reduction. Moving forward to the second technical session, there are 8 papers presented. Out of 8, 4 are presented with co-author. Moving forward to the title of the paper, Police Custody and Major Changes under BNSS 2023. Digitalized procedure is more transparent. Changes introduced in the BNSS. Recent reforms in India's legal system, analyzing 2023 amendments. ADR mechanism in criminal justice system. Analyzes the loopholes in new criminal law in 2023. Comparative study of CRPC and BNS. Victim compensation and role of plea bargaining. BNSS, enhancement of and efficacy of criminal justice system. Moving forward to the last third technical session. There are 7 papers are presented individually. Changes introduced by BNS, impacts of criminal law in women, overview of Bharatiya Sakshi Adhiniyam, electronic evidence, comparative analysis of Indian Evidence Act and Bharatiya Sakshi Adhiniyam, dying declaration, cyber crime, Bharatiya Sanhita Adhiniyam Bill. That's all. Thank you.
I humbly request Professor Dr. Weber Goel Bharti sir, Faculty of Law at Swami Vivekanand Subharti University to kindly address the gathering.
Thank you and Jai Hind, one and all. First of all, I would like to add couple of points. अभी 3 बच्चों ने यहाँ पर रिपोर्टियर वाली रिपोर्ट प्रेजेंट की. मैं देख रहा था कुछ बच्चे हंस रहे थे. मॉर्निंग से लेकर शाम तक अगर यदि आप एक एक स्पीकर को प्रॉपर सुनेंगे और लिखेंगे और उसके बाद उसके बारे में बोलना, कई बार जब आप नोट कर रहे होते हैं ना, तो नोट करते हुए आपको खुद नहीं मालूम पड़ता कि आपने क्या लिखा है. वी आर फ्रॉम द हिंदी बेल्ट. जब हम उसे इंग्लिश में लिखते हैं तो कई बार जल्दबाजी में उसे गलत भी लिख लेते हैं, और उसके बाद फिर यहाँ पर आकर बोल पाना. अगर मैं बात करूँगा कि यहाँ पर अगली बार हम सेमिनार कराएंगे कौन रिपोर्टियर का काम करेगा, तो कई लोग ये कह देंगे इससे ज़्यादा बोरिंग काम कोई नहीं होता. लेकिन अगर यदि दूसरा पर्सपेक्टिव और दूसरा पहलू देखा जाए, नॉलेज सीकर अगर यदि कोई है तो इससे ज़्यादा इम्पोर्टेंट काम कोई नहीं है. क्योंकि जितना रिपोर्टियर सीखता है एक एक आदमी को सुनकर, उतना कोई नहीं सीख सकता, क्योंकि वो अटेंटिवली एक एक चीज़ को सुनता है. तो अगर यहाँ पर आज 3 लोगों ने रिपोर्टियर का काम किया तो ज़्यादा साधुवाद BLLB के बच्चे, क्योंकि LLM में तो उनका जॉब है, उनके पास रिसर्च मेथडोलॉजी उन्होंने पढ़ी, उसके अंदर एक टीचिंग मेथडोलॉजी आती है सेमिनार मेथड ऑफ लर्निंग, और वहाँ पर सेमिनार कैसे कंडक्ट होना है, इन हाउस सेमिनार, रीजनल सेमिनार, नेशनल सेमिनार, international seminar. They are the different pedagogy and different objective and the different criteria before giving the nomenclature or deciding the nature of that seminar, and then how to organize from inception to end. सेमिनार ऐसा नहीं है कि आपने सोचा और आप सेमिनार को एग्जीक्यूट कर दें. आपको एक थीम लेना पड़ेगा, उस थीम के लिए फिर स्पीकर सोचने पड़ेंगे, उस थीम का कॉन्टेम्परेरी सोसाइटी के अंदर यूटिलिटी सोचना पड़ेगा. आपको सोचना पड़ेगा आपका सेमिनार का ऑब्जेक्टिव क्या है और आप क्या उस ऑब्जेक्टिव को अटेन कर पा रहे हैं या नहीं, आपका वो आउटकम आया या नहीं आया जो आपने सोचा था. सोचना पड़ेगा कि टाइम कौन सा होना चाहिए जब हमें स्पीकर मिल जाएं. उसके बाद में ऑडियंस, उसके बाद में ऑडियंस के द्वारा एक्सेप्टेबिलिटी, और फिर एक टीम बनती है, उस टीम को पूरा जोड़ना. Organization of seminar is not an easy task, but it is expected from all the students of LLM that they should know, because in 3rd semester they are learning and they are studying one paper, that is seminar on contemporary issues, which is all about how to organize seminar. They are expected to hold at least 3 seminars in the semester, where they will form their own teams from the students. They will request the faculty members to become the resource persons. They will circulate the notice among the students to be the audience. Then they will understand the pleasure and pain of behind the organization of one seminar. So today, this seminar, where I was expecting more contribution from the LLM 3rd semester, sorry to note and sorry to share, I didn't get that. If you are learning and if you are doing something for the purpose of higher education or for the purpose of fulfillment of your dreams, then you should be active. I am not asking that you should be proactive, but you have to be active. If you are not active, then the coming time will reject you. The society is proactive. Our ages, or you can say the time when we have studied, that was not the proactive time, and the learning system was not that much vibrant as it is today. We are having the entire globe in our pockets with the entire good knowledge and the bad knowledge, but the segregation of the content in the right corner or the left corner, it depends on you, and you will not be in a position to connect that until and unless you are not regular, until and unless you are not attentive. May I know how many students from LLM final year are sitting here? 1, 2, only 2 students. So it's good that 2 students are here. And I would request all the faculty members who are taking classes from LLM third semester, please do something so that they can feel that they are not on the right track. If they are carrying the name that Subharti Law College is with them, then they are expected to understand their responsibility. This seminar is not for me. Professor Garg is around 71. And this type of seminar is not going to add some commercial value in his life. But certainly, for the you people, such type of the activities are going to add not only the commercial values, intellectual values, but also your personality values. And when I am talking about the personality values, it is on the foremost ladder, because whenever you will be before any platform, then your personality will speak on the, on the forefront. So it was something, but I would like to appreciate the 3 students who have, at least accepted the offer of the faculty members and tried and have make an effort to prepare the report and even make another effort to present the report from this podium. So before starting my session, I want a big round of applause for them. And my request, you can laugh on my wordings, on my statements, on my knowledge sharing, but not on my students. They are too young. Might be possible they will not in a position to bear up with that. This is a temple of learning. This is a temple where we can transmit the knowledge. This is a temple where we can deep root the idea how to pay respect to the senior. But if we are giving a laughter to my junior, what message we are giving? Even I am not perfect. I will be perfect when I will take the last breath. अपनी आखिरी सांस लेते हुए मैं perfect हो जाऊंगा, क्योंकि तब मेरे अंदर कोई सुधार नहीं कर पाएगा. So how I can say that my students are perfect? Might be possible it is slightly bitter to digest, but I request you to please never give a laughter to my students who are sharing their views, their thoughts in whatever manner, though they are not that much good. Might be possible they are not perfect, might be possible they are full of flaws, but at least they tried. An effort matters, and efforts that are countless, and that matters a lot beyond imagination. I think I am loud and clear, and in future you will not give such type of reaction if somebody is sharing something from this podium. So far as the purpose of this one-day national seminar is concerned, I would like to share the history. We received 2 letters, one letter from the Ministry of Law, one letter from National Legal Service Authority, that we have to initiate sessions to spread awareness about the new criminal laws. We have requested to our Honorable Vice Chancellor that we want to arrange such invited lectures, and he permitted. Later on there was a discussion in between me, Premchand sir, Reena madam and Afreen madam. They constitute seminar committee, that we are going to invite some guest speakers on new criminal laws. Then suggestion was like that, why not we are holding it in a way that it can be a seminar where we may have participation from the students. Because if it will be only in the manner of a guest lecture, then retention will be not that much as it is expected. We will not be in a position to get the desirable outcome. So ultimately, we have converted the idea and changed the idea and converted it in form of the national seminar. We get the approval from National Legal Service Authority because it is National Legal Service Day. This is 9th November. So we decided that we will hold this seminar on 9th November. So this is the idea behind that we came up with this. In today's session, in absentia, I would like to appreciate the efforts of Professor Assad Malik and Professor Bageshwar madam. and the way they shared their knowledge in that much short period. I am not sure that how much you have captured and how much you have grabbed, but I will try to reconnect and I will try to give a small recap in my own words, in my own way, because they have given you the idea about the Britishers and about the Indian government. They shared about the objectivity of the Britishers and the objectivity of a democratic republic. The objectivity of the Britishers is not to do justice but to rule over Indians. When we are talking about rule over Indians, then ruling means by hook and by crook. My subordinate is expected to serve. It is not like that we have any choice to choose, but without choice we have to impart and we have to serve. This was the objectivity at the time of the Britishers, and the mutiny of 1857 that was resulted, and ultimately, as rightly stated by Professor Bageshwar madam, that IPC was the outcome of that. The objectivity of 1833 Act, that was codification of the Indian laws. It has taken around 110 years to the Britishers that they have taken from 1723. 1723 they came up with the mayor codes, and with the help of the introduction of the religious laws, with a proper introduction of the British law and proper injection of the British law in traditional values, per se the traditional values of the Indian civil system and Mughal civil system. They were the two double fold civil system which was applicable in our country India. At one fold that was Indian system and another fold Mughal system. Sharia law and Indian law, per se we can say Hindu system, or the Indian knowledge system in present time we can say. At the time it was too tough for the Britishers to implement their legal system, and again I would like to say it has taken round about 113 years from 1610 to 1723, because from 1610 from Surat they came up with the three presidency town: Chennai, Kolkata, Chennai, Madras and Mumbai. Bombay. Mumbai is today. Yeah. So after these three presidencies town, they were not in a position to control even these three presidency townships. They were not in a position to control even after the proper demarcation and the division of the public of, or the person who are residing within the geographical boundaries of India, that was divided in two parts: black town and white town. Black town, the inhabitants and the citizens and the persons who were living in the geographical boundary of India outside the domain of East India Company, or the offices of East India Company where the governor and the viceroy and the representative of East India Company were residing. Their companies, officers were residing, and the workers of the company were residing. The workers of the company who were Indian, who were residing, they were in the white town, and outside that area entire Indians were given the name that is the black town. This is the first division. The division which were not made by the Britishers and not made by the Mughals or the Muslim invaders, that was introduced by Britishers. The only one objectivity: to introduce British legal system in India. To your information, and might be possible you are well aware, the highest colonies around the world, the credit goes to Britishers. In the entire world, the highest colonies were in Britishers. They ruled majority of the countries around the globe. And after English Bill of Rights, America, which was the colony of the Britishers, they learned a lot from the Britishers. And ultimately they decided, why not we come up with the American Bill of Rights? And immediately after some time, they came up with the American Bill of Rights. And they declared themselves free from Britishers, and they are not that much capable that they can raise their voice against the Americans. But try to understand the situation of 1857. The mutiny, and even afterwards the Indian society was divided in such a manner that they came up with the legal system named Indian Penal Code, the punishment for Indians. And the system, if you will learn, the transnational crime, the concept of transnational crime, which was not applicable in 16th, 17th or 18th century and even in 19th century that was introduced in Indian Penal Code. As rightly stated by Professor Bageshwar Deshwal Madam, the purpose was to punish, it was to award justice. There is a big difference. And further, she added the CRPC, the procedure for the implementation of the substantive law, 1861 failed. Then 1898 again failed. And then 7 amendments. And then in 1973, India came up with the CRPC. Now for your knowledge and for the process of your own research, try to understand the law which were applicable before 1950, how many laws were replaced or amended and they were reenacted or modified, or how many laws were implemented in the same manner. Indian Evidence Act as it is, Indian Penal Code as it is, but procedure was changed. Something substantive which was developed for me, for my protection, for my rule, it was remained as it is. But the procedure was changed. Why procedure was changed? So that if I am changing the procedure, I can rule in the same manner as it was executed, forced or implemented by the Britishers. The objectivity might be possible. We can give the color of the political parties. We can say this is, because BJP is something towards division of, community division. That is why they have come up with the law. And Congress was slightly good and they believe to carry their own cultural heritage. But I am not agree with that, because I have done a little bit research and I found that the present laws which were in a new form means with a new interpretation, with a new intent, and the intent is to do justice. The objectivity is not to punish. In jurisprudence we have studied theories of punishment, and the objectivity is to have a reformative state. And if we give sentence, then we normally say we failed to reform one. That is why the one was sentenced. So the point is, when we are talking about justice, and justice not to be done but it seemed to be done, and when we are talking about the conviction, more specifically about the criminal justice system, our criminal justice system has been criticized a lot round the world because of 3 reasons. 1, because of the conviction rate. 2, because the gender bias laws. 3, the law is not relevant or not updated and not as per the need of the time. The procedure is silent with regard to the electronic evidence. But the Evidence Act that says that electronic evidences are, acceptable. Until and unless we are not having a proper procedure, how we can say like that? In last more or less 75, more than or around 70 or 80 years, we have observed different amendments, different propositions and different opinion from the different political parties on the viewpoint of the genders, Rajdroh and Rashdroh, in the name of the property right, in the name of the kidnapping, abduction, and one point even today that remain in my brain, that still there is a requirement of slight change. Earlier, extortion was given under the chapter which was offences against property. Extortion is a crime, offence against property. So, extortion that is related to extort property, or extortion is related with something blackmailing to a human being. It is related to a crime which is also related to the crime against human body. So earlier, if I am connecting it, it is something related to abduction, because the ingredient of the abduction, the objectivity and the intent of the abduction and the crime behind the extortion somehow few of the ingredients are identical. Right now, the space is too wide. Abduction is under 140 and extortion is 308. So somehow the demarcation and the ruling, as rightly stated by in the morning session, definition clause, we were totally confused at the time of learning and framing the definition for the purpose of the different examinations. We are having faculty members who are sitting here who have worked hard for the purpose of cracking examination. But ultimately that codes were not that much easy that can be understood by a layman. And law is not for a lawman, law is for a layman. Because ignorance of law has no excuse. But the law which is in present time in form of BNS, BNSS and BSA, that is in the new form. It is in a simplified form. We can understand the law in a proper manner. And the objectivity is to make you understand so that you cannot get confused with the media channels, with the political debates and the political slogans as they are propagating the objectivity of the new criminal laws. The objectivity of new criminal laws is to simplify our criminal justice system, to make you better understand the criminal justice system, to better define few crimes, to redefine few offences, to remove few offences. So this was the objective of IPC, and since CRPC of 1973, it was outdated as stated by the Supreme Court of India in numerous Supreme Court verdicts. So it was needed to be reformed. As rightly stated, law is not a painted stick which can be fixed forever in a garden. But like life, law is not static. That means law is ever changing. We must have that much component in our legal system that we can interpret and redefine without amendments. And the IPC, CRPC and Evidence Act have loosened that sanctity that at the time of the redefining and the interpretation, we can connect with the present requirement or as per the day-to-day or contemporary aspect. So the biggest issue behind the introduction was to connect it, and the challenge to make you understand. The biggest challenge to make a layman understand the objectivity behind the introduction of all these three criminal laws. And the objectivity of this seminar will remain unaccomplished until and unless you people will not share with the layman. Try to have one performa. I would like to request the in-charge law club, Dr. Sarika Tyagi, to develop one performa on the basis of BSA, BNSS and BNS. And on the basis of those three performa, they will conduct couple of survey and try to make awareness in the society, in rickshawala, in the street vendors, with the shopkeepers, with the street childrens, with the vendors at railway station and at bus stops, more specifically where we feel their petty offences, occurrence of the petty offences are much there. In those Jhuggi Jhompadi area where they are not illiterate. So try to develop those three different performa and circulate those performa with the help of the students, and they will collect the data and try to consolidate that data and develop pie chart with that what is the present time of knowledge they are having with regard to these three criminal laws. And after 3 months, try to conduct another survey and understand the difference with a different segment of the students. 26th November is not too far. That is our constitutional day. On the constitutional day and before constitutional day, we can conduct one survey, and at the time of 26 January, we can conduct another survey. And these two surveys can better justify our effort whether we will be in a position to get the better outcome or not. Once again, I would like to say, our issues are known, our challenges are unknown until and unless 140 करोड़ की बात नहीं करूंगा क्योंकि 140 करोड़ तो हमारी सेंसस है, उसके अलावा कुछ फॉरेनर्स भी हैं. So until and unless everyone who is residing within this geographical boundary, they are aware about these criminal laws, we will not be in a position to state that how far we have competed with the challenges. Challenges are many, but being a law student and being head of this institution, if the entire force is with me, if entire force is with all the faculty members who are working in this college, then I am confident enough that we will be in a position to compete all the challenges what we are facing before the implementation of new criminal laws. With these words, I would like to pay thanks to the organizers. Though I am one of them, but I am behind the curtain, so I would like to pay thanks to all entire organizing team and to the guests in absentia who were present in the morning, and once again to the founder of the university, and undoubtedly to this gathering. वैलिडिटी तक रुकने का मतलब होता है कि आप वास्तव में कुछ कैरी होम मैसेज लेके जाना चाहते हो, घर पे कोई मैसेज लेके जाना चाहते हो, और अगर आप थोड़ा पढ़ाई में सिंसियर रहेंगे तो आपको सक्सेस कंपैरेटिवली बेटर मिलेगा, ये मेरा अपना भरोसा है. विद दीज वर्ड्स, थैंक यू वेरी मच. आई हैव टेकन मच टाइम, more than what I am expected. So once again, thank you one and all. Jai Hind, Jai Bharat.
I request Dr. A.P. Garg sir, Director Research Applied Sciences at Swami Vivekanand Subharti University, to kindly enlighten us.
Very good evening to all. By this time you are all tired, including me.
My apologies, मैंने ज़्यादा समय लिया.
No, this is not because of that, but the time, the 1-day seminar, it could have been 2-day seminar, or maybe that's a 3-day seminar, so that the things could have been. But the 3 repertoires have made my task easy, because most of the points they have been taken up by them. So what I wrote in the morning, I'm not going to touch them. I will share only my experience. What one of the reporters said, that I don't agree with these 3 laws. It is not correct. The correct position is this, that why we make the law? We make the law to develop a civilized society. Agree? Okay. Will these 3 laws be able to make a civilized society? I ask the question to you. Or are these laws capable of making a civilized society? From my viewpoint, the answer is no. अब मैं आपको कुछ अपने एक्सपीरियंस बताता हूँ. 1986 की बात है, जब मैं जर्मनी में था. गौथे इंस्टीट्यूट में जर्मन लैंग्वेज हम लोग पढ़ते थे, और उस समय तक 10 साल मेरे ऑलरेडी पढ़ाते पढ़ाते हो गए थे, तो पढ़ने की आदत कम हो जाती है टीचर्स को, बोलने की आदत ज़्यादा रहती है. लेकिन फिर भी एनीवे हम क्लास में बैठते थे. सुबह 8 बजे क्लास शुरू होती थी, 8 से 1 बजे तक, बीच में गैप 2 क्लास के बाद होता था. सैटरडे संडे छुट्टी रहती थी, और फ्राइडे हाफ डे रहता था, यानी 1 बजे के बाद ख़त्म हो जाता था, क्योंकि 1 बजे तक क्लास होती थी. और वहाँ सिस्टम ये था 1 से 2 लंच, और 2 से 5 बजे तक जो था एक स्टाम्प टिश कहते थे उसको. स्टाम्प टिश में क्या होता था कि जितने भी स्टूडेंट जो पढ़ रहे हैं वो मान लीजिए 10 कंट्रीज़ के हैं, तो 10 कंट्रीज़ के अलग अलग बैठेंगे. एक किसी कंट्री के 2 स्टूडेंट एक साथ नहीं बैठेंगे. एक राउंड टेबल होगी, वहाँ टीचर बैठा रहेगा. टीचर का कोई रोल नहीं है, टीचर कुछ नहीं बोलेगा, और वो 10 के 10 लोग वो होंगे जो आपस में एक दूसरे को लैंग्वेज को नहीं जानेंगे. ऐसा वो मेटिकुलस. और ये कहते थे कि भाई अब आप जर्मन में ही बोलो जो भी बोलना है, टूटी फूटी जैसी भी बोलो, आप यू स्पीक एनीथिंग, जो आपकी मर्जी हो. और वो 2 से 5 वाला जो टाइम था वो मुझे सबसे अच्छा लगता था, क्योंकि उसमें क्या था कि वो प्रैक्टिस आपकी होती थी, और दैट वाज ए वंडरफुल प्रोग्राम. तो हमारा एक कलीग था अरविंद, वो वाइस चांसलर भी रहे हैं, अभी रिटायर हुए वाइस चांसलर से. तो वो और हम साथ साथ थे. तो उसकी अच्छा लैंग्वेज कोर्स के टाइम में हम फैमिली नहीं ले जा सकते थे. वहाँ एक प्रोटोकॉल थे सेट कि फैमिली लेके आप जाओगे तो आप फैमिली से हिंदी में अपनी मदर टंग में बात करोगे तो आप लैंग्वेज कैसे सीखोगे। इट वाज ऑल्सो प्रोहिबिटेड कि जो हमको इंटरनेशनल हॉस्टल में जगह दी गई थी वहाँ पर जो रूम्स थे तो नेबर जो होगा वो आपका वो दूसरे कंट्री वाला होगा। सो मनी सिस्टम्स उन्होंने डेवलप कर रखे थे। अब मैं आपको ये स्टोरी इसलिए शेयर कर रहा हूँ कि फ्राइडे को उसकी वाइफ ने बच्चे को जन्म दिया, वहाँ से टेलीग्राम, उस समय मोबाइल फ़ोन नहीं हुआ करते थे जैसे आजकल आपके पास हैं, लैंडलाइन ही एक सिस्टम था जब हम अपनी फैमिली से बात कर सकते थे। तो आप ये देखिए कि जब वो टेलीग्राम उन्होंने दिया तो टेलीग्राम पहुंचा, फ्राइडे में पहुंच गया। टेलीग्राम वाज द फास्टेस्ट मोड ड्यूरिंग दोज डेज ऑल्सो। लेकिन फ्राइडे में हमारा 1 बजे इंस्टीट्यूट बंद हो गया, हम लोग घर चले गए और वो टेलीग्राम डिलीवर नहीं हुआ। टेलीग्राम वो डिलीवर हुआ हमको मंडे को। तो क्लास में जब 8 बजे क्लास शुरू हुई तो हमने क्लास में कहा वहाँ आपको जर्मन लैंग्वेज में ही जो भी प्रॉब्लम्स आप फेस कर रहे हैं या वट एवर आर योर फीलिंग्स दैट यू हैव टू एक्सप्रेस इन द क्लास एंड द टीचर विल डिस्कस इन जर्मन लैंग्वेज। तो टीचर ने वो जर्मन लैंग्वेज में हमसे डिस्कस किया, बताया, और उसने हमसे कहा कि भाई जब तक हमें 2 महीने हो चुके थे तो हम थोड़ी बहुत गिटर पिटर कर लेते थे, टूटी फूटी जर्मन बोल लेते थे। बात ये अपनी बात 1 बार नहीं, 2 बार नहीं, 3 बार कैसी न कैसी, जैसे बच्चे होते हैं ना, छोटे बच्चे होते हैं, आप देखोगे कि वो अपनी बात कभी इशारे से कभी इससे वो पूरी मेहनत करते हैं अपनी बात आप तक समझाने की। द सेम वाज द कंडीशन। तो टीचर ने मुझे साथ में डिप्यूट किया अरविंद के, बोले कि आप दोनों पोस्ट ऑफिस जाओ और पोस्ट ऑफिस जा कर के उनको कंप्लेंट लॉन्च करो। और टीचर ने पीछे हमारे भेज दिया, साथ में एक टीचर भेज दिया था कि वो हमको ऑब्जर्व करेगा कि हम कैसे कम्युनिकेट करते हैं। हम जा कर के खड़े हो गए, वहाँ लाइन थी, लाइन में जाकर खड़े हुए तो 2-3 के बाद ही हमारा नंबर आ गया था और हम अपनी बात अपनी टूटी फूटी लैंग्वेज में जैसा था हम उसको कम्युनिकेट कर रहे थे कि भाई हम आपने 2 दिन बाद हमको दिया, इससे बड़ा हमें मेंटल टॉर्चर हुई, सारी चीज़ें सर। एंड वी टुक 10 मिनट्स। हमारे पीछे जो और लोग खड़े हुए थे किसी ने हमको ऑब्जेक्ट नहीं कहा, किसी ने ऑब्जेक्ट नहीं किया। और यहाँ अगर आप किसी लाइन में चले जाएं और अगर आप 2 मिनट से ज़्यादा लगाएंगे तो लोग हल्ला मचाना शुरू कर देंगे आपके पीछे, और पर्टिकुलरली जब आप अपनी बात ठीक से कम्युनिकेट नहीं कर पा रहे हैं पूरी तरह से। तो जब हमको 10 मिनट भी हो गए तो इसके बाद किसी ने हल्ला नहीं मचाया। 2 लेडी जो थी, जो हमारे पीछे थी, वो हमारे से बोली, उन्होंने अपना टर्न छोड़ दिया, हमसे बोली कॉमन जी मिटे विद अस, मिटस, मतलब हमारे साथ चलो। तो हम ऊपर वाले मैनेजर के पास गए। मैनेजर को जाकर के पहले उस लेडी ने हमारी बात उनको समझाई, क्योंकि वो समझ गई थी इतनी देर में जब तक हम 10 मिनट में अपनी बात कह रहे थे। अब देखिए मैं आपको बताता हूँ, अब ये सिस्टम की सिविलाइज सोसाइटी की बात कर रहा हूँ। उस मैनेजर ने हमको बताया कि भाई आपके पास 2 ऑप्शन है। एक ऑप्शन ये है कि आप हमें कंप्लेंट कर दीजिए राइटिंग में, उसने कागज हमें निकाल के दिया, पेन निकाल के दिया, आप कंप्लेंट कर दीजिए एंड वी विल फॉरवर्ड दिस कंप्लेंट। तो जिसकी रेस्पॉन्सिबिलिटी थी, इसके ऊपर फाइनेंशियल पेनल्टी भी हो सकती है या कोई मिसकंडक्ट पेनल्टी भी हो सकती है, लेकिन पेनल्टी जरूर होगी, बिकॉज व्हाट यू आर सेइंग इट इज़ करेक्ट। इसकी जिम्मेदारी थी कि फ्राइडे में जब ये आ गया था तो इंस्टीट्यूट से आपका घर का एड्रेस लेकर के इसको वहाँ डिलीवर करना था। इट वॉज हिज रेस्पॉन्सिबिलिटी, ही एडमिटेड। न उसने कहा कि मैं आपको एक ऑफर देता हूँ, भाई अगर आपको फ्राइडे को मिल जाता तो आप क्या करते। हमारा अरविंद ने कहा कि भाई मैं अपनी वाइफ से बात करता, फ़ोन पे बात करता, उसको सांत्वना देता, उसको सारी चीज़ें करते थे, हम जो अपना सिस्टम है उससे ये। तो उसने कहा नाउ देयर इज़ वन ऑफर फ्रॉम माई साइड दैट यू टॉक टू योर फैमिली मेम्बर्स फ्री ऑफ कॉस्ट फॉर हाफ एन आवर। हाफ एन आवर का मतलब है कि 1 मिनट की कॉस्ट थी उस समय वहाँ पर 5 मार्क, 5 डच मार्क एट दैट टाइम, जब यूरो नहीं चलता था। मैं आज से 40 साल पहले की बात कर रहा हूँ, करीब 38 साल पहले की बात। और 5 मार्क 1 मिनट, 5 मार्क इंटू 30 मिनट्स उसने हमको टाइम दिया कि आप आधा घंटे तक बात कर लिए। आधा घंटे तक कोई आदमी क्या बात करेगा, ही गेव द लिबर्टी, आप आधा घंटे बात करें, यू कैन टॉक फॉर हाफ एन आवर फ्री ऑफ कॉस्ट. दिस इज द वन. और द सेकेंड थिंग इज दैट यू राइट द कंप्लेंट and I will forward. No, that is the civilized society. No law in India permit such type of the liberty to the people or to the authorities, both. Civilized, हम लोगों की क्या रिक्वायरमेंट होती है भाई? जो civilized 95% लोग तो वैसे ही गॉड फियरिंग है हिंदुस्तान के अंदर. आप जरा एक बात सोच लीजिए कि अगर गॉड ना होता तो क्या होता? अगर ऐसा होता, हम लोग सब ये सोचते कि भगवान एग्जिस्ट ही नहीं करता, और हम ये नहीं सोचते कि भगवान हमको देख रहा है कहीं से और वो पनिशमेंट देगा और ये सारी चीज़ें देगा या हमको कोई नुकसान होगा. अगर ज़रा सा सोच के आप देखिए, इफ़ इट वुड हैव बीन देन व्हाट वुड हैव बीन द सोसाइटी? कैसी सोसाइटी होती? जंगल वाली होती, हर आदमी एक दूसरे को काट रहा होता. तो 95% लोग तो वैसे ही गॉड फियरिंग है, वैसे ही लॉ को अप्लाई करते हैं. 5% लोगों के लिए लॉ आपको बनाना है, उनके लिए इम्प्लीमेंट करना है. सिविलाइज सोसाइटी में 95% लोग तो वैसे ही सिविलाइज्ड हैं, दे नो इट. सो सिविलाइज्ड सोसाइटी बनाने के लिए लॉ स्टिल इट इज, वी आर, मतलब एज इंडियन सिस्टम, इंडियन जस्टिस डिलीवरी सिस्टम, मैं समझता हूँ स्टिल इट इज, वी आर फार बिहाइंड. टेक्नोलॉजी में तो हम बहुत पीछे हैं ही हैं. जैसे आजकल आप मोबाइल देख रहे हैं और ये सारी चीज़ें देख रहे हैं. 92 के अंदर मोबाइल टाइप सिस्टम जो है यूरोप में आ गया था 92 में. और 92 में जब मोबाइल सिस्टम था, हालांकि वो 500 ग्राम का होता था, दैट वाज हैवी फ़ोन, और उसको चलाते थे. हम टेक्नोलॉजी में इतने पीछे हैं. अभी भी आप देखते हैं कि आपका इंटरनेट की बात है, 5G 4G 6G की बात लोग कर रहे हैं, लेकिन अभी भी आप समझते हैं कि 5G बहुत बड़ी चीज़ है, बट लेकिन यू विल फाइंड कि अभी वेस्टर्न कंट्रीज़ के अंदर 20G पे पहुंच गए. तो अभी हम सिविलाइज सोसाइटी में, टेक्नोलॉजी में, साइंस में, लॉ में, सिविलाइजेशन में अभी बहुत पीछे. अभी जब मैं बात कर रहा था, सुबह मैं शेयर करना चाहता था आप लोगों से कि लॉ की जब हमने 3 ये तरह के लॉ बना दीजिए, और टेक्नोलॉजी जैसी जैसे एडवांस होगी, साइंस एडवांस होगी, लॉ भी आपको चेंज करना पड़ेगा. ठीक है. अब आप मुझे बताइए, एआई के अंदर एक गाड़ी एलन मस्क ने बनाई और उसने कहा ये ड्राइवरलेस कार है, इसने आकर के किसी को ठोक दिया. टेक्नोलॉजी है, देयर मे बी समथिंग रॉन्ग. तो आपके कौन से लॉ में किसको पनिशमेंट देंगे आप? गाड़ी को देंगे? ओनर को क्यों देंगे भाई? नहीं, ओनर की तो कोई केयरलेस है नहीं है. कंपनी भी कह देगी. कंपनी कैसे कह देगी? कंपनी कहेगी कि भाई कहीं फॉल्ट हो गया, कुछ हो गया, टेक्नोलॉजिकल फॉल्ट हो गया. R&D रिसर्च टीम को कैसे दोगे? हमने तो ठीक बनाई थी सारी चीज़. सो स्टिल देयर आर सेट. नहीं, चलिए मैं इसके एग्जाम्पल को थोड़ा और मॉडिफाई करता हूँ.
एक आर्टिकल है,
गाड़ी चल रही है. यस, अभी मैं बता रहा हूँ. अभी वीकेंड, क्योंकि मैं डॉक्टर वैभव से कितनी बार ये कहता हूँ कि जब हम लॉ की जो क्लास है, लॉ में डिस्कशन पार्ट जो है बहुत रखिए आप. एवरी डे कम से कम 2 घंटे डिस्कशन रखिए आप. सुबह 9 बजे से 1 बजे तक पढ़ाइए, और 1 से 2 लंच के बाद, 2 लंच के बाद जो है रोज़ाना डिस्कशन रखिए किसी भी टॉपिक पर. अब जैसे मैं अपने एग्जाम्पल को थोड़ा मॉडिफाई करता हूँ. मॉडिफिकेशन इन द सेंस कि कार है, कार के अंदर सेंसर लगे हुए हैं. ठीक. अब वो कार तो सेंसर करके जा रही है, लाइट चली गई रोड पे, सेंसर तो सेंस नहीं, और उसने सामने से टक्कर लग गई. अब बताइए कौन है रेस्पॉन्सिबल? नहीं है, लेकिन सेंसर ने नहीं, जैसे लाइट तो बाहर गई ना, रोड पे अंधेरा है ना, रोड पे थोड़ी वो करेगा. नहीं उतना नहीं है. डार्क में कितना, देयर इज ए लिमिट. सेंसर की भी एक लिमिट है कि वो कितने डार्क तक सेंस करेगा. कैसे करोगे? स्टेट को क्यों पनिश करोगे? आप आई एम पुटिंग सर्टेन क्वेश्चंस टू यू पीपल। और मैं आता हूँ क्वेश्चन पे। हमारे यहाँ जो सिस्टम है, FIR दर्ज करते हैं आप, FIR दर्ज करते हैं। FIR में क्या है कि आप कहते हैं कि सब ये क्राइम अगेंस्ट द लॉ है, अगेंस्ट द स्टेट है, स्टेट उसमें पार्टी होती है। क्राइम A ने किया, B के अगेंस्ट किया, अरे भाई स्टेट से क्या मतलब है? सफरर मैं हूँ, क्राइम करने वाला वो है, क्यों स्टेट डिफेंड कर रही है? मुझे करने दो ना। सो स्टिल हमारा जो लॉ है, जो सिस्टम है, लीगल सिस्टम है, अभी भी हम सिविलाइज्ड सोसाइटी की तरफ नहीं है। मतलब माय व्यू पॉइंट इज सिविलाइज्ड सोसाइटी इन ए सेंस ऑफ द परफेक्शन, जहाँ सिविलाइज्ड सोसाइटी इन ए सस्टेनेबल मैनर। सस्टेनेबिलिटी का मतलब आप समझते हैं कि आप जैसे ह्यूमन है, ह्यूमन का जीनोम जो है इट इज़ मेड फॉर 150 ईयर्स, और आप 150 साल जिंदे नहीं रह रहे, ठीक है? एनवायरमेंट पॉल्यूशन हो गया, आप पॉल्यूशन की वजह से बीमारी हो गई। बहुत सारे लोगों को, कितने लोग 150 साल जी रहे हैं? सब लोग। एवरेज लाइफ आज की डेट में हिंदुस्तान में 72 ईयर्स है, तो 50% है। 50% तो मर रहे हैं स्टेट की वजह से। शुड वी प्रोसिक्यूट द स्टेट? मेरी लाइफ आधी करने के लिए कौन रेस्पॉन्सिबल है? माई क्वेश्चंस आर वेरी स्ट्रेट फॉरवर्ड, थॉट प्रोवोकिंग। देखो आप देखिए, मेडिकल डॉक्टर, मेरे जो आइडिया है, जो मैं कहता हूँ कि जो स्टूडेंट, जो बच्चा है, छोटा बच्चा जैसे जब स्कूल पढ़ने जाता है तभी से उसको 3 चीज़ सिखानी चाहिए। एक उसको बेसिक्स ऑफ द मेडिकल, हेल्थ एंड हाइजीन। दूसरा उसको लॉ, लीगल सिस्टम। और तीसरा उसको एनवायरनमेंट। 3 चीज़ अगर आप प्योर कर लें, 3 ट्रायंगल, देन यू कैन ऑब्टेन ए सस्टेनेबल लाइफ, लॉन्ग लाइफ, गुड लाइफ। और लीगल प्रोफेशन जो है, इट इज़ ए वेरी नोबल प्रोफेशन। मैं इसको मेडिकल प्रोफेशन से भी ज़्यादा नोबल समझता हूँ। लेकिन जैसे आज मॉर्निंग में कह रहे थे ना, जिन्होंने कहा था ना कि एडवोकेट से जज साहब ने पूछा कि आप सच बताइए, कोई एडवोकेट सच नहीं बताता। सारे एडवोकेट जो हैं कहते हैं एविडेंस, और एविडेंस पे आप आ जाइए, एविडेंस कैन बी मैनिपुलेटेड। अभी डिजिटल एविडेंस की भी जब बात हो रही है तो टेक्नोलॉजी इतनी एडवांस हो गई है कि दिस डिजिटल एविडेंस कैन ऑल्सो बी मैनिपुलेटेड। तो जितना हम लोगों को साइंस डेवलप हो रही है, सोसाइटी डेवलप हो रही है, टेक्नोलॉजी डेवलप हो रही है, उसके हिसाब से हमें लॉ और लीगल सिस्टम को कंटिन्यूसली चेंज करना पड़ेगा। मेरा कहने का मतलब ये नहीं है कि ये 3 लॉ जो है बेकार हैं, इम्प्लीमेंट नहीं होने चाहिए। इट इज़ बेटर देन द प्रीवियस, बट स्टिल देयर इज ए नीड ऑफ द बेटर लॉ। स्टिल देयर इज ए नीड ऑफ द गुड लॉ फॉर ए सिविलाइज्ड सोसाइटी, for such a society who can live together. International law, civilized law, civil laws. अभी आप बहुत सारी चीज़ें देखें, इंटरनेशनल लॉ पे मैं नहीं जाना चाहूँगा क्योंकि दैट इज़ नॉट ए टॉपिक ऑफ दिस सेमिनार। लेकिन जो हमारे 3 लॉज हैं, दे आर गुड बट स्टिल नॉट परफेक्ट। Still they need many of the things to be changed. अब इम्प्लीमेंटेशन की बात आते हैं। इम्प्लीमेंटेशन पे जो भी वक्ता हैं, आज इस वाले पार्ट को कम लोगों ने टच किया है। सब ने टच किया, सब लॉ चेंज हो गया, लॉ ये हो गया, ये हो गया, सब टच किया, लेकिन इम्प्लीमेंटेशन। अब आप देखिए, आप तो सब लोग लॉ के स्टूडेंट्स हैं। जज साहब जजमेंट लिखते हैं, किसके बेस पे लिखते हैं? फैक्ट्स पे लिखते हैं, फिर उसके बाद अपने कुछ कोट करते हैं, ठीक है, जो प्रीवियस लॉ हैं। तो आप जज साहब से पूछिए प्रीवियस जो केस लॉ है वो तो इसमें मिलेंगे नहीं। तो जज साहब की कंडीशन देखो ना, वो बेचारे कहाँ से जो है अपनी बात को सपोर्ट करेंगे। लॉ का जो जजमेंट है, जजमेंट का साइज छोटा हो जाएगा। चैलेंज उनके लिए है इम्प्लीमेंटेशन, या नहीं? अब पुलिस वाला की बात सबने कर ली, सारी चीज़ें हैं। तो अभी भी क्या है कि इतने सारे, दूसरा हमारे जस्टिस सिस्टम के अंदर सबसे बड़ी जो चैलेंज है, वो चैलेंज है पेंडिंग 51 मिलियन ऑफ द केसेस। जो ऑलरेडी केसेस पेंडिंग है वो कौन से लॉ से डील होंगे? करंट से या पुराने से? पुराने से। तो जो हमारी सरकार और जो कहते हैं कि साहब हमने लॉ बना दिए और अब पेंडिंग केस खत्म हो जाएंगे, कहते तो दे आर मेकिंग ए फूल। वेरी क्लियर, पेंडिंग केस जितने हैं उतने ही रहेंगे, उसका इसके ऊपर कोई प्रभाव पड़ने वाला नहीं। और हमने कह दिया कि साहब के 3 महीने में जजमेंट मिल जाएगा, इतने दिन में ही मिल जाएगा। अगर हम किसी डॉक्टर से कहें कि भाई आज तुम्हें हार्ट की बीमारी हो रही है और 3 महीने में तुम्हें इलाज दे देंगे, तो क्या ये सस्टेनेबल है? नहीं। तो लॉ का इम्प्लीमेंटेशन, लॉ का क्योर, लॉ शुड बी ये सोशल क्यूरेटिव एंड प्रोटेक्टिव तो है ही नहीं, और क्यूरेटिव जो है इट इज ए लॉन्ग टाइम कंज्यूमिंग प्रोसेस। तो सिविलाइज सोसाइटी के लिए, जब हम सिविलाइज सोसाइटी की बात करते हैं, एंड व्हेन वी ड्रीम ऑफ द सस्टेनेबिलिटी, लॉन्ग लाइफ, then we have to still think, and there is a great challenge before the lawyers. Law is such a profession, इतना पेइंग प्रोफेशन भी है, कमर्शलाइज भी है, सारी चीज़ें हैं। आप देखोगे, मैंने तो किसी डॉक्टर को देखा नहीं, सुना नहीं कि उसकी 25 लाख रुपए फीस हो 1 घंटे के सर्जरी की। आपने किसी ने सुना है? नहीं सुना। मैंने सुना है कि बहुत सारे लॉयर्स ऐसे हैं सुप्रीम कोर्ट में जिनकी 1 घंटे की फीस जो है 25 लाख रुपए, 30 लाख रुपए है। सो दीज थिंग्स, हाइपर टेक्निकल लॉ अभी भी क्या है कि इसको हाइपर टेक्निकल बना रखा है। जो कायदे में क्या है कि लॉ शुड बी डिलीवर्ड, द जस्टिस शुड बी डिलीवर्ड बेस्ड ऑन द फैक्ट्स। लेकिन अभी भी अगर आप कोर्ट्स में जाएंगे तो जस्टिस डिलीवरी जो है, इट मेनली डिपेंड्स एट हाउ योर लॉयर प्लीड द केस, द फेस वैल्यू ऑफ द लॉयर, द मनी व्हाट यू पेड टू द लॉयर। तो अभी भी क्या है कि जस्टिस डिलीवरी सिस्टम, अब आपने जैसे सुबह बात हो रही थी, उन्होंने कहा 20,000 रुपये से कम वाला जो केस है उसके लिए, भाई 20,000 रुपये से कम वाला केस कोर्ट में तो वो भी जाएगा ना, ठीक है, समरी ट्रायल भी जाएगा, लेकिन 20,000 तो लॉयर ले लेगा फीस। तो बेचारे को उसको क्या मिला? वो कहेगा छोड़ो यार, 20,000 रुपये का केस है, मैं जाता ही नहीं समरी। 20,000 तो लॉयर ले लेगा, फिर 3 दिन 4 दिन मेरे और लगेंगे कोर्ट में जाने में, खड़े होने में। तो अभी भी क्या है कि अभी भी जो चीज़ है, स्टिल देयर आर सेवरल लेकुनी। जो लॉ बनाया गया है वो खाली अभी भी जो है खाली ये दिखाने के लिए कि भाई हमने कुछ चेंज कर दिया और ये ला दिया, बट इट इज़ नॉट गोइंग टू मेक एनी सब्सटेंशियल चेंज इन द लाइफ ऑफ ए कॉमन मैन हु इज़ लिविंग इन द विलेज। जो गांव में रह रहा है आदमी, उसको जिसको जस्टिस चाहिए, उसके लिए अभी कुछ इसमें चेंज नहीं है। आप सुभारती यूनिवर्सिटी के स्टूडेंट्स की क्या जिम्मेदारी है? सुभारती यूनिवर्सिटी के स्टूडेंट्स की, जैसे प्रोफेसर वैभव गोयल ने कहा कि हमको एक सर्वे करना चाहिए, मैं कहता हूँ कि सर्वे बाद में करना चाहिए, सर्वे से पहले हमें एजुकेट करना चाहिए। हमारी यूनिवर्सिटी ने 5 गांव गोद ले रखे हैं, और मैं चाहूँगा कि सुभारती यूनिवर्सिटी के लॉ के स्टूडेंट्स कम से कम एक दिन महीने में, एक दिन एक गांव में जाएं और जाकर के वो गांव में शाम को बैठें, चौपाल पर बैठें, उन्हीं की भाषा में बात करें, उनको ये लॉ जो हैं 3 लॉ हैं, इनको सिंपल भाषा में उनको समझाएं, बताएं, उनसे बात। जब तक आप प्रैक्टिकली उस आदमी के पास तक नहीं जाएंगे तब तक आपको प्रैक्टिस बहुत सारी चीज़ें नहीं आएंगी। आपके लिए तो बहुत बड़ी लेबोरेटरी है, पूरी सोसाइटी आपकी लैब है, पूरी सोसाइटी आपकी लैब है। एनीवेयर यू कैन गो एंड डू द प्रैक्टिस। आपके पास तो रेस्पोंडेंट्स बहुत है, आपके पास तो क्लाइंट्स बहुत है। यू हैव ए वास्ट नंबर ऑफ द 140 करोड़ पीपल जिनके पास आप जा सकते हैं, जिनको समझा सकते हैं, बता सकते हैं। तो मेरा कहने का मतलब यही है, हालांकि मैं भी ज़्यादा टाइम ले लिया है, अब मैं ज़्यादा अपनी बात नहीं कहूँगा। ये उम्मीद करता हूँ कि सुभारती यूनिवर्सिटी के लॉ के स्टूडेंट्स will do the something new to build a civilized society। पता चलना चाहिए लोगों को, सिविलाइज सोसाइटी को, लोगों को पता चले कि हाँ, ये सुभारती यूनिवर्सिटी के विद्यार्थी जो हैं सिविलाइज सोसाइटी को सिविलाइज्ड बनाने में दे आर मेकिंग सम कंट्रीब्यूशन, दे आर मेकिंग सम कंट्रीब्यूशन टू एजुकेट द लोअर क्लास पीपल। हमें और आपको तो आती हैं बहुत सारी चीज़ें, हम और आप तो अपनी बात कह भी लेते हैं और हमारी बात कई बार प्रशासन सुन भी लेता है बहुत अच्छी तरह से, लेकिन क्या एक गांव का आदमी जो बिल्कुल गांव में बैठा हुआ है, जो बोल नहीं सकता, अपनी बात नहीं कह सकता, दबा कुचला है, जो बड़ा डिप्रेस्ड है, सप्रेस्ड है, क्या वो उसको न्याय मिल पा रहा है? क्या वो अपनी बात कह पा रहा है? तो आप उनकी आवाज़ बने, उनके लिए कुछ करें। आपको अंदर से अपने आप में इतना ऐसा महसूस होगा कि येस, यू आर डूइंग समथिंग फॉर द सर्विस, समथिंग गुड फॉर द सोसाइटी। सो विद दीज वर्ड्स आई हैव ए प्लेजर एंड ऑनर टू कमेंट दैट you people do the wonderful thing to organize this seminar on this most important topic. Most important topic in the sense that issue, challenges and implementation. Issue, challenges and implementation is the biggest thing. लॉ तो हमारे यहाँ बनाते रहते हैं, लेकिन हर चीज़ का एग्जीक्यूशन, इम्प्लीमेंटेशन इज ए डिफरेंट। तो इम्प्लीमेंटेशन पर आप बात करें, इम्प्लीमेंटेशन पर आप करें, बहुत अच्छा रहेगा। डू सम रिसर्च, डू सम पब्लिकेशंस एंड do some. So once again I am thankful to the organizers that they invited me to share my views with the legal experts, and I would like to encourage the all 3 repertoires, and I would like to request the organizers to give them some special type of the certificate instead of the common certificate, so that the other people, they can also be motivated and they can also come forward. So thank you very much and best of luck, and I hope that next time when we meet, then I will listen from some of you that you went to some place, you educated some village people, some poor people, some unaware people, some uneducated people about these laws. So best of luck and thank you very much. Thank you Professor Goyal, thank you Anurada ji, and thank you faculty members, and thank you to all the participants. Thank you very much.
सर की परमिशन से 2 पॉइंट ऐड करना चाह रहा हूँ। पहली चीज़ तो सर, जैसे कि जो सर्वे होगा उसमें जरूरी है, नेट ये कहता है पहले क्या आउटपुट था और आपने जो किया उसके बाद क्या डिफरेंस आना चाहिए।
तो पहले ही सिखाया, फिर जाके
नहीं, पहले 0 लेवल पे बिना सिखाया क्या था और सिखाने के बाद कितना चेंज आएगा। तो ये एक रिसर्च का भी पॉइंट हो जाता है, तो ये वाली चीज़ गई। दूसरा, हमारे यहाँ पर हम सर्वे और लीगल लिटरेसी स्टूडेंट से कराते रहते हैं। और तीसरा जो आपने सर्टिफिकेट वाली बात कही थी वो पहले से ही मैडम सर्टिफिकेट बना रही है, उन्होंने पहले से रिक्रूटमेंट के सर्टिफिकेट अलग से तैयार कर दी है। और एक सबसे बड़ी चीज, आपने जो लॉ वाली बात कही आपने खुद ही जवाब दे दिया, तो मैं सर के लिए एक बात जोड़ना चाह रही हूँ कि लॉ को अगर जितना व्यक्ति सोशल साइंस या बायोलॉजिकल साइंस या मेटीरियल साइंसेस को पढ़ता है प्री नर्सरी से किसी ना किसी वे में, जिस दिन वो लॉ को उतना पढ़ने लगा तो वहां पर सारी समस्याओं का समाधान मिल पाएगा। हम पैदा होने से लेकर लॉ हमारे ऊपर एप्लीकेबल होता है और 50% लॉ ग्रेजुएट भी ऐसे होंगे जिन्हें लॉ के बारे में मालूम तो है लेकिन उसका इंटरप्रिटेशन वो मिस इंटरप्रेट करके करते हैं। तो ये बिल्कुल सर ने जो सजेशन दिया कि लॉ डे 1 से आ जाना चाहिए, तो हमारी जो समस्या चलती है और जो अपनी जर्मनी का एग्जांपल दिया, हमारे यहाँ पर वो सारी चीजें लॉ के अंदर हैं लेकिन उसका लोग किस तरीके से यूज कर रहे हैं ये नहीं, हमारी ओन ह्यूमन वैल्यूज है, डिस्क्रिशन के अंदर है इन वेलफेयर ऑफ द पब्लिक, चाहे वो क्वासी जुडिशियल बॉडी है या जुडिशियल बॉडी है, उनका डिस्क्रिशन पैरामाउंट है और उसके ऊपर कोई बैरियर नहीं है। लेकिन वो डिस्क्रिशन को विंग्स एंड फेंसेस से फेस को देखकर यूज करें तो वो तो हमारा ह्यूमन लीगल नीड है, वो इंडियन टेंडेंसी हम कह देंगे। अदरवाइज आवर इंडियन लीगल सिस्टम इज द बेस्ट, ईस्ट और द बेस्ट, इंडिया इज द बेस्ट। थैंक यू वेरी मच।
Honorable Professor Dr. A.P. Garg, sir, Professor Dr. Vaibhav Goel, sir, faculty members present here, and all my dear students. I feel privileged that I have been given this task of Thanksgiving. So today, on the occasion of National Legal Service Day, that is 9th November, we got an opportunity of a wonderful national seminar on issues and implementation of the new criminal laws that are enforced from July 2024. I must thank in absentia Professor Bageshwar Deshwal, Professor Assad Malik and Advocate Saju Jacob for enlightening us with the minute details of these laws and what are the differences between the past law, that is the IPC, and this law. Secondly, I am thankful to our founder chairman, Sir Dr. Atul Krishna, whose vision of providing holistic education is world known. I am thankful to our Vice Chancellor, Major General Thapliyal, for providing facilities for arranging this wonderful session. I am thankful to Professor A.P. Garg, sir. I am thankful to Professor A.P. Garg, sir, Director Research, who always promotes an atmosphere based on research. I am thankful to Professor Vaibhav, sir, who as a leader of our organization values the courage and ability of his team members and encourages them to initiate anything new. Next, I must thank the seminar committee headed by Dr. Premchand sir, the organizing secretary, and Dr. Reena Bishnoi, whose guiding spirit is behind the success of today's event. I am thankful to all the faculty members present here and all the students as well as the presenters who presented nice papers on this topic. I am thankful to the technical support team, the support staff, without whose help we could not make this program a success. I am thankful to the rapporteurs for a wonderful presentation of the report of today's event.